ಈಗ ಬೆಳಗ್ಗೆ ಹೋಗಿ ಬರ್ಬೋದಾಗಿತ್ತಲ್ಲ. ಆಗಲ್ಲ. ಸರ್ ಒಂದೇ ವಿಚಾರ ಎಷ್ಟು ಸಲ ಕೇಳ್ತೀರಾ? ಅದು ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ, ನಾವು ಬರೆಯೋದಷ್ಟೇ, ಒಂದೇ ಬರ್ಬೇಕು ಅಂತ ನಾವು ಹೇಳಕ್ಕಾಗತ್ತಾ? ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಕೆಲಸ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಮಾಡುತ್ತೆ. ಪೆಂಡಿಂಗ್ ಕೆಲಸ ನೀವು ನನ್ನ ಹತ್ರನೂ ಕೇಳ್ತೀರಾ, ಅವ್ರ ಹತ್ರನೂ ಕೇಳ್ತೀರಾ. ಸಾಹೇಬ್ರು ಏನ್ ಹೇಳಿರ್ತಾರೋ ಅಷ್ಟೇ ಬರೀತೀವಿ ನಾವು. ನಾಳೆನೇ ಬರ್ಬೇಕು ಅಂತ ಅವ್ರು ಹೇಳಲಿಲ್ಲ, ನಾಳೆ ಡೇಟ್ ಕೊಡಿನೇ ಕೊಟ್ಟಿದೀವಿ ಅಷ್ಟೇ. ಎಷ್ಟು ಕೇಳಿದ್ರು ಅಷ್ಟೇ. ಸುಮ್ಮನೆ ಅದೇನಕ್ಕೆ ಅಷ್ಟೊಂದು ತಲೆ ಕೆಡ್ಸ್ಕೊಂತಿರು? ನೆವರ್ ಸ್ಟೆಪ್ ಇನ್ ಟು ದ ಶೂ. ನೀವು ಫಾಲೋ ಮಾಡ್ಬೇಕು. ಅಲ್ಲಿ ಕೆಲಸ ಅವ್ರು ಮಾಡ್ಬೇಕು. ಎಲ್ಲಾರ ಕೆಲ್ಸನೂ ಕೋಟಾಲ್ ಮೇಲೆ ಮಾಡಿಸೋದು. ಒಂದೇ ಬರ್ಬೇಕು. ಏನ್ ಕಂಡೀಷನ್, ಏನ್ ಮಾತಾಡ್ತಾರೆ? ಸಾಯಂಕಾಲನೇ ಅಮ್ಮಂಗೆ ಹೇಳೋಣ ಅಂತಿದ್ದೆ. ಯಾಕೆ ಬಿಡು ಅನ್ಕೊಂಡು ನಾನು ಸುಮ್ಮನಾದೆ, ಅಲ್ಲಿ ತನಕ ಹೋಗಲ್ಲ ಅಂತ ನೋಡಿ ಇವತ್ತು ಅಲ್ಲಿ ತನಕ ಮಾಡಿರೋ ತಪ್ಪನ್ನು ಮುಚ್ಕೊಳ್ಳೋದಂತೆ. ಪಾಪ ಇವ್ರು ನಮ್ಮವರೆಲ್ಲ ನಂಬಾಗಿದ್ದಾರೆ. ನಾನೇ ಹೊಡೆದಾಡಷ್ಟು ಹೊಡೆದಾಡ. ಏನೋ ಒಳ್ಳೇದಾಗುತ್ತೆ ಅನ್ಸುತ್ತೆ, ಏನೋ ಒಳ್ಳೇದಾಗುತ್ತೆ ಅಷ್ಟೇ ಅನ್ಸುತ್ತೆ.
My lord, on matter pertaining to Kalburgi bench, my lord. Point for consideration regarding my promotion. Immediate, my lord, from 2020.
No, what is that Kalburgi?
Kalburgi bench, all judicial officers.
Judicial officers, yes.
Any.
What is that matter?
My lord, it's regarding to consideration of my promotion, my lord, from 2021. The matter is pending.
25th, yes.
25. Much obliged.
ಯಾವ್ದ್ರದ್ದು?
ನೆನ್ನೆ ಇದ್ದಿದ್ದು
ಏನಾಯ್ತದ? ಹಂಗೆ ಹೋಗಿದೆ. But you have not mentioned that, Mr. Saina ಹೋಗಿದ್ದು. ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆಯ್ತು, ನಾಳೆ ಹಾಕಲಿ. Only for extension and entry matter. Don't argue. Will not allow Somsekhar to argue. Yes.
However, it was rejected by the respondent or based on the JOC is not equal to PUC, my lord. So
Which year?
25.
Yes, 26.
Your Lordship, one matter. WP 20796 of 25 listed on 29th list ಆಗಿತ್ತು. ಅದರಲ್ಲಿ it's a short question, Your Lordship. Bescom has withholded the movement order. 42 ಅಂತ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ತಾವೇ ಹೇಳಿದ್ರಿ. ಬಟ್ ಅದು ಲಿಸ್ಟ್ ಆಗ್ಲಿಲ್ಲ ಇವತ್ತು ಮ್ಯಾಟ್ರು. ನಾಳೆಗೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಸ್ವಾಮಿ ಪ್ಲೀಸ್.
Verify. Yes. Date ಕೊಟ್ಟಿದ್ರೆ ಸರಿ, ಇಲ್ಲ ಅಂದ್ರೆ 10ನೇ ತಾರೀಕು ಕೊಡಿ. Yes.
Tomorrow.
We'll
Tomorrow.
verify that what has happened.
Please, Your Lordship.
One fresh matter.
Fresh matter ಕೊಡಿ tomorrow.
That's tomorrow. Fresh matter.
one matter will be 24.
Tomorrow.
Selection to report
Tomorrow.
Fresh matter.
ಅಲ್ಲ
Which year? Which year, Mr. Bhatt?
24 madam.
24. Yes.
But
24.
selection madam, otherwise I would not have moved.
Yes, 24th. Yes.
RSA.
Hmm.
RSA 2009.
ಕೊಡಿ ಸರ್, RSA
ಕೊಡಿ.
WP fresh ಎಲ್ಲ ಕೊಡ್ಬೋದು.
Fresh and fresh matters will give a
Also
date.
pending matter.
26th, yes.
One cup ಕೊಡ್ತಾರೆ, divide ಮಾಡ್ತಾರೆ.
Yes, 26th, yes.
Your Lordship, this is pertaining to the post of typist in the newly established court in Mysore. Now, Your Lordship, the peons have already received an appointment. The typist also can be considered in this matter. It's a 2025 matter.
What is that you are challenging?
They have not been considered. there's a fresh notification that has been issued, though
Yes.
we have been,
Yes,
up-
25th, yes.
25th.
Fresh matter kodi.
ಕೊಡಿ sir.
First time matters, it will come tomorrow. Huh? Arrears, yes.
Milords,
26th,
26th,
25th, yes.
25th.
Fresh matter kodi ಬರುತ್ತೆ.
Milords, a pending matter.
Salary ಕೊಟ್ಟಿಲ್ಲ. Yes, second.
Milords, pending matter, Milords. I'm a Group C driver, have been reduced, my pay has been reduced to a Group D. My superannuation is in 2 years, Milords.
Second, yes. Yes, second. Orders, yes.
Serial number 19, my lord.
Circular is very clear, only a written statement, written, what should be considered.
Yes.
My lords,
Third, yes.
my lords, pending matter, my lords, where I filed a vacating IA also, my lords, and for
Which
the
year?
respondents,
Which
2024, my lords.
2024, now you are filing vacating.
No, my lords, it's been filed, it has to be heard, my lords, it was filed last year itself, my lords.
Yes, 26th, yes.
Grateful, my lords.
Yes, third.
My lord, I am at serial number 19.
ಸರ್ ಒಂದ್ ನಿಮಿಷ ವಿ ಸಿ ಅಲ್ಲಿರೋರು ವೇಟ್ ಮಾಡಿ ಸರ್ ಒಂದ್ ನಿಮಿಷ.
Please.
Yes, third March. Third, yes.
ಅವ್ರದ್ದು third.
Last time, emergent notice, survive,
Fourth March.
Fourth March.
Yes,
4th March.
yes. Not tomorrow. Suspension is 23rd, yes.
Milords, challenging the endorsement wherein my fixation of pay has been rejected, Milords.
Yes.
It's a 2019 matter, Milords, very old matter.
Fourth, yes.
My lords, serial number 70.
Yes. 49. 49 you are appearing for?
I already informed them.
I am for the petitioner.
Yes.
Date may be fixed.
You are appearing for whom, madam?
2 weeks.
ನೀವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಾ?
I am for the respondent 6 and 7 in the requisition 2540/24.
Yes, at the request of council for respondent number 6 and 7. Leave this matter after 2 weeks. Leave this matter on 3rd.
Kindly stay there.
Interim order granted earlier is extended.
My lord, serial number 71, my lord.
Serial number 35.
Yes.
Last time I have it next week, Lord, I sent objections to the.
Have you informed other side,
Is
Mr.?
there?
Yes, at the request of council for.
Last chance is given.
Yes, respondent, leave this matter on 23rd. Yes.
Public.
34. Yes.
Request for some matter.
30.
Being subsequently pleaded in 2018 petition.
No, I have informed other side.
I'll inform other side, Lords, and then.
Yes, at the request of council for the respondent. Leave this matter after 2 weeks. You will
My lord.
inform-
Lord, serial number 71, my lords.
Serial
Serial number 71, and for the respondents, my lords. I was in receipt of instructions only yesterday. I'm seeking a week's time to file objections, my lords. I've informed the other side.
You have informed other side.
Please, my lords, I've informed the other side.
You are
Anytime,
appearing for which respondent?
all the 3 respondents, my lords.
Only 2 is there.
Please, my lords, I'll file wakalat for the rest. 3, my lords. Registrar General, High Court of Karnataka, Principal District and Sessions Judge Raichur, and Additional Senior Civil Judge Raichur, my lords.
ಎಲ್ಲಿದ್ದಾರೆ ಮೂರನೇದು?
71.
71 ಅಲ್ಲ, R1 and R2 ಅಷ್ಟೇ
71 my lords.
ತೋರಿಸಿದಾರಲ್ಲ.
My lord,
ಏನಾಗ್ತಾರೆ? Yes,
71.
Bernard Council
Ha, illa, I'm for Sudarshan Suresh, my lord. I filed wakalat.
1 and 2, 6, 2 weeks time. Yes.
Please, my lord.
Serial number 21, my lord.
Serial- 70, yes, madam.
I applied for respondent number 1 and I have informed the petitioner council 2 weeks.
Yes, at the request of respondent number 1 and 2, leave this matter after 2 weeks.
69. Withdrawal transfer matter in view of subsequent development.
Yes.
Fresh appointment has been given.
Learned Council for the petitioner filed a memo seeking leave of this court to withdraw this
My
memo
lord.
is taken on record.
Serial number
Dismissed as
21, my lord.
Serial number?
21, my lord. I pray for time for complaints, my lord. There is a short,
21.
Yes, my
Yes, at the request of petitioner, week's time is granted to comply of subject.
My lord, serial number 18, my lord, non-compliance alert. 2 weeks.
At the request of petitioner, 2 weeks time is granted to comply of subject.
Seal number 43, my lord.
43.
Arguing counsel is not well, my lord. A week's time may be granted. State is on the other side.
Appearing for whom?
A petitioner.
at the request of counsel for the petitioner, leaves this matter up to 2 weeks.
51, my lord.
51.
As for the petitioner. Don't is the only part. So 2 weeks, my lord, and need some documents.
You are appearing for?
Petitioner.
At the request of petitioner, leaves this matter up to 2 weeks.
Bill number 58, my lord. I pay for the type filing the petition, my lord.
58.
58.
Hmm.
I pay for the respondent number 3 and 4.
Have you informed other side?
Yes, my
Huh?
lord. Please, my lord.
3 and 4. Yes, at the request of, have you informed?
Yes.
3 and 4, leaves this matter after 2 weeks.
My lord, filing memo for posting, my lord, this is a fresh matter.
First time?
Sir, VC adjournments yaru? VC adjournments?
Yes.
90, my lord, Siddhaya.
Yes, mister.
As I am not well, 1 week's time may kindly be granted, my lord.
Serial number?
19, 19.
Yes.
3830.
Petitioner leaves this matter after 2 weeks. Yes.
Wish number 1 for being spoken to, serial number 1. Jagadish Shastri for petitioner.
On for the petitioner.
Sinchana MR.
What is this, mister?
In this case, my lord, I produced the judgment, my lord, the Supreme Court judgment, where only the point is, my lord, at the time of verification, it not produced with curable defect.
Where is that?
My lord, I produced the judgment, my lord.
When it can be produced?
My lord, the kindly page number, take the page petition, my lord, judgment on Veena versus, my lord, the state of Karnataka. Page number 11. Page number 11.
Veena versus?
Veena versus state of Karnataka. Under the division bench judgment. Page number 11. Para Milan judgment. The small Supreme Court judgments noted not the Dolly Chandur versus and KRN Singer versus the Honorable Apex Court has.
No, have you served the copy to them?
Served, my lord.
Judgment copy has been served.
So the 4 judgments which he has served through their WhatsApp, my lord, so by memo of being spoken to as valid. The judgment, 2 of the judgment, it's already been dismissed by this honorable court, my lords, by considering Dolach and the case itself. And the second case, which is referring for writ appeal, my lords, it has been pending before the apex court. So at this stage, it can't be considered, my lords, as per his request, because corporation has filed writ appeal in that. Has filed a special leave appeal.
Yes.
My lord, that is division bench, my lord. There's a division bench order, my lord. I can kindly see that this is division bench. It's ordered. My lord, that with the curable defect is stated.
No, curable defects means what, sir?
My lord, the non-production of certificate in is the curable defects.
Curable defects under when?
When in the provision selection list, in the provision selection list, I given the objection also.
Yes, Mr. Madam, what is this?
My lords.
What you say? You are asking.
My lord, once.
No, not you. That.
My lord, say, at the time of provisional list he has given, I have also not disputed that. Our first contention is, my lord, so at the time when he appeared for an interview, that the time itself has not been, because the notification also was very clear. And the interview card also very clearly it says, whatever the documents you have to produce at the time of the
No, what
virginity.
Supreme Court said? What the Supreme Court said?
Lord, in Dolach and the.
See, it is not that he has obtained after that notification.
No, that is not the
He has
dispute at all.
obtained earlier. There is no dispute that. See, he is not making proper submission. That is how that this problem is arises. He is also not putting that cases properly. The case is that, see, when he has produced a certificate along with that objection, still there was list was not issued. Supreme Court said it is incurable to that extent. Till then you can be. After that, once the list is announced, you can't do anything.
Once the provisional list is been
Provisional
announced.
list he has produced along with that provisional list. There you can consider his objection saying that yes, if it is not at the scrutiny, that time you are not done it.
There
Option
also-
still open there. Then it is not his case that after the notification he has obtained. He has obtained. He is also making an allegation that at the scrutiny time he has produced. Anyhow, you have produced the documents you have given, but still you are not disputing that at the time of the objection he has produced that. Supreme Court, you consider that if that certificate is proper, then.
My lord, at this juncture, my lords, the list
No, I
has
will-
been
I will
published
consider.
at 2022.
No, he has approached immediately. He has approached immediately See, when that writ petition has been filed, 2023 itself.
2023 has been filed. My lords,
You-
the matter could
No,
be taken
what-
up on Friday.
what-
I'll come and argue
Yes,
the
yes.
matter.
You
on-
convince on that point also.
Please.
What prohibited you to consider when objection has been filed?
My lords, the original documents were not available even after the provisional list was published. He has given the Xerox photocopy of
Ah,
that
you
list.
can
That was the
seek for-
reason it has not
Now,
been
who
considered.
will give an objection along with that original, madam? If it is lost, it
The
is
time
lost.
of verification when it is
No, that's
not
what
there
that-
with the authority,
No,
my
have
lords,
you
how
read,
to
no,
consider it?
two judgment which is dismissed by division bench, what they said, have you read it?
Please, my lords. before
There,
that.
even at that objection stage, he has not produced. Therefore, if it is produced, we could have been considered. That's
That's
what.
to consider at this stage, my lords, we have, appointing authority needs to
No,
be
just
considered
because
it now.
pending before the court is not the criteria. He has a rest to the court immediately.
Now we have to
You-
remove the post of fourth respondent, then it has to be
Take it
replaced.
out, take it out. If it is wrong, take it out.
I'll
We-
convince
yes,
it on
yes.
Friday, my lords.
Yes, you convince that. Because first thing is, I have doubted that person who is having in a certificate, seeing that he is not produced at the scrutiny cannot be believed. But anyhow, some documents you have produced. Supreme Court said.
That's
you-
first at the stage, he made an allegation on the commission itself.
No, that-
After filing of the affidavit, he come up with a new points, my lords. Every
What is
time,
that?
whenever
No,
the
no, no.
points has been
Similar,
defended, is coming up. with-
similar case, in case of what he has produced, the judgment is dismissed all. In the,
It's been dismissed in
in
all
one of the
cases.
cases similar to this case.
Please, 2A
There
certificate which
also,
has not been.
there
produced.
also he has, the contention is that I have produced that, KAT has given a clear finding that it is false, it has not been produced. Division bench ultimately held at the time of the objection also that is not produced, therefore dismissed. But Supreme Court said that you answer that.
Please,
Yes. When do you want?
Tuesday.
Unless you show any judgment which saying that if it is not produced at the scrutiny stage, it cannot be considered. And otherwise, as on that, see what has happened, one of the Supreme Court judgment has doubted with that judgment that has been referred to that larger bench. Larger bench is also has not answered. They said it is correct. Then subsequently, one more division bench said that since larger bench is not answered, we have to be accepted. That is law.
Both
as on
of
today,
Sakshi Araha
what
and
my-
Rajkumar.
as I understood, you have to be convince me that what is that any new development. I can't depending upon you.
Please, I'll
Yes.
do that. I'll
Till
read.
again make.
No,
yes,
I'll
make me- yes,
assess this court, my lords.
Yes,
We've done 11, my lords, 11.
yes, 11th.
My lords, appointing authority
My
needs to
lord.
be considered now at present. If
No,
this
no,
court
no, no.
passes any order on it.
ಇದು ಅದ್ರದ್ದಲ್ವ ನಾನು ಈಗ ಇನ್ನೊಂದು ಕೊಟ್ಟ
My lord, I have one confession. My lord, if she submitted after the selection, provisional selection list, also there is some inconsistency with the name, my lord. Because there is a fully discrepancy in the name, because.
No, that let them decide. If that, no, we don't know that certificate is correct or not. That has to be decided. If they decide, if it is correct, then there is no other alternative. If that certificate,
Certificate itself is defect, my lord. It's
that let them, I am not sitting here to decide that. Let them decide that. Let us see. First, let them answer that question, then we'll see. Yes,
11th, my
11th, yes.
preliminary hearing matter, serial number 2, Shruti SP for petitioner.
Appearing for the petition of my lord. My lordship, petitioner is appointed as a bill collector in the year 2007 to 8.
IA 1 of 2025 for dispensation of production of
Copy of the
Annex
order.
D for a period of 4 weeks, it is dispensed. Yes, madam.
Lordship, the petitioner appointed as a contract basis on 2008. Till today, there is no allegation. On one complaint by Enjappa, ಕುರಿ ಶೆಡ್ಡಿನಲ್ಲಿ ನನ್ನ ಕುರಿ ಶೆಡ್ಡಿಗೆ ಮೀಟರ್ ಹಾಕದೆ ರೀಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ನಾನ್ ಬಿಲ್ ಕಲೆಕ್ಟರ್, ನಾನು ಅಲ್ಲಿ ಹೋದಾಗ ಗೇಟ್ ಹಾಕಿತ್ತು ಅಂತೇಳಿ 2-3 ಸರ್ತಿ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಹೈಯರ್ ಆಫೀಸರ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರು, ಮೀಟರ್ ಇನ್ಸ್ಟಾಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಲೈನ್ ಮೆನ್ ಮತ್ತೆ ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಇನ್ಸ್ಟಾಲ್ ಮಾಡಿದ್ರು. ನಾರ್ಮಲ್ ರೀಡಿಂಗ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಶೋಕಾಸ್ ನೋಟಿಸ್ ಅನೆಕ್ಷರ್ ಬಿ ಸಬ್ಮಿಟೆಡ್ ರಿಪ್ಲೈ ಅಟ್ ಅನೆಕ್ಷರ್ ಸಿ ವಿತೌಟ್ ರಿಪ್ಲೈ ಸಸ್ಪೆಂಡ್ ಮಾಡ್ತಾರೆ. ಅವ್ರಿಬ್ರನ್ನ ಕ್ವಶನ್ ಮಾಡಲ್ಲ, ಏನು ಮಾಡಲ್ಲ, ಸೇಫ್ ಗಾರ್ಡ್ ಮಾಡೋಕೋಸ್ಕರ ಇದ್ ಮಾಡ್ತಾರೆ. ನಾನು ಬಿಲ್ ರೀಡಿಂಗ್ ನಾರ್ಮಲ್ ರೀಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದನ್ನ ತಪ್ಪಿಸ್ಕೊಳ್ಳೋಕೆ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ಇನ್ಸ್ಟಾಲ್ ಮಾಡೋದು ನನ್ನ ಕೈಯಲ್ಲಿ ಇಲ್ಲ ಮಹಾರಾಜ್. ಐ ಆಮ್ ಎ ಬಿಲ್ ಕಲೆಕ್ಟರ್.
Yes, you take notice, yes.
ಬೇಸ್ಕಾಮಿಗೆ ಆಲ್ರೆಡಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀನಿ.
Yes. Who is that managing director Bescom? Rakshita DJ is directed to take notice for 1. Who is second respondent? Same, 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies and so on. Yes.
Serial number 3, Prasad Hegde KB
For pensionary benefit, my lord, 24 December retired. In
Hmm.
earlier occasion, your lordship directed to file a representation as per order dated annexure K, my lord, till they were not.
Not
clear.
consider.
Not consider.
Who has to consider?
This AG, my lord,
Yes.
fourth respond, 1 to 4 respond can,
Government advocate is
can
directed
take.
to take notice for 1 to 3.
1 to 4 I say
For
advocate.
our ಯಾರ ಬೇರೆ ಇದೆ.
ಇದು, ಹಾ.
ಯಾರು ಅಮರೇಶ್. N Amaresh is directed to take notice for respondent number 4. Issue emergent notice to respondent.
Rajesh Shettigar is appeared in earlier case, my lord, I may be permitted.
ಯಾವ್ದಕ್ಕೆ? Bakru education.
Fifth. In,
Who is Rajesh Shetty?
yes, my lord, in earlier.
Rajesh Shetty is directed to take notice.
Rajesh
for-
Shettigar.
Shettigar.
Yes.
Counsel for the petitioner is directed to serve 2 sets of copies on one government advocate, 1 set each to Amresh and Shettigar.
Rajesh Shettigar.
Yes.
Serial number 4, R. Ramachandraya.
Appearing for the petitioner, my lord. Petitioner is working as a DRE employee more than 30 years, my lord. This honorable court is already passed out a similar case, annexure D and my lord. Annexure D and AE. Supreme Court honorable directed to respondent.
So what is that your case? Ian, what is your case, mister?
But petitioner is working as a DRE employee, my lord. Since last 30 years. Their services not regularized. The similar matter, my lord, annexure D and E, my lord. Similar, this
And
honorable
you are
court,
working as in what?
DRE employees, daily rate.
Oh, ಅದಕ್ಕೂ
ಹೌದು.
ಇದೆಯಾ? Yes.
This similar matters already this past court is already passed out. Annexure D, my lord, D and E. Supreme Court also, they went to the Supreme Court also, Supreme Court was directed to respond authority to consider the regular service of the DRE employees, my lord.
Yes.
Annexure D and E.
That government advocate is directed to take notice for respondent number 1. Issue emergent notice to 2 and 3.
The
Yes.
copy is served to the other state advocate. University
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲಿ ಮೇಡಮ್ ಇದ್ದಾರೆ.
She is appearing for
University.
veterinary.
2 and 3.
Yes.
2 and 3. 2 and 3 says.
Vaishali Hegde is directed to take notice for 2 and 3. Counsel for the petitioner is directed to serve 1 set of copies on government advocate and 1 set on Vaishali Hegde. Yes.
Date may be given, please, my lord.
ಕೊಡಿ ಸರ್ವಿಸ್ ಮಾಡ್ಕೊಬಾರ್ದು. Yes.
Serial number 5, A. Nagarajappa for petitioner, connected matter.
Petition, my lord, this is, my lord, the suspension of, my lord, 2 matters.
Why 2? What is that?
Lord, it's a different officers, my lord. One is, my lord, in first matter, is the Shankar, my lord, is the, my lord,
That officer section
second division assistant.
Para numbers to be stated correctly, annexure detail not forthcoming at verification. Second matter, office violation, you comply that. Pass over. Pass over, yes.
Serial number 6, R. Ramachandraya.
Madbudu, sir.
Here in this case, my lord.
Yes.
Petitioner is ex-employee of the respondent bank, my lord. They made a false allegation against the employee at terminated service. Where petitioner went to the tribunal is passed order. Thereafter, the petitioner bank is filed a writ petition before honorable court. That is a annexure G, my lord, annexure C. That as for the honorable court has already partly allowed for the director to the respondent bank to consider the representation of so and so, my lord. Till now, they are given endorsement, my lord, annexure A. Without any valid reason, they given issue the endorsement, my lord.
What is that endorsement?
Endorsement, it is there is no any provision. You appeal for the further appeal, my lord. Annexure A.
What has happened that, who are you?
I am petitioner, my lord.
No,
I
ನೀವೇನ್
am ex-employee of the petitioner bank, my lord.
Yes, ex-employee of State Bank of
Please,
India.
my lord. When I am working in the, they made a false allegation against me. That I have dismissed my service, my lord. Thereafter, I challenged before the tribunal, CJT. CJT set aside the order of the bank, respondent bank, my lord. Again, respondent bank, they filed writ petition before the honorable court for challenging the tribunal order. That honorable this court was directed to the set aside the matter for partly allowed to directed to the respondent bank.
Order.
Annexure C, my lord, page 33. But I made a presentation according to the orders of the honorable court.
Annexure?
Annexure C, my lord, annexure C.
Annexure C is the division bench.
Please, my lord, that order. That order, they, accordingly, that order only I made
Why
representation.
you went to that division bench, mister? Which
Twen-
order you have challenged that?
That is one, the annexure, I am annexure A challenge and endorsement. They're squashing for endorsement, seeking for quashing endorsement.
ಮೊದ್ಲು ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ?
I am seeking the endorsement, squashing endorsement. That is annexure 6, annexure representation, challenging. Annexure D.
No, Mr. Council, annexure C.
Please, my lord.
You have filed a writ petition before the division bench challenging what, mister?
I have not failed. Respond bank only.
ಆಯ್ತು ಅವರೇ ಆಗ್ಲಿ ಏನನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ಅಲ್ಲಿ?
As of the but tribunal has awarded the order, the challenge before this was.
ಎಲ್ಲಿದೆ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಯಾವ ಪ್ರೋಸೆಸ್?
Annexure B, my lord, page 14. Tribunal order.
Petitioner is a former employee of the Export Bank, Penalty State Bank, India, that's order of that disciplinary authority. Tribunal ಅಲ್ಲಿ ಏನಾಯ್ತು ಆರ್ಡರ್?
Set aside ಮಾಡಿದ್ರು ಅದನ್ನ. You have to reconsider of the employees of the taking department.
ಅಪೀಲ್ ಅಲ್ಲಿ ರಿಟ್ ಅಲ್ಲಿ ಏನಾಯ್ತು?
Writ ಅಲ್ಲಿ the part forward, my lord.
ಏನಂತ ಆಗಿದೆ?
ಏನಂತ reconsider ಮಾಡಿ ಅವರಿಗೆ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರು. Part forward.
Read order. Read page 43.
Please, my lord.
Para 15.
In view of the aforesaid, we are of the opinion that the CJT has set aside the order of the removal of service from the employee based on this summarize and conjecture when the request interference at the hands of the court. Thus, the order of CJT ordering reinstatement of the employee with back pages being a very lenient approach of CJT is set aside. However, in view of the charges leveled against the employee, we are of the opinion that the matter requires consideration at the hands of the General Manager of State Bank of India, Regional Office, Davangere, in respect of the quantum of the punishment. Since the employee is more than 50 years of age, old age, is another still having service of more than 5 years, my lord. Accordingly, I have made a presentation before his respondent bank.
ಏನ್ ಮಾಡಿದಾರೆ ಅವ್ರೀಗ?
ಅವರ ಎಂಡಾಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ, annexure A, my lord.
Issue notice. Yes.
Muttana is appearing, which has entered document.
Appear ಆಗ್ತಾರಾ?
ಹೌದು.
TP Muttana is directed to take notice for respondents. Council is directed to serve 2 sets of copies.
Serial number 7.
Please, brother.
Satish K for petitioner.
I appear for the petitioner.
Not been listed. On 30th January.
Yes, I will hear. Yes.
I have served a copy. Yesterday only I have served a copy.
Yes.
Lord, the petitioner is an employee of Lord KPTCL. Lord, on deputation to KADB.
Yes.
By order dated 20, annexure A, page 25, 8/7/2021. Lord, the Industries and Commerce Department writes a letter to the KPTCL, my employer, seeking, Lord, its consent for deputation.
Yes.
Lord, the Industries and Commerce seeks deputation, which is given at annexure B, page 28, only to show that there is a consultation between employer, borrowing and lending authority.
Yes.
Lord, annexure B, page 28.
Yes.
For a period of 1 year, I was deputed.
Yes.
That is on 21/8/2021.
Yes.
Thereafter, my lord, from time to time it was extended. Thereafter, my lord, annexure C, page 34. The KADB requests for continuation of my deputation for a period of 1 year. My lords will find at page 34, annexure C. It is on the request of KADB.
Yes.
For another 1 year, I was then, my lord, by order dated 7/5/2025, the period of deputation was extended for 1 year
Yes,
from with effect from 16/5/2025.
yes,
That, my lord, my period of deputation will come to an end on
yes.
16/5/2026.
Yes,
That, my lord, this May 2026.
yes.
Lord, impugned order is at annexure E, page 38.
Hmm.
The fifth respondent, who is also, Lord, deputation from KPTCL, is now posted to my place. Without, my lord, consultation, I have been repatriated to my parent department.
Yes, where is that read?
Lord, annexure E, page 38.
Yes,
Lord, Lord, it is not until further orders.
yes.
My period is specific for a period of 1 year. Your lordship may kindly come to page 37, my lord.
Yes.
1 year ಅಂತಿದೆ, ಮುಂದಿನ 1 ವರ್ಷದವರೆಗೆ ಮುಂದುವರಿಸಲಾಗಿದೆ. Until further orders ಅಂತಿಲ್ಲ.
Yes.
Lord, annexure E, page 38 is the impugned order. ಗಿರೀಶ್ ಕುಮಾರ್ MR, ಸಹಾಯಕ ಅಭಿಯಂತರರು ವಿದ್ಯುತ್, ಕರ್ನಾಟಕ ವಿದ್ಯುತ್ ಪ್ರಸರಣ ನಿಗಮ, ಇವರು ಹಾಜರಾತಿಯನ್ನ 31/26 ಪೂರ್ವಾಹ್ನದಿಂದ ಅನ್ವಯವಾಗುವಂತೆ ಅಂಗೀಕರಿಸಿದ್ದು, ಸರ್ಕಾರದ ಉಲ್ಲೇಖಿತ ಆದೇಶದನ್ವಯ ತಕ್ಷಣದಿಂದ ಅನ್ವಯವಾಗುವಂತೆ ಮತ್ತು ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ನಿಯೋಜನಾ ಸೇವೆ ಮೇರೆಗೆ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರ ವಿಭಾಗ KIDB ಕಚೇರಿಯ ವಲಯ ಕಚೇರಿ ಮೈಸೂರು ಇಲ್ಲಿ ಸಹಾಯಕ ಅಭಿಯಂತರರು ವಿದ್ಯುತ್ ಹುದ್ದೆಗೆ ಶ್ರೀ ಕಿರಣ್ ವಿ ಇವರ ಜಾಗಕ್ಕೆ ಮರು ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿದೆ. ಮುಂದುವರಿದು ಶ್ರೀ ಕಿರಣ್ ವಿ ಸಹಾಯಕ ಅಭಿಯಂತರರು ವಿದ್ಯುತ್ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಭಿಯಂತರ ವಿಭಾಗ KIDB ವಲಯ ಕಚೇರಿ ಮೈಸೂರು ಇವರ ಸೇವೆಯನ್ನ ತಕ್ಷಣದಿಂದ ಅನ್ವಯವಾಗುವಂತೆ ಅವರ ಮಾತ್ರ ಇಲಾಖೆಯಾದ ಕರ್ನಾಟಕ ವಿದ್ಯುತ್ ಪ್ರಸರಣ ನಿಗಮ ನಿಯಮಕ್ಕೆ ಹಿಂದಿರುಗಿಸಿ ಆದೇಶಿಸಿದೆ. By, my lord, respondent number 4.
Yes.
Lord, he cannot repatriate unless consultation and, Lord, the period of deputation cannot be curtailed if it is, my lord, tenure post. My lord, my lords may ask the transfer guidelines, can it be applied to deputation?
Transfer, no.
My lord,
I have not asked the transfer guidelines is applicable. It is
yes,
not applicable. Yes.
Lord, if it is a tenure post, whether it can be curtailed before the deputation. Lord, Lord, para 32 of the Ramakrishnan. Para 32 of, my lord, judgment of the Honorable Apex Court is that if it is a tenure post, it cannot be curtailed unless my service is unsatisfactory.
Yes.
Lord, ordinarily, deputationist has no legal right to continue in the post. A deputationist indisputably has no right to be absorbed in the post to which he is deputed. However, there is a bar thereto as well. It may be true that when deputation does not result in absorption in service to which an officer is deputed, no recruitment in its true import and significance takes place, as he is continued to be member of the parent service. When the tenure of deputation is specified, despite a deputationist has not having indefeasible right to hold the said post, ordinarily the term of deputation should not be curtailed except on such grounds, for example, unsuitability or unsatisfactory for performance. But even when the tenure is not specified, an order of reversion can be questioned when the same is malified. Therefore, my lord, my deputation is for a tenure. It can be curtailed only when there are allegations or unsuitability. Lord, now, my lord, as per annexure D, page 37, Lord, my service is continued from 16/5/2025 for a period of 1 year. That is, my lord, till 16/5/2026.
Yes.
It cannot be curtailed. And, my lord, recently the division bench has held that, my lord, transfer guidelines applies even for deputation. Lord, Court of, my lords, a specific question was posed. Krishna. My lord, a specific question was
No, I think 2025 guidelines that has been removed.
that has been removed. My lord, that is considered, my lord, para 9, para 10, my lord. Kindly come to para 10. Both, my lord, 2024 and 25 guidelines
Yes.
Para 10, my lord.
Yes.
Having heard the learned counsel appearing for the parties and on perusal of the entire writ petition papers, the following points would arise for our consideration. 2, my lord. Whether the general transfer guidelines dated 25/6/2024 would be applicable to deputation. Kindly come to para Lord, 19. In the light of the above discussion, my lord Scott, I'm sorry, my lord.
Yes.
Para 19. In the light of the above discussion, we are of the considered view that transfer guidelines laid down under the government order dated 25/6/2024 and subsequent government order dated 12/5/2025 would be applicable to case.
Government order
Ada
2015.
ತಪ್ಪಾಗಿದೆ. 12/5/2025 is the transfer guidelines. Subsequent transfer guidelines would be applicable to the cases of deputation also, subject to Rule 50 of KCSR and relevant government orders issued from time to time.
Posting of the government from post to another headquarters to where the department existing so and so. Unless change of the officer.
Therefore, my lord, the transfer guidelines applies even for deputation, which is answered when it is a tenure post. If there is no tenure, my lord, I may not have a right, or it is for a period of 1 year or until further orders. Yes, my lord. Then the order will come to an end when another order is issued. Here is a case, my lord, it is for a period of 1 year.
No, in that situation, why can't you apply that transfer guidelines?
Yes, my lord.
If there is no tenure also.
Yes, ma'am.
No, you said that if there is no tenure is fixed, transfer guideline is not applicable. Why you can't say that? There also you can say that before 2 years it cannot be.
It can be. Yes.
No, I am saying that why?
Not the reasons.
Case.
Yes, ma'am.
It is tenure is not fixed. You have been deputed. Within that 2 years you have been repatriated. You can't say that in view of the transfer guidelines you cannot be.
Yes, my lords, maybe.
No, because only options they have given is if that under Rule 50 it is in a 3 years, 5 years.
It is 5 years.
5 years.
Even if it is 5 years, I have not completed 5 years. But here is a case where, my lord, my service is extended till 16/5/2026. My lord, they can repatriate my service, saying that it is unsuitability. That is what, my lord, Union of India versus Ramakrishnan says.
Yes.
Admittedly, my lord, he is on deputation since the year 2021, which is approximately around 4.5 years or 4 years, 8 months. Lord, the question of tenured post does not arise because the rules does not contemplate tenured post in these categories of posts. And present government order, which has been reaffirmed in Krishna Kumar, says for all category B posts, class B posts, it is 2 years. Yes, his period has been more than 2 years. It is almost 4.5 years.
No, the division bench said subject to Rule 50.
Rule 50.
Rule 50 only provides for the maximum period in which deputation can be granted, not the
Therefore,
minimum period.
If that maximum period is crossed, you can't apply transfer guidelines. Otherwise, you apply. That is what that meaning.
The transfer guidelines contemplate only a period of 2 years for this particular category of employees. What it says that even if he is renewed for another period of 2 years or 2 years, it can never be more than 5 years. He has to come back to the parent department within a period of. So Rule 50 has got no application. That it does not put the ceiling on the period where he has to be deputed. Only the point for consideration would be whether 2 years period has elapsed since his coming on to deputation.
No, mister. There are two things. For the deputation, maximum is 5 years.
Total maximum.
Maximum is 5 years. He cannot be outside his parental department for 5 years. Within that borrow department, he can save for 2 years. He can be saved for 2 years, or if they say until further orders, he has to go because he has accepted that. Now he is on 2, even he has not crossed maximum 5 years. Second thing is that even 2 years, Here he has accepted for 1 year, that is also not completed.
That is, he is here on deputation since the year 2021.
No, that is only 5 years. That is also not crossed. That's what I asked him. It is not crossed.
I have not.
When he has comes to that, this thing.
Synopsis.
21/8/2021, my lord.
21/8?
2021.
Then before that only this 1 year will complete.
Oh, ಹೌದು.
21/8. 5 years.
21.
26/8 ಗೆ ಆಗುತ್ತೆ.
ಆಗತ್ತೆ. And the government order for
26/8 ಆಗ್ಲಿಲ್ಲ, ಆಮೇಲೆ ಈ 1 ವರ್ಷನೂ ಆಗ್ಲಿಲ್ಲ.
15, 16, 5, 20.
Deputations are one. My lord, whatever may be the previous order by which he has come into his position.
Yes.
The government order for transfer is binding on the departments, and it overrides any contrary clause which may be there in his period of appointment. One, his earlier deputation for 1 year. Subsequently, it is renewed or extended. The documents are not produced on the conditions on which it has been extended.
No, that's all over. Now that by Annexure D, it has been renewed for 1 year.
It has been renewed for 1 year.
16/5/2025. It can be reduced giving in a proper reason. Otherwise, deputation is right also protected. He cannot be thrown whenever he want. That's what that Supreme Court said.
So that is a different case, my lord. My lord, what he
Law is
reminds-
same, Mr. Case may be different. Law is same. Yes.
So that was a case in Ramakrishna where he was due to be absorbed, my lord. He was due for absorption, and the fact that he is removed from that post would also take away his right to be absorbed into that post.
Yes.
And then there they said that because he has got a right to the post, and he is now there on deputation, and he is entitled to be absorbed into that post. The fact that there is no absorption yet does not take away his right to continue in the post without any reasons for being removed from the post.
Yes.
Which is on a different category from the post where he is on deputation here, where he has no right for absorption in this department.
Yes.
And there that would be a vested right because he would be entitled to be absorbed into the post where he is deputed. This is not a case where he is entitled to be absorbed into a post where he is deputed. And there would be a vested right which exists. Here there is no vested right in the department where he has been lent to. The only question would be whether he has completed a period of 2 years as under the new guidelines which is issued and which has been confirmed by in the case of Krishna Kumar Manad, which is 2 years. Those rules contain 2 years.
Yes.
Irrespective of what has been given in the letter of appointment, that would override the conditions which have been there.
Now, when he has come to this thing?
He comes into this place in the year 21/8/2021.
Yes.
And the period of 1 year, even if it is there, it is not a tenured post. Even though the tenure might have been mentioned, that does not make it a tenured post. Tenured post has got a different implication under the statute.
Now, one thing, Mr.
Please.
You have completed the tenure of 2 years. Same department and same post. It is an extension. It is
Extension,
not an annuity.
yes.
Therefore, transfer guidelines will not apply.
Will not apply. But
Transfer
my
guidelines-
lords asked in other cases whether that applies.
No, transfer guidelines.
Lord, it is not for this case, Lord. I am not relying upon, Lord, my lords were asking whether.
Now, what is the facts of the case in that, this thing?
And respondent number 5 has already.
In Union of India versus Ramakrishnan.
Yes.
But deputation, he was on deputation. Once tenure is fixed,
Yes.
whether it can be curtailed is the question. Lord, while answering that question, my lord, this one,
One more judgment which is produced by, ಅದು ಯಾವತ್ತು ಹೋಯ್ತು ಅದು? ನೆನ್ನೆ ಇತ್ತಲ್ಲ, ಅಡಿಷನಲ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಅಪೇರ್ ಆಗಿತ್ತಲ್ಲ.
if tenure is not fixed, my lord, I have no case.
Some more judgment has been produced, additional advocate general. If that borrowing department don't wants that, he can be send it.
It can.
That is what that.
Not that-
This is what your borrowing department only, they wants to send it you out. Yes, Monday.
That is my lord, CB Chikkalgi versus state.
No, I have not seen, but matter has been adjourned on Monday. We'll have it, this matter also on Monday. Yes.
But
Yes. Same issue. Will he say here on that Monday? Additional Advocate General is appearing in that matter. Yes. Yes, Monday I will.
Till
have.
then. Reported, my lord.
Huh?
He has already reported on second.
Who?
Respondent number 5.
No, if it is not implemented, not to implement till Monday.
Status quo may be out.
Yes.
Status quo, but your lordship may stay,
Yes,
my
already
lord.
reported, my lord.
No, I can say stay if it is not implemented. When that order has been passed.
Not date yesterday. My lord. On
When you have-
second, it is passed.
31st.
ಅಲ್ಲ ಅದ್ರ ಕೆಳಗಡೆ ಎರಡು ಅಂತಿದೆ. Impugned order is dated 2/31/1 ಕೆಳಗಡೆ ಎರಡು ಅಂತಿದೆ. It is passed on 2/2.
Yes.
Today is my lord 4th. I have filed yesterday and your lordship may.
No, will say yes.
I will have no posting now, my lord. At least.
No, even that is also question has been raised in that. We'll see what the traditional Advocate General is
They
answering.
rely on SEMA, my lord. SEMA was a case where it is a transfer within the department. SEMA will not apply in a deputation case because there is no.
No,
question
he
of
is not
application.
relying on that SEMA case.
ಇಲ್ಲ ಸೀಮಾ ನಂದು.
They put it in the synopsis.
ಇಲ್ಲ ಇಲ್ಲ ಸೀಮಾ.
Deputation will only to go back to the parent department. The parent department will allocate.
No, that he has relied on some judgment. I think it is on that. If borrowing department don't want, they can send it at any time. That's what that he has argued. Additional Advocate General.
There, my lord, consultation is required.
Necessary. It is their Supreme Court judgment. One of the department can do it. 2000 SC kudi.
CB Chikkalgi versus state, my lord, the division bench.
I once Kunal Nandan. 2000. This is again the two judge. Person concerned can always at any time be repatriated to his parental department to service in substantive position therein at the instance of either of the department. That is what the let us.
Your lordship may stay if it is not implemented.
Yes.
Your lordship may
Stay of annexure D dated 7/5.
E.
He has already been. He has already reported. That is what we have just produced.
No, I am not hearing testing that whether reported or not. Just hear my order. Annexure E dated 31/1/2026 is stayed subject to condition if that order is not implemented.
R1, my lord, my learned friend, government advocate may be direct.
Advocate is directed to take notice for respondent number 1. Who is for KPTCL?
Mr. A. Chandrachud.
Chandrachud 1 and
2.
No, Karnataka Industrial Area Development Board 2. Yaar iವ್ರೆ KDB. PV Chandrasekhar for 3 and 4.
Yes.
You are appearing for 5. 5. Leave this matter. And ಯಾವತ್ತು ಹೋಗಿದೆ ಅದು?
Sir, 9/2.
9. Yes.
Sir, dispensation.
We'll see that on that day what will. Yes.
If my lords are hearing the
same
similar
issue.
issue, my lord, I may not have.
Additional Advocate General has appeared.
Serial number 8, Manjunatha H for petitioner.
For the petitioner's counsel, my lord, the petitioner before your lordship is a retired judicial officer
Yes.
who was appointed as a member of the Karnataka State Consumer District State Commission, my lord,
Yes.
as a judicial member,
Hmm.
and he was relieved in the month of January 2025, my lord.
Hmm.
By virtue of the Supreme Court order in May of 2025, my lord, your lordships had also extended the benefit of continuance of service for certain members who were already there, continuing in the services. Subsequently, my lord, representations were given as per Annexure A by the petitioner to the government to reinstate him because the posts have remained vacant till date and there is no recruitment process which has commenced. As per the Honorable Supreme Court's order, my lord, until the recruitment process is commenced and appointed, all of them were directed to continue to be operational. And recently, my lord, as per Annexure J, this Honorable Court, Dharwad bench has granted an interim order. Annexure J at page 126, my lord. Similarly, placed retired district judicial officers, my lord, have been directed to continue in the services. As per Annexure J at page 126, my lord, the operative portion is at page 128.
Yes.
Para 7, my lord. Accordingly, by way of interim arrangement, R2 is directed to permit the petitioners to continue as presidents of the district consumer redressal commissions in the same places from which they were relieved until further orders or till the recruitment process is completed.
Yes.
Here, my lord, the post is still vacant. No recruitment process has commenced at all. Pursuant to amendment of the consumer appointment rules, my lord, they have not been given effect to. And the representation was also yet to be considered. My lord, we request your lordships to extend the same benefit to this petitioner also.
No, when he has relieved.
My lord, on he was
25,
relieved on 9/1/2025, my lord, as per Annexure D, page 24. Subsequently, my lord, pursuant to your lordship's order also at Annexure G, which is at page Annexure H, my lord, at page 124. There was a notification which was issued, Adisuchane, at page 124, my lord.
Yes.
Your lordships, this first writ petition in the third line, my lord, 17162 of 2025, your lordships had granted the interim order.
Page number?
Page 124, my lord, Annexure H, Adisuchane.
Yes.
Adisuchane, third line, Swami, writ petition 17162 of 2025, your lordships had extended the interim order, pursuant to which this notification came to be issued.
For extension.
Please,
of-
my lord, for extension.
No appointment has been made.
No appointment, my lord.
My lord,
Till now, they're vacant.
Page number 126, my lord, they are the persons who have not been attained the age of 67 or the 70 as per the section 55 of the consumer. They have not attained that age, so they were extended.
What is the age of the petitioner?
My lord, all of them are
Already-
under 67, my lord.
My lord, this is already he has attained 67. It is a retirement age.
68, my lord. He's 68 years old.
What is that age limit is?
My lord, there is no, if your lordship may kindly look at the Supreme Court order, it doesn't say age limit. Your lordship may kindly come to the interim Supreme Court order at Annexure E, my lord. And
Page number
page
111,
number
my lord.
26, my lord.
Annexure?
Annexure E at page 26 and reliefs are at page 109, my lord.
No, why Supreme Court has extended that?
Because there were no recruitments happening in all the states, my lord.
No, that is true. Recruitments.
Direction
can
at
be-
page number 111 may be looked
Person
into.
who is barred under that statutes can be permitted to work.
No.
Only, my lord, after superannuation also, they were permitted to continue.
Superannuation,
Please, my lord.
the reason is that in respect of extension of the time.
Please.
Therefore, that issue was there. Supreme Court said frame the rules and all.
Please.
For a second time, extension can be
Please.
given or not. Now, person who has barred that age, he is not entitled for.
My lord, that was not.
No. That is what that law says.
111 page 111 may
Please.
be turned, my lord.
Yes.
Directions.
Page?
Page 111, my lord. 111, my lord.
Summary of relief starts from 109, my lord. Category of persons. And the relevant is 111.
111, yes.
President, 3, my lord, President and members of the State and District Commission who have been appointed and serving prior to Limaye. Limaye is 3/3/2023 judgment, my lord.
Yes.
Prior to that, all of these were serving prior to 3/3, which is, I would be extend. They shall be allowed to complete their tenure in entirety. In the event of their tenure ending before the completion of the recruitment process, under their new rules to be notified, their appointment shall be allowed to continue until completion of the set recruitment process. There is no time frame or age denoted.
Allowed to complete their tenure
Please.
entirety.
Please.
In the event of their tenure ending before the completion of the recruitment process under the new rules to be. See, in the
Also
event
similar-
of their tenure ending before the completion of the that is tenure. It is not that age limit. See, they have been fixed a tenure of 5 years.
Please.
Before that, if tenure is completed before the recruitment, extend subject to that age limit.
Yes.
It cannot be that beyond that.
My lord, does age limit was not a question before the.
No, but section says, show me that what is that age limit. You can't go beyond that.
55, my lord, qualification.
What is?
55.
My lord, even assuming, my lord, if we go by the age, he was appointed in 2020. He has not completed the term of 5 years,
No.
full 5 years.
Age of
He has not completed full 5 years.
No, see, if the persons who is entitled to be work till 79, what is that age limit?
55, man.
55 ಅಲ್ಲ 55 6 ಅವರು ರಿಟೈರ್ ಆಗದೆ 60 ಗೆ
No.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜಸ್ ಆಗಿ
Section, madam.
ಸೆಕ್ಷನ್ 50
section 55, what, yeah.
Qualification
That president, members of the members.
provided further, my lord, I jump to 55(1), my lord, provided further that no president or a member shall hold the office of such other he has attained such age as specified in the rule made by the central government which shall not exceed in the case of the president the age of 70 years. In the case of any other member, the age is 67 years.
67 years. Yes.
ಇವ್ರು 66 ವರ್ಷ ಸ್ವಾಮಿ ಇವ್ರು.
No, 67 already.
Sorry, my apology. 68. My apology. In a related connected matter, really they are under a
60.
They are within 66.
They are all below connected.
Yes.
In connected matter, they are below. My lord, I may be permitted to may seek for a pass over on this. I will clarify with the Supreme Court judgment itself that the age was not a criteria which was
Supreme
taken
Court has not considered this. Only said if your term is there, term is there means you have not completed 67. That is the meaning. You cannot be appointed beyond that statute says. If term is there, if that rules has been framed, if you are before that term is completed, even after the term is completed, if the rule has not been framed, you can be continued. Supreme Courts have not said that age, but section says that age is 67.
Please, my lord. That was
beyond that.
Please, my lord. I may be permitted to clarify on that aspect, my lord.
Yes,
If I request for a pass over, I will.
Yes, pass on.
Please. Lord, similarly, item number 12 is also, but that is within the age, my lord.
Yes, 12.
12 and 22, my lord.
12, then we'll come back. Yes.
Please,
on the serial. Yes.
Serial number 9, Vijay Kumar for petitioner.
Yes, 1 of 2026 for dispensation of certified copies of the annexure L, H, F for a period of 4 weeks. Typed copy A, so and so annexures is dispensed. Yes.
And petitioners were appointed on daily wage basis in Lord Malagappa Gram Panchayat, between 85 and 87. That Gram Panchayat was merged with the Shumagga municipality, in 1996.
Yes.
Lord, the persons who were absorbed, who were merged with the Shumagga municipality, regularization were sought to be made, except the petitioners, on the ground that they have, without any valid reasons, their names were not included. They approached this honorable court in WP 36081 of 2013.
Yes.
That was disposed of, directing to consider their claim.
Yes.
Since there was no response from the respondents, they filed a contempt. During the pendency of the contempt, by an endorsement, their claim is being rejected on the ground that they do not fulfill the conditions prescribed under the Uma Devi's case.
Yes.
That endorsement is under challenge.
Yes.
On the ground that the Uma Devi has subsequently been diluted. They have complied with the 4 conditions prescribed under the Uma Devi.
Yes.
Therefore, they having retired from service, now they sought to be denied the regularization. The recent judgment,
Who has to?
The respondent number.
Government advocate is directed to take notice.
R 1, 5 and 6, is government.
1, 2 and 5 and 5.
1, 5 and 6,
6. Amresh is directed to take notice.
Notice may be ordered to respondent 2 to 4,
2 to 4 issue emergent notice. Yes.
Please.
Serial number 10, Suvarna Lakshmi ML.
Annexure M is under challenge whereby the petitioner is in the cadre of Powerman. Powerman being a Group C cadre, the seniority is maintained circle wise.
Yes.
Now, I was promoted as Powerman on 19/6/2014.
2014. Yes.
My parent circle is KGF division.
Yes.
I'm working in Bangarpet.
Yes.
On 15/4/2019, there was a complaint filed about my participation in a political rally.
Yes.
To avoid the controversy and to keep me away from the constituency of Kolar,
Yes.
for a short period, I was transferred to Chikbalapur division.
Yes.
So my parent division, which was Bangarpet,
Yes.
my salary was paid by them. Last pay certificate was held by them. Attendance was held. And even my service records were at KGF division.
Yes.
Short period, I went and I came back,
Yes.
After that, various other seniority lists have been published. The previous one, your lordships could kindly take page number 49. which is Annexure G. This is 18/9/2024.
49.
Ali serial number 13, SV Manjunath.
49, yes,
49, page 50 is the seniority list.
yes.
Powerman Antima Jeshtata Patti, Dinanka
You are in
so.
Bangarpet.
Ali Malaj, in column
Yes.
25, ಪ್ರಸ್ತುತ ಹುದ್ದೆಗೆ ಹಾಜರಾದ ದಿನಾಂಕ, which is shown as 19/6/2014, which is the date of promotion.
Yes.
Now what has been done, my lords, is, if your lordships could see, my lords, Annexure J, page number 54, which is the provisional list. From serial number 13, I am pushed down to serial number 45 at page 56.
Yes.
Here, the ಪ್ರಸ್ತುತ ಹುದ್ದೆಗೆ ಹಾಜರಾದ ದಿನಾಂಕ 19/6/2014 ಅಂತ ತೋರಿಸ್ತಾರೆ. Remark reported to this division on 4/5/2019 ಅಂತಾರೆ. So based on this, it is altered.
This is which division seniority list?
This is also KGF division itself.
KGF only.
Please, my lords.
Why that you are in the KGF only?
Please, my lords. Briefly, I was, my lords, moved during elections to
Yes.
Chikbalapura, and I came back on 4/5/2019.
No, that is not on your request.
That is not on my request.
Where
It
is that transfer order?
My lords, may kindly see Annexure B, my lords. Annexure B is the report of the superintending engineer.
Yes.
After that is Annexure C, which is OM. OM dated 16th April 2019,
Yes.
which is done in the interest and in the background of, my lords, the controversy that was involved there.
Yes. Now that page 55.
My lords,
Where
one
is
more.
the serial number?
45, my lords.
45. Yes. Manjunath.
Please, my lords. Even I have produced the salary certificate, which is at page Annexure H, my lords. Page 53. Even that shows, my lords, that my salary also was paid by them.
No, this is a provisional list.
Provisional list ಗೆ ಉತ್ತರ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರೇ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀನಿ. Annexure M.
Annexure N.
M, page 63.
What is that?
Here, my lords, ಉಲ್ಲೇಖದಲ್ಲಿ ನಿಗಮ ಕಚೇರಿ so and so dated 28/11/2025. This is the direction by the second respondent. Then ಈ ಕಚೇರಿಯ ಪತ್ರ ಸಂಖ್ಯೆ 5/1/26, which is provisional seniority list. ತಮ್ಮ ಪತ್ರ, which is my objection. My objection also is not considered. Solely based on ನಿಗಮದ ಕಚೇರಿಯ ಪತ್ರ, which is 28/11/25, they say we are refixing it.
Yes, you take notice. Bangalore Electricity Supply Company ಯಾರಿದ್ದಾರೆ? Bescom. Rakshita DJ is directed to take notice for all three. No, this Communication Division Bescom, all three. Yes. Counsel for the petitioner is directed to serve 2 sets of copies and so.
My lords, a date, please, because I'm due for promotion.
They have not yet issued final seniority
My
list.
lords, it will be coming, my lords, in the next week.
Yes.
Based on this communication that is impugned herein.
19th.
But same stage, please, my lords.
Yes. You serve a copy to her.
Serial number 11, Vijay Kumar for petitioner.
Yes, Mr.
The selection and appointment of.
A1 of 2026 dispensation of certified copies JK for a period of 4 weeks, subject to production of that dispensation of type to copy. Yes, allowed.
Selection and appointment of respondent 4 to 7, my lord, as chairman of the National Council for Homeopathy and president of 3 autonomous boards are under challenge, my lord. But 1/3/2025 a notification was issued seeking inviting applications for the post of chairman as well as president of 3 autonomous boards, my lord. Before issuing the said notification, my lord, on the previous selection process, but the petitioner has approached this honorable court challenging the selection and appointment of the post of chairman and one of the president of one of the boards. But those writ petitions were allowed. And my lord, the post of chairman and the president of medical assessment board were set aside.
Where is that?
Lord, I have not produced that, my lord.
Yes.
The said order was challenged in the division bench, and the division bench allowed the appeal, set aside the order of one single judge. The matter was taken to the Supreme Court by the petitioner. Lord, I produced the order of the petitioner, Supreme Court, my lord, at page 87, my lord, annexure D.
Yes.
The judgment starts at page 62, my lord. The very same petitioner had approached the
Yes.
Supreme Court, my lord.
Yes.
Lord, the observation made by the Honorable Supreme Court, relevant paragraph, my lord, is at page 79, my lord. Serious allegations were made against the Secretary Ayush Malad for having not considered the claim of the petitioner, though he is qualified and eligible, and ineligible candidates were selected.
Yes.
Para 36, my lord.
Yes.
The conclusion recorded by the Secretary, Government of India, that the third respondent did not have the requisite experience as head of the department, which is nothing but his ipse dicti, is plainly suspect and vulnerable on the face of all these three orders and has to be declared to be a conclusion which suffers from gross perversity. This was the observation, my lord, made by the Supreme Court insofar as a denial of, my lord, appointment to the post
Yes.
by virtue of the observation made by the third respondent. My lord.
Yes.
My lord, finally, my lord, page 51, page 85, para 51.
Yes.
We hold that in the matter of essential qualification prescribed by the statute, there should neither be any deviation from the statutory requirement nor the advertisement inviting applications while conducting any selection unless power to relax qualification is shown to exist. But it was my specific case that the chairman and the president, my lord, were not having the prescribed qualification. Finally, my lord, the conclusion is at page 88.
Yes.
The appeal insofar as they are directed against the impugned judgment and order of the division bench reversing the judgment and order of the single judge are accepted. While we set aside the former, the latter is restored, meaning thereby the appointment of the third respondent stands quashed. The third respondent shall step down from the office of the chairperson of the commission forthwith. By forthwith, we mean the week from a date to enable him to complete his pending assignment without, however, taking any policy decision or decision involving finance. Fresh process be initiated for appointment to the office of the chairperson of the commission expeditiously. We hope and trust that the selection process will be taken to its logical conclusion in accordance with law.
Yes.
Pursuant to this order, my lord, 1/3/2025 notification was issued.
Yes.
Lord, which I have produced, my lord, that annexure. Annexure C, my lord, page 56.
Yes.
Lord, strangely, since the petitioner had already crossed 65 years, my lord, Lord, a clause was inserted at page 57, clause 5, my lord. Upper age limit. Application must be less than 65 years of age as on the closing date of receipt of the application.
Now, where you are reading?
Lord, page 57, my lord. Lord, clause 5, my lord.
Class 5. Yes.
Upper age limit. The applicants must be less than 65 years of age as on closing date of receipt of the application.
Yes.
Lord, this is contrary to 2020 Act itself. Well, therefore, I approach this honorable court in WP, Lord, 7479 of 25. Lord, page 96 may kindly be seen. Lord. The interim order granted. A detailed order was passed, Lord. Page 92, it starts.
Yes.
Page 96, last paragraph, my lord.
Yes.
Lord, therefore, it appears prima facie that the impugned notification overreaches the provisions of National Commission for Homeopathy Act 2020. Hence, the petitioner is for granted interim relief by permitting him to participate in the selection process for appointment to the post of chairperson of the National Commission for Homeopathy and presidents of 4 autonomous bodies for homeopathy. This is, however, subject to outcome of this writ petition. This writ petition is pending as on date, my lord.
Yes.
But in the meantime, my lord, the third respondent, that is the Secretary Ayush, against whom, my lord, I had approached this honorable court on earlier proceedings, my lord, and the observation made by the honorable Supreme Court insofar as para 36 concerned. But I expressed doubt with regard to his, my lord, participation would.
No, as per the Supreme Court order, he has not been removed.
No, he has been removed.
Then?
But his appointment was quashed. I'm talking about the participation of the Secretary Ayush as a member of the search committee.
Yes, no, who is the secretary, Ayush?
That is third respondent herein.
No, who is that, to whom you have challenged this appointment?
Appointment, no, the appointment of chairperson was under challenge. Now, the Supreme Court observed that the third respondent, that is the Ayush secretary, could not have, my lord, para 36 is in so far as Secretary Ayush is concerned, my lord.
There is an,
That is Secretary Government of India, that the third respondent did not have the requisite experience as head of the department, which is nothing but his, that is third respondent is the person who was appointed as chairperson. His appointment was under challenge. And my lord, here the observation is the Secretary Government of India, my lord, has failed to notice that he did not have the prescribed qualification, and it doubted his integrity insofar as his appointment is concerned.
secretaries also?
Yes, ma'am.
Where is that?
My lord, that is para 36, page 79. My lord, the conclusion recorded by the Secretary Government of India that the third respondent did not have the requisite experience as head of the department, which is nothing but his ipsit dixit, is plainly suspect and vulnerable on the face of all these three orders, and has to be declared to be a conclusion which suffers from gross perversity.
Yes.
My lord, this is observation of the Supreme Court, my lord, insofar as appointment of third respondent therein by the secretary is concerned.
Yes.
Now, my lord, since I came to know that even the Secretary Government of India is going to participate in the search committee, my lord, on the presumption that there will be likelihood of bias, I approached once again this honorable court in WP 16751 of 25.
Yes.
My lord, your lordship may kindly see page 270, my lord.
Yes.
My lord, initially your lordship were pleased to grant an order at page 270.
Yes.
My lord, order dated 21/7/25, my lord.
21/7.
Yes, ma'am.
Yes.
Oral order. The learned counsel appearing for the respondent submit that till the next date of hearing, the respondents will not announce the list. At the request of the learned counsel for the respondent, release the matter on 29/7/25. Now, my lord, your lordship subsequently, after hearing the government, my lord, that is the central government, by order dated 7/8/25, my lord, when the matter was posted before this court on 21/7/25, learned counsel for the respondent undertakes not to announce the list till the next date of hearing. Today, the additional Solicitor General opposed the extension of the said undertaking and submitted that the writ petition filed by the petitioner itself is not maintainable. Since the maintainability and merits of the case has to be decided, the order dated 21/7/25 be modified. Accordingly, the order dated 21/7/25 is modified to the effect that the respondents are directed to go ahead with the matter, and any selection made by the selection committee shall be subject to result of this writ petition. After proceeding with the selection process, my lord, now they have issued appointment orders in respect of persons, again, my lord, who are not qualified in terms of the section 4(2) and 19(2) of the 2020 Act.
What is that qualification?
My lord, your lordship may kindly section 4(2), my lord, which are produced
Yes.
at page 26, my lord.
Yes.
This is in respect of the commissioner, the chair appointment to the post of chairperson, my lord.
26.
Lordship got me. Page 26, man.
Yes. Yes.
Lord, the commission shall consist of the following persons: chairperson, 7 ex-official members, and 19 part-time. The chairperson shall be a person of outstanding
Which
ability.
provision you are reading? National Commission, chapter 2.
Yes, madam. Chapter 2, section 4.
Yes. Commission shall consist.
Yes,
of-
madam. I'm
Yes.
reading subsection 2, madam.
Yes.
Chairperson shall be a person of outstanding ability, proven administrative capacity and integrity, possessing a postgraduate degree in homeopathy from a recognized university, and having experience of not less than, kindly note, my lord, experience of not less than 20 years in the field of homeopathy, out of which at least 10 years shall be as a leader in the area of healthcare, delivery, growth, development of homeopathy or its education. Now, what is leader is the explanation and page 27. Explanation.
Yes.
For the purpose of this section and section 19, the term leader means head of the department or head of an organization.
Yes.
Now, section 19(2) also deals with regard to the appointment to the post of presidents in the 4 autonomous institutions, autonomous bodies under the National Council for Homeopathy, which your Lordship will get at page 32.
Yes.
Your Lordship got it.
Yes.
Subsection 2, my lord.
Yes.
The president and member of autonomous boards be chosen under subsection 1 shall be persons of outstanding ability, proven administrative capacity and integrity, possessing postgraduate degree in respective discipline from recognized university and having experience of not less than, kindly my lord,
Yes.
experience of having not less than 15 years in respective field, out of which at least 7 years shall be as leaders. In respondents 4 to 7 were all professors and were head of the department in the concerned colleges.
No, head of the department in that subject or college?
Colleges.
College again, head of the department.
My lord, in the college, for example, my lord, physics professor and head of the department is in respect of only physics department. The definition of a department is being prescribed by the rules, my lord. Your lordship may kindly come to page.
Now, for the purpose of section 19, leaders means head of the department.
Head of the department or the head of the organization.
Head of the department is enough.
No, head of the department means head of the department means it is equivalent to the principal of the college.
No.
Yes. My lord, that is what is the observation of this honorable court in the judgment, my lord, which was rendered. The issue was involved identical. Page 308, my lord. This is the. Your lordship may kindly come to page 317, my lord. Para 16.
317.
Yes, ma'am. This is judgment, my lord, which is affirmed by the Honorable Supreme Court, my lord, in the
17.
317.
317, yes.
Para 16, my lord.
Yes.
It is to be kept in mind that the National Commission for Homeopathy Act is essentially an enactment to create a medical education system and to provide adequate high quality homeopathy professionals in all parts of the country, and therefore the term head of the department or the term head of the organization would have to be necessarily mean that they should have headed a department in a homeopathic unit or should have headed an organization which dealt with the homeopathy or its education. It is well settled that at the time of enacting the law itself, if the legislature foresaw that the use of particular expression would lead to a misunderstanding, misconstruction or an ambiguity, in order to address that issue and ensure that the confusion, if any, should resolve, the legislative commonly adopted legislative device appending an explanation to the provision. Viewed from this background, it is clear that the legislature was aware that the use of expression leader would lead to varied construction in differing contexts and would probably lead to people astray, and therefore it appended an explanation which means clear that the leader would mean a person who was either head of the department or head of the organization. Now, my lord, coming to the conclusion with regard to the concerned person, my lord, that is the, your lordship may kindly come to page 325, my lord.
Yes.
The concerned person had worked as a principal, my lord, from 1/5/2018 to 1/5/2019. Your lordship will get it at page 325, my lord.
325, yes.
My lord, principal 1/5/2018 to 1/5/2019 of a Kottayam College. My lord, your lordship may kindly see page 327. First paragraph, my lord. I'm reading from 327, my lord.
Yes.
Previous paragraph from the top, my lord.
Yes.
It is clear from the above that Dr. Janardhan Nair was an officer in charge and the assistant director and principal from 2012 to 2019.
Yes.
Lordship got it.
Yes.
Which would indicate that he was a principal for 7 years. Since by virtue of being principal, he was head of the organization, it is clear that he possessed the necessary qualification to be considered as a leader for the purpose of the act. So therefore, my lord, head of the department in a college cannot be termed as a head of a leader. For this reason, my lord, under an RTI, my lord, when I submitted an application, the definition of department was also, my lord, Lordship will get it at page 284, my lord.
Take that notice.
Lord.
Who is that council?
Standing counsel for the union, my lord, is first respondent.
Yes.
First and second respondent, I think, even third respondent also.
Minister of Ayush. Who has taken notice in last occasion? That judgment.
ASG had appeared, learned ASG had appeared.
Yes.
Shanti Bhushan, I think, my lord. Will.
Yes. Deputy Solicitor General Shanti Bhushan is directed to take notice for 1 to 3. Council issue emergent notice to 4 to 7. In addition, petitioner is permitted to take out hand summons. Yes, you serve a copy to that.
Let the selection be subject to pending writ petition.
No, they have already selected. Why do you want that?
That has to go.
If the writ petition is allowed.
In the last occasion, what happened, my lord, 2021, immediately I approached this honorable court, my
Selection
lord.
of respondent number 4 to 7 is subject to the result of this writ petition. Yes.
Cell number 12, Manjunath H.
Yes.
Petitioner. The judicial officer relieved on 1/3 with effect from 2/3/2025.
Yes.
So as of now, she's 66 years. Madam.
Yes.
Relieving letter at page 27, Annex C. Madam.
Yes. Learned senior counsel appearing for the. This is within that this thing.
Yes, ma'am. Another 1 year is there.
Yes.
1 year, 1 month is there.
Learned senior counsel appearing for the petitioner submitted that in identical matter. Where is that?
Annex J, my lord, at
page.
Annex H, page 128, my lord, 128.
Directed the respondent to permit the petitioner to continue as a, is the president or member?
Member, my lord, member.
Member of district consumer redressal.
My lord, president of the district consumer, in the first matter, it was, this is president of district consumer, my lord. She was a president of the district urban, Bangalore urban.
Yes, now the
Now,
president.
it is a member.
Who?
This.
No, she is a president. She retired as a president. If your appointment letter, if your lordship may kindly look at,
Yes.
she was, or the, even the relieving letter at Annexure C, M. Shobha Adhyaksharu, Bengaluru Nagara, Erdane Appara Jilla.
Yes.
67.
Yes.
67.
President District Consumer Redressal Commission in the same place from which they were relieved. In view of the above, in view of the parity, the respondent, who has to consider? Respondent number 1 and 2.
Please.
Is directed to continue the petitioner as a president of District Consumer Dispute Redressal Commission in the same place from which they were relieved until further orders or till that recruitment process is completed, whichever is earlier, subject to the age limit
Or 67, as per section
prescribed
55.
under section 55 of the Consumer Protection Act 2019.
And the separate notification with respect to that is also passed by the state, central government itself. It's the
You
same
have to be passed now. In view of the interim order, you have to
Yes.
issue a notification. That's what the, yes.
My lord, in the past hour matter also,
Who is, you are appearing for state. Government advocate is directed to take notice for respondent number 1 and 2. Issue emergent notice to respondent number 3, directed to serve 2 sets of copies on government. What about that
My
passed?
lord, first
That
matter
passed
also
over,
same-
actually 66. Yeah, he's 66. He was relieved on 9/1/2025
Now
for
it's-
attaining age of 65 years.
Maybe that, the same order may be
Same
passed
order.
in
Same
that.
order.
Please.
They will consider. A time frame may be fixed, my lord, for that.
What is that for time frame?
Continue.
Yes, it will continued until new recruitment is taken place or subject to the age limit under this,
Much.
whichever is earlier.
Same.
Lord, item number 9 or
Item number 9 also same.
9 also same.
Same order.
8 and 12, 8 and 12, my lord.
8 and 12.
8 and 12.
Yes.
Another one, madam.
And 22 also, my lord.
22 also within that time.
Please, my lord, within the time, my lord.
No, 22, there is an office
My
objection.
lord, that is typed copy of the representation, which is already, it's
Complaint.
there. Please,
We'll see, we'll see.
Please.
You ask your colleagues to be there.
please,
Yes.
oblige.
Yeah, for orders, seal number 13, Ramananda AD for petitioner.
Lordship, in this case, your lordship had, the respondent had made accusation against the presiding officer of this court. Your lordship had transferred this to on 7/1/2026. It is thereafter was, the matter was heard before that court and there was NBW also, and it is inadvertently now listed
Yes, learned counsel for the petitioner submits that.
on 7/1/20.
Office inadvertently has posed this matter before this court. Submission is taken on record. Office is directed to post this matter.
And
before
moreover,
appropriate.
they have to pay the amount by this undertaking. There was NBW was recalled.
No, let it be there before that.
It may be listed tomorrow.
No, the office will verify and list that. You move the matter before that.
Allah,
court.
your lordship may kindly see, there is
Is there
a.
any date given today?
Date was given today. Given matter. Because they have to comply, they are given only.
On record, release this petition on 4th. Yes. Posted, directed to post this matter day after tomorrow before that appropriate bench.
As per the earlier order dated, your lordship had passed the earlier
No, let us see that, yes.
7/1/2020.
No, they have given a date to post today, maybe office by mistake, service matter.
Because your lordship had directed to be listed
Yes.
before.
Cell number 14, Sharath S. Gowda for petitioner.
But,
Government advocate.
This matter, your lordship will kindly recollect.
Yes.
Absorption under the municipality rules, your lordship was about to allow, seeing that's covered by judgment. Amendment application ಅಲ್ಲಿ ಕೆಲವೊಂದು documents ಹಾಕಿದ್ರೆ amendment application formal ಆಗಿ allow ಆಗಿರ್ಲಿಲ್ಲ. Amendment petition is filed. Physically carrying out, my lords, it's ready, we'll just stitch it to the papers.
Yes.
My lords, this matter, the petitioner was appointed as junior engineer, my lords. On, my lords, 12/12/1996.
Yes,
in
ready,
the-
Mr. Government.
My lord, the first prayer is concerned, my lord, we have considered the representation in accordance with law. The second prayer is concerned, my lord.
What is the second prayer?
First prayer consider agdale, without considering first prayer, my lord. The second, he cannot seek second prayer.
What is that for the read prayer?
Issue it, the first prayer, my lord.
ಅಲ್ಲ ಇವಾಗ ಅದು ಎರಡು ಬರಲ್ಲ my lords, third prayer consider ಆಗ್ಬೇಕಾಗತ್ತೆ. There is covered by judgment.
Respondent authority to consider the petitioners as a.
ಅಲ್ಲ for E, prayer at annexure E will have to be considered.
Observe the petitioner under the rule 5.
2000 with effect from so and so and as,
so on.
ಅದ್ರ ಪ್ರಕಾರ judgment ಇದೆ. I'll just part 2 minutes, my lords, your lordship.
Now, where is that judgment covered?
My lords, along with the amendment application, my lords, and filed under order 6 rule 17 on 17/1/2026. 17/1/2026.
My lord, one submission, my lord. My lord, in annexure J, my lord, this order dated, the communication dated 2/3/2010, my lord. It's a old record is pending, my lord. So we are searching for the old records, my lord. After
you
this
do-
order, my lord,
Now that today, why it is posted?
orders, my lord.
ಅಲ್ಲ my lords, ಇದು
Carried out in that, yes, you. carried out
amendment
the-
petition is already filed, my lords.
Leave this matter in B group.
Please.
You will hear and dispose of.
Please.
Yes, when do you want?
Next week, any dates?
ಅಲ್ಲ ಅವರು ಹೇಳ್ತಿರೋದು ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ರೆಕಮೆಂಡೇಶನ್ ಕಳಿಸಿದ್ದಾರೆ, ಡೈರೆಕ್ಟರೇಟ್ ಆಫ್ ಮುನ್ಸಿಪಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ. ಇಬ್ರು ಸ್ಟೇಟ್ ಏನೆ.
B group, yes. Leave this matter on 17th. Yes, B group, yes.
Till number
My lords,
15.
request for the file, my lords, to carry out amendment
Permitted
physically
to
also.
carry out that amendment. You
No.
carry out, yes.
No, the
15,
file
K.
is fixed.
Srikanti
Office objection, Mr. Office objection. There are 3 office objections, Mr. Gowda. Pass on.
Serial number 16, SB Mukkanappa for petitioner.
Non-amendment
My lord,
not carried out.
amendment petition has filed along with annexes, my lord.
Hmm.
Kindly consider.
You do carried out in that.
Matters, kindly pass.
Pass on.
Serial number 17, yes, Vidya.
17, my lord, undertake to file wakalat for R3 and R4, my lord.
Yes. Yes, so and so is undertake to appear for respondent number 3 and 4. Yes.
Appearing for respondent number 2, ma'am.
You are appearing for
Respondent number 2.
2, it is there, your name is there.
Yes.
Yes. Then what you want? Yes, madam, let
My
him.
lord, date for hearing.
My lord is very, rule is very much clear, my lord. The rule says that the mother has to consent to the which children should be selected
lord,
for
no.
compassionate ground.
Date may be given, senior will argue. my lord.
Yes. At the request of the parties, leave this matter of 2 weeks in B group. Yes.
Date may be given.
Date may be given.
Yes, 25th. Yes.
No, my lord, 27th.
No, today itself is ready. He is ready, you are not ready. Yes. 27th you want?
Please, my lord.
27th, no, 26th or 2nd March?
2nd March, my lord.
2nd March.
Please.
Yes.
Serial number 18, 19 adjourned. Serial number 20, Srikanth MP for petitioner.
Yes, week's time is granted to comply of subjection.
Serial number 21 adjourned. Serial number 22, Manjunath H.
Weeks, huh? Adaitala. Complaints.
Serial number 20, lordship.
Hmm.
Apply now only.
No, if you are urgency, today I will hear that. Otherwise, if you want time, I will grant it. What you want? Yeah. 2 days. 2 days time is granted to comply of subjection. Leave this matter on 10th. Yes.
Serial number 22, Manjunath H.
What is complaint?
That is eligible copies of the living letter, my lord, it's ready.
Eligible copy of the annexure A to be filed. Yes.
It's filed, my lord.
Learned Council has filed an eligible copy of annexure A. Hence, his objection is overruled.
Please.
Same order.
Same order.
Same order. Page.
Annexure relieving letter, that is in charge, Mr. Appointment again.
Page 18.
ಬೇರೆಯವರು charge ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
No, what
That's
is
the
this?
in charge position. Appointments have not happened. In charge.
Where is that?
It's at annexure C, my lord, page 18, which is a typed copy which has been given.
Pudi. Typed copy ಎಲ್ಲಿದೆ?
Annexure C at page 4, my lord.
Yes. ನಾರಾಯಣಪ್ಪ ಅಧ್ಯಕ್ಷರು ಅನ್ಯ ಕರ್ತವ್ಯ
ಪರ್ಯಾಯ ವ್ಯವಸ್ಥೆ ಮಾಡಲಾಗಿದೆ. ಮುಂದುವರೆದ ಮಿಲಡ್ ಪ್ಯಾರಾ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಇನ್ ದ ಫಸ್ಟ್ ಪೇಜ್ ಮುಂದುವರೆದು ಗ್ರಾಹಕರ ಸೋ ಮಾದರಿ ನಿಯಮಗಳ ಆಯೋಗದ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಅಪರಾಹ್ನದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಿರಿಯ ಸದಸ್ಯರಾದ ಶ್ರೀಮತಿ ಶರಾವತಿ ಅವರನ್ನು ಅಧ್ಯಕ್ಷರ ಹುದ್ದೆಯ ಕಾರ್ಯವನ್ನು ನಿರ್ವಹಿಸಲು ಪರ್ಯಾಯ ವ್ಯವಸ್ಥೆ.
Additional charge ಕೊಟ್ಟಿದ್ದೀರಾ?
Additional charge
Now
ಕೊಟ್ಟಿದ್ದಾರೆ.
she has to go back to her membership. Yes.
Please, oblige.
You have not appointed anybody to that post. It is only additional charge. As a member, she has been given additional charge.
Your lordship, ಅದು serial number 20 ಅಲ್ಲಿ ನಾನು ಆಗಲೇ 20 ಅಡ್ಜರ್ನ್ ಆಗಿದೆ 2 weeks ಗೆ, ಅದು 10 ಗೆ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೆ. serial number 20 ಅಲ್ಲಿ ನಾನು ಅಪಿಯರ್ ಆಗಲಿಲ್ಲ.
10th ಅಂತ ಹೇಳಿದ್ವಲ್ಲ.
Please.
10th.
Hearing interlocutory application matter, serial number 23, Venugopal MS for petitioner.
Lords, appearing for petitioners, my lord. I'm filing a memo, my lord, praying to dismiss the writ petition is not pressed, my lord. Insofar as all the petitioners are concerned.
I pay for respondent number 1, no objections, my lord.
Yes. Counsel for the petitioner has filed a memo. Pressed to dismiss that writ petition as not pressed. Memo is taken on record. The writ petitions are dismissed as not pressed.
Much obliged.
Pending applications.
All pending applications are disposed of.
Serial number 24, Ganapati.
It is time for the petitioner. This is seeking the family pension matter. Therefore, the writ petition is for direction to the respondent to release the family pension matter.
What is this matter?
In this case, what happened? This is the petitioner is the wife of late Vardasiddhayya.
Where he was working?
He is working in Vandoor sheep breeding farm at Malavalli. Earlier, there was a dispute between the
sheep breeding farm. Yenidu deputy director of horticulture. Yav department re?
The animal husbandry. Animal husbandry.
Animal husbandry.
Next year, siege my representation matter. Even after filing the writ petition also, they have issued a notice dated 21/12/2023. Our family records called family pension release ಮಾಡ್ತೀವಿ ಅಂತ ಹಾಕಿದ್ದಾರೆ. Annexure J have produced the letter given by the respondents. Annexure J additional document ಇದಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
I filed on 3/3/2025 on the application for direction ಅಂತ ಹಾಕಿದ್ದಾರೆ.
Annexure J ನಾ?
ಅದಕ್ಕೆ J ಇದೆ. With reference to the subject stated above, I am
account officer, deputy director of treasury Mandya. ಏನಂತ ಹಾಕಿದ್ದಾರೆ?
ಅವರು ಫ್ಯಾಮಿಲಿ ಸರ್ವಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ಸ್ ಅನ್ನ ನಾವು ಸಬ್ಮಿಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಸಬ್ಮಿಟ್ ಮಾಡ್ರೆ ನಾವು ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ ಅಂತ
return to this office with that has PPO number issued since pensioners and family pensions have expired. Respectively duly noting the date of the last pension paid on the receipt of which family pension will be authorized to Srimati, wife of Siddharthya, as per the court order and executive order of the department. Yena yav court order?
That is annexure. I have put annexure. Annexure A, madam.
Annexure A.
Yes. This is the miscellaneous application, pending applications filed by the petitioner.
Now that deputy director of treasury Mandya, who is appearing? Aurna yakre party madam, deputy director of. Now why that accountant general office? Yes, Mr.
Yes, sir.
He is a competent authority.
ಅವ್ರ ಲೆಟರ್ ಬರ್ದಿದ್ದಾರಲ್ರಿ 2023 ಕೆಳಗಡೆ ಅವ್ರ ಹಸ್ಬೆಂಡ್ ತೀರೋದ್ಮೇಲೆ ಅವ್ರದ್ದು ವಿತ್ ಕಳ್ಸಿ ರೆಕಾರ್ಡ್ಸ್ ಕಳ್ಸಿ ವಿಲ್ ಗ್ರಾಂಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. But then why you are paying that pension, Mr.
My lord, he has not placed any material to show that she is a legally wedded wife, my lord.
ನೀವು annexure J ಕೊಟ್ಟಿದ್ದೀರಿ ಅನ್ರಿ ಕಾಪಿ ಅವರಿಗೆ? ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ತಗೊಂಡ್ ಬಂದಿದ್ದಾರ್ರಿ.
Annexure H and J.
Purpose of giving a family pension to for survival, Mr. 2-3 ವರ್ಷ ನೀವು ಇಟ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ.
Consider in accordance with law.
No, not accordance with law. What is that they have to send in a records, Mr. What is that relief you have sought, Mr. Annexure F ಏನ್ರಿ?
My request letter to release my pension.
ಅಲ್ರಿ ಏನು set aside ಕೇಳಿದಿರಲ್ಲ ಏನ್ರಿ F?
ಅವ್ರು ನಮ್ಗೆ ಅರ್ಲಿಯರ್ ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ ದಿ ಇದು ಕೊಟ್ಟಿದ್ರು ಮೊದಲ ಅವರು ನಮಗೇನ್ ಮಾಡೋದನ್ನ
F ಎಲ್ಲಿದೆ?
F is a family pension calculation by the accountant general office. Annexure page number 27.
Page number 32, my lord.
ಏನಿದು F ಏನಿದು? Why you sought for quashing this, Mr.
ಒಂದ್ ಲೈನ್ ಇದೆಯಲ್ಲ 6 ಲೈನ್ ಕೊಡಕ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು ಅದು ನಾಮಿನೇಷನ್ ಸಬ್ಮಿಟ್ ಮಾಡಲ್ಲ.
ಯಾವ್ದು ಲೈನ್?
ರಿಟರ್ನ್ ಮಾಡಿದ್ರು. Annexure F ಅಲ್ಲಿ ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ ಆಫೀಸ್ ಲೆಟರ್ ಅಲ್ಲಿ.
ವಿಚ್ ಪೇಜ್ ಮಿಸ್ಟರ್? ಆ 4 ಪೇಜ್ ಇದೆ ಯಾವ್ದು ಹೇಳ್ರಿ?
27 ಒರಿಜಿನಲ್ ಫಸ್ಟ್.
27 ಅಲ್ಲಿ ಏನು? 27 ಅಲ್ಲಿ F ಅಲ್ಲ, F ಇರೋದು 28 ಅಲ್ಲಿ ಇದೆಯಲ್ಲ.
In all the nomination list of family members, joint family photos ಅಲ್ಲಿ ಮೊದಲ ಸೆಕೆಂಡ್ ವೈಫ್ ಫಿಫ್ತ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು ಪೆಂಡಿಂಗ್ ಇಟ್ಟಿದೆ.
ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ?
Annexure F ಅಲ್ಲಿ.
F, which is that?
My lord, in respect of annexure A, F is concerned, Does not place any material to show the.
ಸ್ವಲ್ಪ ನನ್ನ ಕೇಸ್ ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿದ್ದೇನೆ. ಎಲ್ಲಪ್ಪ here with enclosed ಎಲ್ಲಿ ರೈಟಿಂಗ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ?
In all the nomination list of family.
In all the nomination list of the family members.
Photo forwarded by the
Giant
DDO, white
photo
letter
forwarded
so-and-so.
by the DDO, white.
In his office,
department,
name of
letter
the
dated
wife of
so-and-so
Srimati
received in
Siddhamma.
his office. The name of
And
the wife of
accordingly, the
Siddhamma.
PF was not provided.
And accordingly, PF was provided to her. Hence that entire process, paper sent, enclosed and written. ಏನಕ್ಕಂತ ಅದು written?
Because Siddhamma was claiming that she was the wife of deceased person.
She is paying, and now they are paying to that Siddhamma.
Not yet, but she also died, my lord. Before the death of the employee.
Who are you?
I am the first wife.
Now that, do you have obtained the decree?
As per the annexure A, the petition, my lord, filed by the petitioner seeking maintenance. Here itself, there was an issue saying that I am the first wife and declare. Now the accountant general and saying that ಈ ಡಿಗ್ರಿ ಜೊತೆಗೆ ಸರ್ವಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಮೇಲೆ ನಾವು ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾವು annexure J ಎಲ್ಲಿದೆ ಅದು? This is issued on 2019. Now that with reference to that subject stated above, to requested you to return to this office with that house PPA issued to that Dodda Siddhaya since pensioner, family pensioner have expired, so and so respectively, duly noticing the date of the pension paid on the receipt which may family pension be authorized to Srimati, so and so. Now there is in a letter.
Yes.
Now this squashing of annexure F would not arise
because they themselves admitted that a service particular submit ಮಾಡಿದ್ರೆ ರಿಲೀಸ್ ಮಾಡ್ತೀವಿ ಅಂತ.
Now what is your second prayer?
Second prayer is direction to consider.
Issue mandamus to respondent to consider that representation. ಎಲ್ಲಿದೆ ನಿಮ್ಮ representation?
Annexure. Annexure G,
Yes.
by way of notice ಮಾಡಿದ್ವಿ.
Yes, learned counsel for the petitioner has submitted that. Petitioner will not press prayer A. He sought only mandamus directing the respondent to consider the representation annexure E for payment of family pension. The case of the petitioner that petitioner is the legally wedded wife of Dodda Siddhaya. Her husband Dodda Siddhaya was working as what, Mr.?
Driver.
Driver in?
Driver in the first respondent office.
Yeah, was working as a driver in first respondent office.
He reached the superannuation on 30th of April 2002.
He retired on superannuation on 30th
April 2002.
30th April 2002. Thereafter, he was receiving a pension.
Yes, ma'am.
When he was died?
He died on 26/12/2014.
He died on 26/12.
2014.
2014. Petitioner is a legally wedded wife of the deceased Dodda Siddhaya, has filed an application for payment of family pension. In the meantime, what is her name?
Her name is Siddhamma.
One Siddhamma was also claiming that wife of the deceased Dodda Siddhaya. Wide annexure F 58/2019. The second respondent has issued has written that application submitted by petitioner for family pension. The learned counsel for the petitioner submitted that Siddhamma was not a legally wedded wife of the deceased Dodda Siddhaya. And also now that Siddhama is no more.
Yes, ma'am.
No more. And the petitioner has obtained degree from the civil court for
Maintenance.
in maintenance petition, wherein it was declared that petitioner is the legally wedded wife of the deceased Dodda Siddhaya. Wide annexure A. Thereafter, the second respondent has issued a communication. Wide annexure J.
Annexure F.
Annexure J dated 20th/12/2023. A senior accountant officer has written a letter to Deputy Director of Treasury Mandya to order of the department. Pension to the family pension with the authorization of the amount.
Even annexure H also is same contention.
N.
Annexure H issued by the accounts officer.
Yes, has written a letter to both have PF so and so, whichever such as so and so, duly noting the date of the last pension paid and as per the
Last line with me annexure in HL.
written a letter. Avnen permission kelidara, seeking a permission for executing that court order. Thereafter, no action has been taken. Therefore, petitioner is before this court, seeking mandamus. Learned government advocate appearing for the state has submitted that if the petitioner submit fresh representation enclosing the communication wide annexure H and J, na?
Yes, ma'am.
H and J, and all relevant records to the respondent number 1 and 2, the petitioner case will be considered in accordance with in view of the above. Without expressing any opinion on the merit of the case, the liberty is reserved to the petitioner to submit fresh representation enclosing that communication dated 21/12/2023 annexure H and communication dated 20th/12/2023 annexure J and other relevant records to respondent number 1 and 2 within how many days you will do it?
Within after getting the certificate copy immediately.
Within 2 weeks from date of receipt of the copy of this order. The respondents 1 and 2 is directed to consider that case of the petitioner within 2 months from date of receipt of that representation, additional representation. Yes. All pending applications are disposed of.
Serial number 25, Alesha R. Gavimat.
My lord, for a petitioner made application for appointment of Anganwadi Karyakarta. Her name has been shown in the preliminary selection list, my lord. At serial number 4, page annexure E, page 20 in the petition. My lord, during the pendency, notice has been directed to the respondent, and before the open court, I have served the copy to the government advocate. My lord. During the pendency of the petition, my lord, the respondent has issued the second temporary selection list, in which, my lord, my name is not shown and different person name has been shown.
No, in the first list you are there.
I am the only person selected.
Oh, what is your name?
My lord, serial number 4, my lord,
Rekha MS.
Rekha MS. Only ನಾನು ರಿಟ್ ಪಿಟಿಷನ್ ಏನಕ್ಕೆ ಹಾಕಿದೆ ಅಂದ್ರೆ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ನಾಲ್ಕು ಸೆಲೆಕ್ಷನ್ ಮಾಡಿದ್ರು ನವೆಂಬರ್ ಬಂದ್ರು ನಂಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಡ್ಲಿಲ್ಲ.
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಈಗ ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇರುವಾಗ ಒಬ್ರು ಮಮತಾ ಅಂತ ಅವ್ರನ್ನ ಸೆಲೆಕ್ಷನ್ ಟೆಂಪರರಿ ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್ ಅಂತ ಮಾಡಿ ಅನೌನ್ಸ್ ಮಾಡಿ ಪಬ್ಲಿಷ್ ಮಾಡಿ.
ಎಲ್ಲಿದೆ ಅದು ಲಿಸ್ಟ್?
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ 1 ಜೊತೆ ಹಾಕಿದೀನಿ ಸರ್. IA 1 ಜೊತೆ ಪೇಜ್ 8.
IA 1 of 26.
House.
IA 1 of 26 ಇಲ್ಲ.
Page 8 J1.
ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದೀರಾ? 2 ನ 1?
My lord, sorry, my lord, 2 ನಲ್ಲಿ ಹಾಕಿದೆ sir.
Page?
Page 8, annexure J1 ಮೇಲೆ. ಅಲ್ಲಿ ಫಸ್ಟ್ನೇದು ಮೇಲೆ ಮಮತಾ ಅಂತ. ಇದು ಆಕ್ಚುಲಿ ಫಸ್ಟ್ ಅವರ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆಗಿತ್ತು ಇವ್ರದ್ದು. ನಾನು ಐ ಆಮ್ ದಿ ಓನ್ಲಿ ಪರ್ಸನ್ ಟು ಸೆಲೆಕ್ಟೆಡ್ ಇನ್ ಅಂಡ್ ಶೋನ್ ಮೈ ನೇಮ್ ಇನ್ ದಿ ಟೆಂಪರರಿ ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್. ಈಗ ನೋಡಿದ್ರೆ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ದೇ ಹ್ಯಾವ್ ಚೇಂಜ್ಡ್ ಎಂಟೈರ್.
ದೂತನ ಕೊಪ್ಪಳಿಗೆ ಅಂಗನವಾಡಿ ಟೀಚರ್ ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ವಿ. ದ ಪೆಟಿಷನರ್ ಹಿಯರಿನ್ ಈಸ್ ದ ಪರ್ಮನೆಂಟ್ ರೆಸಿಡೆಂಟ್ ಆಫ್ ಘಟ್ಟದಹಳ್ಳಿ ವಿಲೇಜ್ and the selected person Mamata is a permanent resident of ದೂತನ ಕೊಪ್ಪಳು.
ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಾ?
ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರೋದ್ರಿಂದ ಏನೋ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಿಂತೋಗಿತ್ತು. ಅದ್ರ ಮೇಲ್ಗಡೆ ಅದನ್ನ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಮೇಲೆ 1 ಕಿಲೋಮೀಟರ್ ಇದೆ. ಐ ಆಮ್ ಆಲ್ಸೋ ಲೋಕಲ್. ಅದೇ ನಾನು ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಪೇಜ್ 20 ತೋರಿಸಿದಲ್ಲ. ಆದ್ರೆ ಸೆಲೆಕ್ಷನ್ ಮೇಡ್ ಓನ್ಲಿ ಸ್ಥಳೀಯರು ಅನ್ನೋ ಗ್ರೌಂಡ್ ಮೇಲೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಸರ್ಟಿಫಿಕೇಟ್ 1 ವರ್ಷದಿಂದ ಇದೀನಿ ಅಂತಾನು ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದನ್ನ ಅನೆಕ್ಷರ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ನಾನು ಪೇಜ್ ನಂಬರ್ ಇನ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಈಗ ಅನೆಕ್ಷರ್ K1 ಅಲ್ಲಿ ಹಾಕಿದಿಲ್ಲ ಸ್ವಾಮಿ. 6 ತಿಂಗಳಿಂದ ವಾಸ ಆಗಿದ್ದಾರೆ ಅವರು. ಈಗ ಏನ್ ಸೆಲೆಕ್ಟ್ ಮಾಡಿದಾರ ಅವ್ರ ಸರ್ಟಿಫಿಕೇಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅವರಿಗೆ ತೋರಿಸಿದ್ದಾರೆ.
Now, when that application has been called?
My lord, the page number 10 of the.
Where is her certificate to show that she is?
ಆಮೇಲೆ II 2 ನಲ್ಲಿ ಹಾಕಿದೀನಿ. ಪೇಜ್ 10 ನಲ್ಲಿ ಹಾಕಿದೀನಿ ನೋಡಿ ಸರ್. ಅದರಲ್ಲಿ 6 ತಿಂಗಳಿಂದ ಹೆಚ್ಚು ಅಂತ ಲಾಸ್ಟದಲ್ಲಿ.
ಯಾವತ್ತು ಇಶ್ಯೂ ಮಾಡಿರೋದು?
21 ನಲ್ಲಿ
ಸ್ವಾಮಿ 23/2025
23 5/10/2021
21 ನಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
21 ಇಟ್ಸ್ ಎ ಪ್ರಿಂಟೆಡ್
21
ನಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಪ್ರಿಂಟ್ ತಗೊಂಡು
5/10/2021 ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಪ್ರಿಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಮರುಮುದ್ರಣ ಅದಷ್ಟೇ. 21ರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಕ್ಕಿಂತ ಮುಂಚೆ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು.
ಹೌದು.
Authority itself says she is last 6 months in ವಾಸ ಆಗಿದ್ದಾರೆ ಅಂತ.
ಅಲ್ಲ,
ಇದು ಹಾಕಿರೋದು ಅಪ್ಲಿಕೇಶನ್ at the time of the along with the application.
Along with that application it is there.
But along with the application in online application is not in proper in as per the stipulated form. It was rejected ಮೇಲ. Therefore ಅದನ್ನ ಅದನ್ನ ತೋರಿಸಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ನನ್ನ ಟೆಂಪರರಿ ಸೆಲೆಕ್ಷನ್ issued at the first time.
Records will implement them also.
Page 20 ಅಲ್ಲಿ ನನ್ನ ಒಬ್ಬಂದೇ ಸೆಲೆಕ್ಷನ್ ಮಾಡಿ
ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ?
ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ. IML ನಾನು ತಗೋತೀನಿ ಇಂಪ್ಲಿಮೆಂಟಿಂಗ್ ಮೇಲೆ. Am I permitted to take
notice? ಹೋಗಿಲ್ಲ IML.
ಹೋಗಿಲ್ಲ.
IML ಹೋಗಿಲ್ಲ. ಫಸ್ಟ್ ಟೈಮ್
yes
posted
issue notice on IA 1 and 2 of 2026 on implementing applicants.
My lord, any proceedings taken place at the appointment issue ಮಾಡ್ಬಿಟ್ರೆ entire my proceed ಇದು
already issued
appointment order issue ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು. Appointment is subject to the result of this writ petition. Appointment of implementing applicants. What is her name? Mamata is subject to the result of this writ petition.
Please.
Cell number 26, Prasanna VR for petitioner.
Petitioner
for petitioner, connected matter, Ajay Jayan.
Beg to appear for the petitioner. Second matter.
Yes. So Prithvish had told me that he wants it at 2:30 as well.
It can be taken up at 2:30.
He had told me we are UPCL. This is that my lord said. No, my lords, that is a completely different issue. 26 is a complete. This is a different. This is on examination, my lords.
This will continue. Start arguing. One matter is taken, other matter will not be. Therefore,
I will make my submissions.
Whatever that matter will start, they have a chance to be continue at 2:30. Yes,
I will make my submission, my lord. My second matter may be taken up, my lord. WP number, third matter, WP number 953 of 26. My lord. With kind permission.
953.
Yes, ma'am. Kind permission, my lord, I may permitted to file the synopsis list of dates and my lord, the brief submissions.
Yes.
So that I can finish it as early as possible.
Yes.
My lord, I have raised two main contentions, my lord.
Yes.
Regarding Kannada examination. And secondly, my lord, the Hyderabad Karnataka reservation issue, my lord. Hyderabad Karnataka reservation point,
Yes.
which they have altered during the process, my lord, and the how examination which is conducted in the Kannada paper, my lord, is impermissible according to us, my lord, for the petitioners, my lord.
No, that, where is Prithvi? You have raised, what is the ground?
I have raised, first ground is on the minimum marks. Whether minimum qualifying marks must have been set, and in that, whether relaxation should be given to the scheduled caste, scheduled marginal.
First, let him argue. If he succeed, the entire notification is goes.
Yes.
How the Kannada, other why should I hear and have it in that mind? Let him first. If he convinced
Yes, ma'am.
in that point, then entire notification will go. If he fails, then we'll go to that next point.
Yes.
Whether that examination is conducting or not. Why do you want to go to that yours is?
Even in our case also, my lord, they cannot hold Kannada examination itself. That is our contention. Even that, if that is all, my case is also allowed, even the entire process, as far as the holding of Kannada examination is concerned, that will be, that will be cancelled. Whatever is relating to the technical papers, that will remain intact, my lord. Only they have to conduct Kannada examination.
No, but he is arguing that the entire, if it is succeed, entire notification has to go, Mr.
Yes.
Then yours at least
My-
part of that,
my-
they can go ahead with that without Kannada examination.
That is the point, my lord.
That is for
They can, but
yours is that part of the notification has to go.
Yes.
He is arguing that entire notification has to go.
Yes, ma'am.
I will hear first.
Yes, ma'am.
I don't want to waste.
Why?
If he
Because,
is
my lord,
if
why?
his case is out, then
Yes.
I will come to your
Yes.
case whether.
I am in the top of the list. What I'm trying to say is my technical examination result has to be intact. I'm only challenging the holding of the Kannada examination because it is affecting me in the manner in which they are conducting. I'm not at all challenging the entire.
He is challenging.
He is challenging, my lord. If he succeeds, my lord, yes. And even this issue has to be decided because they cannot hold even if he succeeds.
If he fails.
Yes. Yes.
Then I will come to your case.
Please,
Yes.
my.
Otherwise, unnecessary hearing.
Yes.
Suppose if he succeed.
Yes.
If said that no, you do it fresh notification.
Yes.
Then you have also satisfied that.
Yes, and my point has to be answered because they cannot hold Kannada examination. Once again.
Again, if they issued a Kannada examination, then you can. Come.
Yes, ma'am. Yes, ma'am. Grateful.
Yes. Now, which is that matter we want to argue?
3909 for the first one, my lord.
First one.
Yes, your lord.
Yes.
Let's, if learned AG is appearing, my lord, that is convenience, I can argue, subject to your lordship's convenience.
By the time he will come now. He's coming.
My lord,
today.
I spoke, message the AG, he had
He is
informed.
ready today. Because
My
of
lord,
you or urgency only, I am
Yes,
taking
yes,
that
yes.
matter.
My lord,
Otherwise-
my lord, let him argue the matter. My lord, we'll reply by afternoon or by tomorrow, my lord. Depending on if he makes any additional points, I'll
Very well.
reply. Let him-
No, it's better.
Yes, my lord.
I don't
One
want to
shot.
make
If it
it
can be at
parted by
2:30,
so
my
many
lord.
matters. One stretch.
Yes, if it can
But
be
we
at
can it be at
2:30.
2:30, my lords, because Prithvish had informed us yesterday. So based on that, my lord, then today morning, PS Rajgopal sir called me and said, I have inconvenience, Ajay, my matter at 2:30. ಅವ್ರಿಗೂ ಇಲ್ಲ ಅನ್ನಕ್ಕಾಗ್ಲಿಲ್ಲ.
ಅವ್ರದ್ದು ಏನ್ matter ಅದು?
ಅವ್ರದ್ದು elevation scheme, Swami. That's an existing employees matter. That is affecting the promotions of the existing employees. This, my lords, is recruitment.
Then
So-
that is the different. That
That's
will
completely
take some other
completely
day.
different.
Which is that urgency for you? This is what you said Supreme Court has directed.
This is the one.
Then you will hear this first.
Very well.
Yes, you how much time you will require?
About 45 minutes. I can.
Yes, let us see.
Very
2:30 I will,
Yes.
you can continue.
Yes, sir.
Yes. You can inform that Rajgopal will take that matter in some other day.
Yes, I will.
We'll inform.
I'll
Yes.
inform. We'll inform.
Yes.
Let's, I'll just give the facts, my lord. First facts, my lord.
Yes.
My lord, Annexure B, page number 33.
Yes.
On 17/7/2017, my lord, the recruitment notification was issued. Page 33.
Yes.
Let's recruitment notification number reference is given, my lord.
Yes.
17/7. My lord, thereafter the number of posts varied, my lord. Therefore, we can take 3/8/2017, my lord. That's the date of recruitment notification, my lord.
Yes.
My lord, the recruitment notification was issued for various posts,
Yes.
including assistant engineer, electrical, civil, mechanical, junior engineers, chemist, chemical supervisor, so on and so forth.
Yes.
Let your lordships may see, my lords, the recruitment notification
Yes.
at page number 37, para 6, my lords.
Yes.
Selection procedure. Selection will be made purely on merit basis, duly following reservation policy. Merit list will be prepared based on marks obtained in the written test.
Yes.
Now, my lords, para 7, as to how the written test will be conducted, my lords.
Yes.
That they say, my lords, candidate may that the exam center will be in various places.
Yes.
That is Bangalore, Ballari, Shimoga, and we can indicate any 2 tests.
Yes.
Clause 8 is, my lords, Kannada language test, that they will have to pass the Kannada language test.
Yes.
If they have not, my lords, qualified in the Kannada, in SSLC or so on and so forth.
Yes.
My lords, this was the recruitment method, my lords, that was adopted.
Yes.
Recruitment examination, my lords, in terms of the recruitment notification was conducted for the first time, my lords, in the year 2018.
Yes.
My lords, that examination, my lords, came to be cancelled, which your lordships, my lords, would find annexure D, page 45.
Yes.
Let's the respondent corporation, my lords, on its own volition would cancel the recruitment process, my lords.
Yes.
This cancellation of the recruitment process, my lords, came to be challenged before your lordships, my lords, before a single bench, before a division bench. All of them failed. Ultimately, this honorable court also directed for redoing the examination process and upheld annexure D.
No, this is cancellation of
Yes,
examination.
21/1/2018. This is the first exam.
Return test held on so and so has been cancelled.
Yes.
Re-examination will be conducted. What is the reason for cancellation?
My lords, that there was various malpractice, so on and so forth.
It's they are voluntarily.
Yes, voluntarily cancelled.
Yes.
This was the first exam.
Yes.
And first cancellation is on 23/6/2018.
Yes. Yes.
Then comes annexure E, page number 46, my lords.
Yes.
My lords, under annexure E, page 46, KPCL would hand over, my lords, the process of conducting the examination to the Karnataka Examination Authority, KEA. That is annexure E, page number 46.
Yes.
My lords, pursuant to that, annexure H is the examination conducted by the Karnataka Examination Authority.
Yes.
That's the question booklet, my lords. Now, what happens at page 51, my lords?
Yes.
After the examination is conducted at page number 51, a paper publication is published saying that for every wrong answer, 1/3 negative marking is will be deducted from the score.
Yes.
That is annexed page 51.
Yes.
Annexure J.
Yes.
This the annexure J was put to challenge, my lords, before this honorable court at page number 59.
Yes. Yes.
My lords, some not these petitioners, my lords, some 2 persons, my lords, challenged the annexure J and the score, my lords, that was published based on the negative marking.
Yes.
My lords, learned single judge of this court, my lords, dismissed it on 2 counts, my lords.
Yes.
The first ground on which the writ petition stood rejected, which your lordships would find at paragraph number 7, my lords, page number 67.
Yes. Yes.
Page 67, para 7, my lords.
Yes.
The first contention, the first ground on which, my lords, the writ petition is rejected is in the 2018 examination, negative marking was notified. This is only a re-examination. Therefore, it is implied that the conditions of the earlier exam are followed here. That is the first.
Yes.
The second ground is para 10, my lords.
Yes.
Para 10, page 70 onwards.
Yes.
Learned single judge of this court would hold, my lords, that having participated in the examination, they rely upon the leading judgment Madan Lal, which is followed various months.
Yes.
Page 70. That having participated in the selection process, you can't challenge it. You can't turn around, having been unsuccessful. Therefore, my lords, on these 2 grounds, writ is dismissed.
Yes.
My lords, thereafter, writ appeal is preferred at page number 78.
Yes.
My lords, petitioner number 1 is one of the writ appellants, though he was not a writ petitioner.
Yes.
Along with IA for permission, writ appeal is filed.
Yes.
Page 78, appellant 2, my lords, is petitioner number 1 here.
Yes.
Writ appeal came to be filed, my lords.
Yes.
In the writ appeal, my lords, after hearing all the parties, this honorable court, my lords, I'll take your lordships directly, my lords, I'll take your lordships to the findings a little later. But ultimately, my lords, this honorable court, the operative portion is at page 124.
Yes.
My lords, in the meantime, my lords, during the pendency of the writ appeal,
Yes.
the selection process was underway. My lords, there was an understanding that they will not publish the final select list and issue appointment orders. Therefore, my lords, it was kept on hold. No appointment orders were issued. Final select list came to be issued at page 124, my lords.
Yes.
Writ appeals are allowed. Order of learned single judge in so and so are set aside. Notification bearing number so and so. The final score list dated 12/6 and the provisional score list 8/5/24 are quashed. Respondent number 1 to 3 are hereby directed to conduct a re-examination expeditiously and within reasonable time for all candidates appeared in examination of 24 pursuant to the notification dated 2017. Direction is to redo the exam for all the candidates who are appeared in 24.
Now,
The
what about that negative scoring?
They held that negative is bad. Next direction is that, my lords. The re-examination shall be conducted subject to the condition of negative marking, and such condition shall be expressly communicated to all candidates much before the examination.
Yes.
My lords, this order was put to challenge the order of the division bench.
Yes,
Directing re-examination was put to challenge at page 126, my lords.
Yes.
My lords, the contention before the Supreme Court, my lords, initially was that if negative marking is taken away, then the scores can be recalculated and whoever is eligible can be appointed. My lords, it appears that found favor with the Supreme Court at page 127, my lords.
Yes.
We are at para 5, my lords. We are added with the High Court on the question of law that negative marking could not have been introduced without letting the candidates know that an incorrect answer would lead to marks being deducted. If at all considered essential, the candidate should have been clearly made aware of it before the process. Be that as may, the direction contained in the operative part of the order for conducting re-examination would unnecessarily burden the public exchequer. Apart from time and effort being spent, it is also likely to affect the candidates who had taken the qualifying exam knowing fully well there would be no negative marking with serious consequences. In our considered prima facie view, interest of justice would be saved if re-evaluation, reassessment of the answer sheets of all candidates who had taken the qualifying exam earlier is undertaking without negative marking.
Yes.
Then, my lords, at page 129 on the next date of hearing, my lords, page 130.
Yes.
Para 1, my lords.
Yes.
See, so and so learned Advocate General for Karnataka appears for the respondent corporation and submits that the vacancies having remained unfilled since 2017 and to avoid heartburns amongst the candidate interested in employment, he requires some time to obtain instructions from the state as to how the concern could be addressed, which would necessarily include a decision taken at the level of the cabinet. Then, my lords, para 4. Having regard to the special, it would be desirable if the government as one-time measure proposes a closure of action ensuring to the benefit of candidates who participated in the process of selection as far as practicable. Now, the proposal was, my lords, to include both sets of candidates, my lords, with negative marking, without negative marking. Whoever is excluded, try and accommodate both so that it can. Then at page 131, my lords.
Yes.
My lords, ultimately, my lords, the Supreme Court, my lords, notwithstanding the earlier directions, my lord, at page 132,
Yes.
would dismiss while undertaking the recording at para 4. We record the submission of Mr. So-and-so learned additional so-and-so for the state of Karnataka that the retest shall be conducted within 4 months from the date of the order. Now, my lord, this was the order passed.
Yes.
My lord, in the meantime,
Yes.
the order of the division bench was pending in review, my lords, page 133.
Yes.
My lords, the review also ultimately came to be dismissed, my lords, on the ground that Supreme Court has also dismissed, and negative marking has not been seriously urged, page 138.
Yes.
Now, my lords, the review petition, the order in review petition at page 138,
Yes.
which starts, my lords, at page number 133, was again put to challenge before the Supreme Court.
What is that review order you are challenging? It has been.
Yes, my lords. The review, page 133, my lords, it
Yes.
starts. The petitioner in the petition your lordships are holding, my lords, since he was the appellant, he had filed a review, my lord, saying that re-examination is not necessary. At best, only recalculation of marks. Now, my lord, since those contentions were rejected, the division bench also rejected the review.
Yes.
And then, my lord, SLP was preferred against that order also, against the review, which came to be rejected, my lords, on 19/12/2025.
Yes.
Now, my lords, in the meantime, pursuant to the first order, the order of the division bench, my lords, the re-examination had to be conducted. Page number 31, Annexure A. This was the re-examination notification pursuant to the order of the division bench. Lord, your lordships will note, my lords, 27/12, 28/12 are the dates of the technical examinations. 28/12, last one, my lords, is the Kannada language examination. Now, my lords, page 32 are the instructions, my lords. Page 32,
Yes.
my lords, clause 4, my lords. ಸೂಚನೆಗಳಲ್ಲಿ ಕ್ಲಾಸ್ 4 ಮೇಲ್ಕಂಡ ಮರುಪರೀಕ್ಷೆ OMR ಮಾದರಿಯಲ್ಲಿ ಆಪ್ಟಿಕಲ್ ನಡೆಸಲಾಗುವುದು. ಅಧಿಸೂಚನೆಯನುಸಾರ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕನಿಷ್ಠ ಅಂಕಗಳನ್ನು ಗಳಿಸುವುದು ಕಡ್ಡಾಯವಾಗಿರುವುದಿಲ್ಲ. It is only this examination notification which made it clear that we will not prescribe the minimum marks.
Now, what was the negative scoring? How that they are doing negative scoring there?
Originally, there is in the recruitment notification, there is nothing about negative marking.
Anyhow, how they was doing earlier, negative scoring in that subsequent notification?
For every wrong answer, one third marks.
One
third. 0.3 marks, my lords, would get deducted.
Yes.
Now, my lords, in clause 5, they said, as per the recruitment notification, there will be no minimum marks prescribed. The recruitment notification did not prescribe anything. This notification, they said, my lords, that it is not mandatory to score minimum marks. My lords, I'll explain to your lordships, my lords, while I raise the content.
The directions of the Supreme Court is that
redo. There is no direction, my lords. The undertaking before the Supreme
it's kept open for everything, or only that
redo the entire test.
Yes.
That is, in fact, the direction of the division bench also is redo the examination.
Yes.
Now, my lords, clause 5, they specifically said no minimum marks. Clause 6, my lords, ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನವಿದ್ದು ಪ್ರತಿ ತಪ್ಪು ಉತ್ತರಕ್ಕೆ 1/0.3 ಅಂಕಗಳನ್ನು ಕಡಿತಗೊಳಿಸುವುದು. 1/3 marks will be deducted for every wrong answer.
That negative scoring is there.
Yes, my lords. Because there was a direction by the division bench to make it explicit. It was clause 7. ಪಾರದರ್ಶಕತೆಯ ಭಾಗವಾಗಿ ಉತ್ತರಿಸದೇ ಇರುವ ಪ್ರಶ್ನೆಗಳಿಗೆ 5ನೇ ಆಯ್ಕೆ ವೃತ್ತವನ್ನು ಶೇಡ್ ಮಾಡಲು ಕೊನೆಯ ಬೆಲ್ ಆದ ನಂತರ ಹೆಚ್ಚುವರಿಯಾಗಿ 5 ನಿಮಿಷವನ್ನು ನೀಡಲಾಗುವುದು. ಯಾವುದೇ ಆಯ್ಕೆಯನ್ನು ವೃತ್ತವನ್ನು ಶೇಡ್ ಮಾಡಿಲ್ಲದಿದ್ದರೆ ಪ್ರತಿ ಪ್ರಶ್ನೆಗೆ 1/3 ಅಂಕಗಳನ್ನು ಕಡಿತಗೊಳಿಸುವುದು. Not only is it for a wrong answer, even if I don't choose an answer, even if I don't mark anything, 1/3 marks will be deducted. Next, my lord.
All that you can't say that wrong. It is for all.
Yes, my lord. It is for all.
It cannot be that only for.
No, my lord. Not only for. It is for everybody, my lord.
Yes.
Clause 8. ಕನ್ನಡ ಭಾಷಾ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಅರ್ಹತೆ ಹೊಂದಲು ಅನ್ವಯಿಸುವ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಕನಿಷ್ಠ 35 ಅಂಕಗಳನ್ನು ಗಳಿಸುವುದು ಕಡ್ಡಾಯವಾಗಿರುತ್ತದೆ. Minimum marks, my lord, was prescribed for Kannada examination only. ಪರೀಕ್ಷೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ಜಿಲ್ಲಾ ಕೇಂದ್ರದಲ್ಲಿ ಮಾತ್ರ ನಡೆಸಲಾಗುವುದು. Now, my lord, this was put in challenge this is under challenge before your lordships, my lords. My lords, there are two other facts, my lords, which are not borne out in this writ, but in the connected writ. First is, my lords, after the re-examination before the single judge order here, my lords, the Kannada language test was challenged before the Gulbarga High Court, my lords. Where they prescribed the minimum marks after the examination. Therefore, my lords, the Gulbarga High Court, single bench of the Gulbarga High Court held, you can't do that. You have to prescribe it before. Now, my lords, there's an express direction there to prescribe the minimum marks before the examination is conducted, insofar as Kannada language examination is concerned.
Now they have prescribed.
That is why they have prescribed. Now, my lords, the second fact is, on 10/12/2024, my lords, 2025, they would publish a notification, my lords, that is in the connected writ petition, which your lordships would find, my lord, sir, Mahalakshmi Jumna, last matter.
2328.
Yes. Yes, 27.4.
Yes.
Let's page 234 in that, my lords. On 24/12/2025. 234. This is before the examination.
Yes.
I'm taking advantage of this one.
Yes.
Circular. A circular dated 10/12/25 was published on KPCL website, wherein at serial number 3, it was dated that selection lists will be prepared as per Government Order 3625. Subsequently, certain candidates have raised objections stating that since recruitment process commenced in 17 under the rules of dated 16/11/2016, applying 25 rules is inappropriate. They have requested withdrawal of notification dated 10/12 and preparation of the select list as per 2016. In this regard, it is hereby stated that KPCL will come under circular dated 16/11/16, which was further clarified by notification dated 3/6/25. Accordingly, both notification are applicable to the examination scheduled on 27 and 28. Therefore, my lords, KPCL says we will apply 2016 and 2025 circulars.
How can that both?
Both, my lords. My lords, page 235 and 236 are the two circulars, my lords.
Is it conflicting or they
No, my lords, they are in pari materia.
Yes.
Page 235.
Yes.
The clause that I rely upon is clause 2. This is the circular, 2016 circular, which they say, my lords, they will follow. I have no difficulty. Clause 2, my lords.
Yes.
May I read clause 2 at page 235?
Yes.
ವಿವಿಧ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳು ಇನ್ನು ಮುಂದೆ ಮಿಕ್ಕುಳಿದ ವೃಂದ ಹಾಗೂ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಅರ್ಜಿ ಆಹ್ವಾನಿಸುವ ಅಧಿಸೂಚನೆಯನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕವಾಗಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡು ಆಯ್ಕೆ ಅಂತಿಮಗೊಳಿಸಲಾಗುವುದು. It said for local cadre and for Hyderabad, Karnataka, two separate notification, two separate methods of recruitment.
Yes.
Two separate recruitment processes should be conducted.
Yes.
In this case, my lords, there are two separate recruitment notification.
Yes.
But the selection process becomes combined by conducting only one examination.
Yes.
Now, the 25 circular which they say they will follow, my lords, annexure Z3, page 236.
Yes.
3625.
Yes.
My lords, at page number 237.
Yes.
My lords, clause 2 is what they will rely upon.
Yes.
Before I read that, can I read the last portion, my lords?
Yes.
ಮುಂದುವರೆದು ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳನ್ನು ಭರ್ತಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಈಗಾಗಲೇ ನೀಡುವ ಸೂಚನೆಗಳಂತೆ ಕಡ್ಡಾಯವಾಗಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕ ಪರೀಕ್ಷೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. 2 different examinations shall be conducted. ತಪ್ಪಿದ್ದಲ್ಲಿ ಸಂಬಂಧಪಟ್ಟ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಿಗಳನ್ನೇ ನೇರ ಹೊಣೆಯಾಗಿ ಮಾಡಲಾಗುವುದು. Let's kindly note the date of this notification 3/6/25, which is at page 236, and at before the examination on page 234, 24/12, they expressly make a notification saying we will follow 3/6/25. Now, my lords, please have page 237, clause 2, which they will rely upon today, my lords.
Page
237.
Yes.
Clause 2. My lords, I have relied upon the last portion.
Yes.
They are relying upon column 2. ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಾತಿ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಒಂದೇ ಪರೀಕ್ಷೆ ಕೈಗೊಂಡಾಗ ಅನುಸರಿಸಬೇಕಾದ ಕ್ರಮ. ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಪಡೆಯಲಾದ ಆಯ್ಕೆಯನ್ನು ಪರಿಗಣಿಸದೆ ಮೆರಿಟ್ ಪಟ್ಟಿಯಿಂದ ಆಯ್ಕೆ ಪಟ್ಟಿ ತಯಾರಿಸಿದ್ದಲ್ಲಿ ಸ್ಥಳೀಯ ಮೊದಲಿಗೆ ಮಿಕ್ಕುಳಿದ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳ ಪರಿಗಣಿಸಿ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ತಯಾರಿಸುವ ತದನಂತರ ಸ್ಥಳೀಯ ವೃಂದದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಹುದ್ದೆಗಳಿಗೆ ಪರಿಗಣಿಸಿ ಅರ್ಹ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸುವುದು. 2, my lords, transpose those who are meritorious in HK to non-HK and prepare the merit list. My lords, this clause will apply if the examination is conducted prior to 3/6/2025. Clause column 2.
Yes.
If it is not, the last portion, my lords, kindly see the direction there. ಮುಂದುವರೆದು ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ಹುದ್ದೆಗಳಿಗೆ ಭರ್ತಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಈಗಾಗಲೇ ನೀಡುವ ಕಡ್ಡಾಯವಾಗಿ ಸ್ಥಳೀಯ ಮತ್ತು ಮಿಕ್ಕುಳಿದ ವೃಂದದ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿ ಪ್ರತ್ಯೇಕ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿ ಪ್ರತ್ಯೇಕ ಪರೀಕ್ಷೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿದೆ. So as on the date of the examination was conducted, 3/6/25 was available, which they say, my lords, that we will follow. And even in the 2016 circular, which they say will apply, clause 2 said there shall be 2 different recruitment processes. Now, therefore, my lords, challenging on these grounds, my lords, we have approached this court. I'll just set out the brief grounds, my lords.
Yes.
I've served a copy on the other side. I've summarized all of it.
Yes.
My lords, your lordships may kindly note, my lords, that we have approached the court before the exam was conducted. The first petition, my lords, they have approached before the exam was conducted.
Yes.
My lords, the first ground that we have raised is, my lords, that there is no stipulation of minimum marks in the exam notification. My lords, the response of the respondent, my lords, in the statement of objection is twofold. One, in the recruitment notification, we have not prescribed minimum marks. Therefore, we need not prescribe. We are only telling what the recruitment notification. Second is, in the earlier exam also, it was not prescribed. This is only a retest. My lords, I have an answer to both of that. First, let me show your lordships the rule, my lords. Your lordships will find that rule, my lords, at page 144, my lords.
In which petition?
In the first, your lordships have the second petition.
No, first petition. Yes.
First petition.
Yes.
Your lordships may have the second petition, my lords. It has
39094. Second petition.
Second petition, page 165, my lords.
No, which you are
My lords, Mahalakshmi Jumnanal, my lords. That 2-3. That is the most comprehensive. Your lordships may refer to.
Yes.
Let's page 163, my lords.
Yes.
Let's, can I read that clause, my lords?
Yes.
Since the Hyderabad Karnataka notifications were in the second one, I'm only referring to.
Yes.
Page 163, my lord.
Yes. Which annex?
Annexure. Annexure T. Just give me this. Let's clause 3.3.3. For the written test to be conducted, the MD will nominate the authority to conduct the written test. Specify the minimum pass marks for general category
Yes.
with relaxation up to 5% marks for SC/ST candidates. Now, my lords, therefore, my lords, 3.3 in my respectful submission is, first, for general category, minimum marks has to be stipulated. Second, for scheduled caste and scheduled tribe, only these two category of candidates will get relaxation of 5% of marks.
Yes.
Now, my lords, this is the statutory rules, my lords. The recruitment rules prescribe this. Now, my lords, the contention of the respondent is the recruitment notification did not prescribe, therefore we will not. My lords, the law is before the exam is conducted, the minimum marks can be prescribed. It need not be prescribed, my lords, in the recruitment notification. Please have a look at the impugned notification itself. Recruitment notification, insofar as Kannada language test, does not prescribe the minimum marks.
Yes.
But the impugned notification, my lords, prescribes the minimum marks for only Kannada.
Yes. Annexure?
My lord, annexure A.
Yes.
Annexure A. Only insofar as Kannada, my lord, at page number 42 prescribes the minimum marks, because last time they did not prescribe it.
Yes.
Single judge of this court held, my lords, that it has to be prescribed before the examination. Therefore, my lords, they have prescribed it. I'm just passing on the judgment for your lordship. My lords, your lordships may.
Yes.
There is
yes.
Geeta Chavan. Geeta Chavan did not. My lords, I'm sorry, my lords, it's not annexed to that. My apologies, my lords. I'll just place it on record, my lords. It seems to have been missed in the list. I'm sorry, my lords. My lords, my learned friend Ajay was also there, my lords. Both of us contested that, where they specifically, in terms of the recruitment rules, I'll just show your lordships the recruitment rules insofar as Kannada language examination is conducted.
Yes.
My lords, the recruitment rules at annexure T, your lordships may just. The Kannada language test, my lords, there was a specific condition that insofar as Kannada language test, minimum marks will have to be prescribed as at 3.3.3.
3.3.3 is.
No, similar. 3.3 prescribed minimum marks for technical examination.
So where is that Kannada examination?
Yes, my lord. I'll just. My lord, your lordships may come to page 166, my lord.
Yes.
Clause 4.5.
Yes.
No person who is eligible for appointment to any post in the cadre of AE equivalent and below shall be appointed to the post on the ground of his selection unless he has passed such Kannada language test as may be prescribed by the corporation.
Yes.
So on and so forth, my lords. Note, the language test shall be for 100 marks and its standard will be at the level of third language.
Yes.
Therefore, 4.5 clearly said you must have passed. Pass means there has to be a minimum marks, we have to score above that.
Therefore, court said that you have to.
You have to prescribe. There, my lords, the challenge was only specific to the Kannada language examination. Therefore, my lords, in this recruitment, while exam is being notified, they said that we will prescribe minimum pass marks for Kannada.
You have no grievance for that.
No, my lords. Now, in so far as technical is concerned, 3.3, my lords, though it's stipulated that minimum pass marks shall be prescribed. They say, my lords, that the recruitment notification did not prescribe, therefore we will not prescribe. Recruitment notification respectfully need not prescribe. It can be prescribed before the exam is conducted. That is where, my lords, the impugned notification comes into picture, where they say, we will not prescribe. Had they not said that, my lords, it's a different matter. But when they categorically say there will be no minimum marks, it is violative of 3.3.3.
Yes.
One, because general category candidates, my lords, do not have a minimum marks.
Yes.
And by not prescribing, the benefit that is available to scheduled caste and scheduled tribe by virtue of the recruitment rules
Yes.
is sought to be taken away.
Yes.
Both of which, my lords, are impermissible.
Yes.
I'll also show the judgment, my lords, where they said that before the stage is crossed,
Yes.
you can set the minimum marks.
Which is that?
That is the judgment in Tej Prakash, my lord. I just handed over to your lordship. It begins at page number 21, my lords.
Yes. Yes.
Lords, this is the Constitution Bench judgment, my lords.
Yes.
My lords, in so far, there, my lords, the question was, it was referred to the Constitution Bench for on reference because of the divergent opinions in the judgment in K. Manjushri,
Yes.
as well as in the judgment of Tej Prakash. Manjushri said after the recruitment has begun, you can't change the recruitment process. Then, my lords, the Tej Prakash said, would it apply in all cases? That your lordships will find at page 37, scope of reference.
Yes.
Then, my lords, page 40.
Yes.
They say, my lords, when the para 22, when the commencement of the recruitment process and end.
Yes.
Paragraph. My lords, then at paragraph number 26, my lords.
Yes. Page.
My lords, page 42. My lords.
Yes.
Then they go on the doctrine of legitimate expectation.
Yes.
Ultimately, my lords, while discussing at para 29
Yes.
on the decision of Manjushri,
Yes.
they would hold, my lords, that if the prescription of the qualification is before the stage has crossed, that it will start from clause para 29.
Yes.
It would end, my lords, at about the finding. I'm not reading it for paucity of time. Para 40, my lords.
Yes.
After discussing the facts of that case, they would hold, my lords, at ultimate conclusion is at para 62.
Yes.
Where they say, my lords, you can't change para 65.2. 65.1, recruitment process commences from the issuance of advertisement calling for application and ends with filling up of vacancies. 65.2.
Yes.
Eligibility criteria for being placed in the select list notified at the commencement of recruit cannot be changed midway through the recruitment unless the extent rules so permit, or the advertisement which is not contrary. Even if such change is permissible under the extent rules, the change would have to meet the requirement of Article 14 and satisfy the test of non-arbitrariness. Then, my lords, 65.4. Recruitment body subject to extent rules may devise appropriate procedure for bringing the recruitment process to its logic, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and rational nexus to the objects ought to be achieved. Extent rules having statutory force are binding on the recruitment body, both in terms of procedure and eligibility.
Yes.
However, where the rules are non-existent or silent, administrative instructions may fill the gaps. 65.6. Placement in the select list gives no indefeasible right to appointment. The state or its instrumentality for bona fide reasons may choose not to fill up the vacancies. So therefore, my lords, they held rules have primacy.
Yes.
And that before the stage is crossed, the minimum marks can be prescribed, my lords.
Yes.
In fact, at page 29 onwards, Manjushri was with reference to the prescription of minimum marks itself, my lords.
Page number, Manjushri has been.
Manjushri has been extensively discussed, page 43, my lords.
Yes.
Let's page 45. If your lordships were to come, my lords, 27. This is where, my lords, therefore, introduction 27 within quotations, placitum B, my lords.
Yes.
Therefore, introduction of the requirement of minimum marks for interview after the entire selection process, written examination interview was completed, would amount to changing the rules of the game after the game was played. We may clarify that prescription of minimum marks for any interview is not illegal. We have no doubt that the authority making rules, regulation and selection can prescribe the rules, the minimum marks both for written or prescribed for written examination, but not for interview, or may not prescribe any minimum marks for either written exam. Where the rules do not prescribe any procedure, the selection committee may also prescribe the minimum marks as stated above. But if the selection committee wants to prescribe minimum marks, it should do so before the commencement of the selection process. Let's next 35 minutes. Kindly see minutes. The ratio in Manjushri is that the criteria for selection is not to be changed after completion of the selection process. Though in the absence of rules, the selection committee may fix minimum marks either for written examination or for interview for the purpose of selection. But if its minimum marks are fixed, it must be done before the commencement of the selection process. This view has been followed in so and so. Let's yes. Therefore, my lords, my first submission is, my lords, before the written examination was conducted, there is provision to fix the minimum marks, no doubt about it. But in the impugned notification, they say we will not fix, which is contrary to 3.3.3, my lords. And their only answer to that is recruitment notification is not done. And in the earlier time, we did not prescribe it. My lord, in the earlier recruitment notification, my answer is twofold. The calculation of marks itself was put to challenge.
Yes.
Therefore, my lords, there's no question of saying that minimum marks was not prescribed, so on and so forth. Only if the calculation of marks was correct, my lords, question of minimum marks. Second is, my lords, my conduct is being, my lords, held against me. But what they say is the results of my conduct is taken away by judicial orders, whatever, for whatever reasons. But your conduct remains, the consequence of the conduct goes. It can't be that way, my lords. If the exam is cancelled in toto, then it goes in its entirety. Today, they can't say previously you have participated, therefore it goes. Ultimately, today, your lordship, the selection is at a very, very nascent stage. Recruitment notification is there. For whatever reasons, earlier exams are cancelled. This is the first examination after the recruitment. So, therefore, my lord, these petitioners have approached your lordships at the first instance. Recruitment notification, before the exam is conducted, we have approached your lordships. My lord, I have the judgment of Geeta Chavan, my lords, where they directed prescription of minimum marks. Now, their case is, it is only restricted to Kannada because the judgment was pertaining to Kannada. Let's page 45 minutes.
Yes.
Let's page, internal page 31, rule is quoted, the rule that I just read out to your lordships.
Yes.
Then, my lords, ultimately at page number 45.
Yes.
Conclusions are drawn, my lords.
Yes.
Fully relying upon Tej Prakash. They can't say minimum marks will be prescribed only for Kannada and technical examination in the presence of rules, my lords. My lords, the second ground of challenge, my lords, in my summary of contentions, my lords, I have noted.
Yes.
C, my lords. They have relied upon circular dated 6/11/2016 and 36/25. I've given the page numbers. Para C, internal page 2, my lords. This is pertaining to Hyderabad, Karnataka. I read out.
Which is that next contention?
Page 2, C. A conjoint reading of government circular dated 16/11/16 and 3/6/25 shows that where separate recruitment notifications are issued for HK and non-HK, separate selection process and examinations are mandatory. My lords, I have no difficulty in saying, my lords, when their notifications say that we will follow this, they should have conducted two different examinations. Now, in these batches of petitions, both HK and non-HK, general, SC, ST, all combinations are available. Therefore, locus may not be a question, my lords. My lords, next is merit solely based on written test is ultra vires, the statutory rules, my lords. My lords, the procedure prescribed in the rules of recruitment, my lords, which I just pointed out.
Yes.
My lord, I'll just take your lordships to the rules annexed T, my lords. What the rules prescribe, what is the methodology they have adopted, and their answer to that.
Where is that?
Annexed T, page number 162, my lords, it starts.
Where is that rule notification prescribed?
My lords, original, yes, my lord. Your lordships may kindly see, my lords, page number 57.
Yes.
My lord, your lordships got it.
Yes.
Selection will be made purely on the basis of merit-based, duly following reservation policy. Merit list will be prepared on the basis of marks obtained in the written test.
Yes.
Now, your lordships may kindly see the rules or the amended rules, page 176. Page 177, relevant portion.
Yes.
My lord, the relevant rule would start at 3.3.2a, which is at page number 176.
Yes.
The lordship got 176.
Yes.
First one, my lords, in the column. Recruitment to the post in the cadre of JE, AE, and equalist chemist headmaster will be made by selection considering the mark obtained in the qualifying examination and interview.
Yes.
This was the existing.
Yes.
My lords, in my first petition, my lords, I have relied upon the existing and not the amended. But in the first petition, I have filed a memo, my lords, since it has come. Now, kindly see the amendment of 2009. Recruitment to the post of JE and AE will be made by selection considering the marks obtained in the qualifying examination and the written test. Therefore, my lords, it's a two-stage process. One is the qualifying exam and the written test. Now, the recruitment notification says it will be only on the basis of written test and nothing of the qualifying exam. Now, respondents, my lord, seek to counter this on two contentions, my lord.
Yes.
My lords, this contention, my lords, is sought to be rebutted by the corporation, my lords, on two contentions. First is at page 111 of the reply statement of the corporation.
In this case.
Yes, my lord. They have filed.
In which case they have filed?
In the first case, they have filed reply, my lords. 3909.
What is their contention?
First contention is that there is a resolution to make it a one-stage selection process. Therefore, that resolution will prevail over the rules. Page 111 and 112.
111.
Yes.
Yes.
Right. This is the 111 and 112.
Yes.
My lord, I am assuming, my lords, that this resolution will prevail over the rules.
Yes.
One, my lords, these are resolutions which can't prevail over notified rules.
Yes.
In the reply statement, they come up with this resolution, my lords. Candidates are not notified about this. But at any rate, please have a look at the last resolved, my lords, at page 111.
Yes.
Resolved that the managing director be and is hereby authorized to carry out the recruitment process for entry level posts as above in the 2 stages, keeping in abeyance the provisions for oral written test to the set post in the C&R rules on a one-time basis. My lords, the resolution is in the year 2014, page 111 top. Page 112 is the second resolution, again of the year 29, 2014, at resolved point 1, my lords, last sentence. Modification of the decision of the board in its 230.
Page 112.
Yes, my lords. Other resolved.
Resolved.
First clause. Last but one sentence. Modification of the decision of the board in its 230 on a one-time basis only. So I am assuming modification is correct. It is only on a one-time basis, which stood, my lords, dissolved by virtue of a recruitment notification of the year 2015, my lords. I'll just tell the date.
They have
Yes,
completed.
on the basis of this, for the very same post, 1/12/2014.
It is completed.
Yes. That is not disclosed, my lords. That is not disclosed to your lordships at all. The only basis is that this modification takes place.
Yes.
Therefore, my lords, one-time measure is over. Second, over notified rules, statutory rules, executive instructions can't take place, my lords.
That is in which year that recruitment is over?
1/12/2014. Can I just place it for your lordships?
Yes. Yes.
There, my lords, the recruitment process is a one-stage recruitment process, my lords.
Yes.
And for the same post, AE, AEE, my lords, in fact, I have other notifications, but they may have got nothing to do with these posts.
Yes.
Therefore, that one-time measure may not strictly apply, my lords. Therefore, my lords, my submission is that the process, my lords, is contrary to the rules. My lords, and in so far as the fifth option, my lords, for negative marking, my lords, earlier round of litigation was for every wrong answer, there is negative marking. No doubt about it, my lords. But here is a case where even if I don't answer anything, my lords, I am bound to have negative marking, my lords.
No, that is, see, that is not contrary to that any rules. That is for the employers to fix.
Yes, my lords.
You cannot.
They can prescribe it before the exam, no doubt.
For the exams, it is not arbitrary. It is for everybody.
Very well.
You can't say that if it is for you too difficult, don't attend that exam.
My lords, if I don't attempt, then I will not have.
Means to say you are not interested. It's difficult.
Very
I
well.
don't want to recruit in this process.
Yes, my lords. My lords, therefore,
You can't say that because of exams.
Yes,
I can't do it. You have to modify.
Yes,
Yes.
my lords, then I'll give up that contention for the present, my lords. I'll not press on that. Can I just show your lordships the judgments, my lords, which I rely upon, my lords?
Yes.
My lords, first one, my lords, was a judgment. My lords, I have given the propositions, my lords, in the list of citation.
Yes.
Where this was a case, my lords, if your lordships were to see from paragraph 3 and 4 onwards, there was participation in the selection process. Because today what is held against these candidates is, you have participated in the selection process, you can't turn around and challenge. Last time learned single judge held the same thing, which was reversed. Now, my lords, again we are.
Now, what is that finding of the division bench regarding that?
Yes,
What you have participated and
they said, unless you participate, my lords, kindly look at this. Unless I participate, I am an outsider to the selection, I can't question it. Without filing my application, I can't challenge it because I'm an outsider to the selection.
That is what that, or what is that judgment of the Supreme Court said? Once you participated, you cannot be.
Yes, madam.
That means to say, person interested on basis of the notification, you should be aggrieved and you have to challenge.
Before I file my application to the notification, I can't challenge, madam, because I'm a stranger.
No, if you want, you want to apply for the notification. By seeing that notification, these are all the
terms and conditions.
Term and conditions, it is illegal. then you can approach the
No,
court.
my lords. At that stage, I can't, my lords.
Why?
All the judgments, including Madan Lal, which was relied upon, were cases where, my lords, I have filed my application, I participate in the written test, my lords, I go to the interview. There, my lords, in the interview or in the document, I become unsuccessful. Then I can't turn around and say recruitment notification itself is bad. After having participated in it. That was, my lord, if your lord, Madan Lal is in fact quoted by the learned single judge, my lord. In the earlier round, which your lordships will find, my lords, at page number 89, my lords.
Yes. Yes.
Page 89.
Yes.
Thus, the petitioners took a chance to get themselves selected at the
9, where you are reading.
789, the quotation, my lords. I'm so sorry, quotation. 89 of the writ papers, my lords.
No, writ papers you are reading.
I'm
Not
so sorry. I'm
judgment.
so sorry. Yes, ma'am. 89 of the writ paper. On the earlier occasion,
This is a single judge order.
yes, ma'am. Single judge order which was set aside.
Yes.
Since, my lords, the contention is having participated, I can't.
Yes.
Within the quotation, my lords.
Yes.
Thus, the petitioners took a chance to get themselves selected at the said oral interview. Only because they did not find themselves to have emerged successful as a result of their combined performance, both at written test and oral interview, they have filed this petition. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or selection committee was not properly constituted.
Yes.
Now, my lords, there he participate in the written test, goes to the interview.
That earlier round you have not participated. Before that only challenge.
My lords, after the written test, only in the written test we got to know there is negative marking.
Then you have challenged.
Then we challenged.
That's what that consideration of division right.
Yes, my lords. Now here, even before the written test, the first writ petition is filed. My lords, even before your lordships, my lords, the interim order is resisted saying that look, let the selection go on. Now, my lords, they can't raise a contention having participated. Because, my lords, not in respect of my client, as a third person, I cannot challenge this recruitment because I have not participated. Now, if I file the application, they can't say you have filed the application, therefore you are out. Only a participant, before he takes a calculated chance to get selected, can challenge it. Page 90, my lords, that is where they say. In Tajveer Singh, they quote, my lords, it is therefore tried that candidates having taken part in the selection process without any demur or protest cannot challenge the same after having been declared unsuccessful.
Yes.
Now, my lords, as on today, there is nobody who is declared unsuccessful because there's only a score list at the most and verification, document verification, nothing more. Therefore, my lords, my submission is, if your lordships were to take to my list of citation, my lords, the first judgment would show, my lords, first and the second judgment are for the proposition that the recruitment rules will prevail over the advertisement notification.
Yes.
Because their contention today is that I have filed my application pursuant to the recruitment notification, therefore I can't challenge it.
Yes.
Only because I have filed the application, relevant paragraph would be paragraph 21 and 24, my lords,
Yes.
which is at page number 6 and 7, my lords.
Yes. Yes, we'll continue.
Yes, I'm so sorry. I'll just read these judgments and close it.
Yes.
Great.
ಏನಪ್ಪ
20 ದಿವಸ ಇದೆ ನನ್ನ ಸರ್ವಿಸ್ ಸ್ವಾಮಿ 22ನೇ ಇಸ್ವಿಯಿಂದ 4 ವರ್ಷದಿಂದ ನನಗೆ ಸಂಬಳ ಎಲ್ಲ ಬ್ಲಾಕ್ ಮಾಡಿ ತುಂಬಾ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ 25 ದಿವಸ ಇದೆ ದಯಮಾಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು ಪ್ರೀವಿಯಸ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪೋಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರಿ ಮೆಮೊ ಇಲ್ಲ ಅಂತ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ದಯವಿಟ್ಟು ಪೋಸ್ಟ್ ಮಾಡಿ ನನಗೆ ಅನುಕೂಲ ಮಾಡ್ಕೊಡಿ ಸ್ವಾಮಿ ಇಬ್ರು ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ ಸ್ವಾಮಿ
ಇದೇ 40 ನೆಕ್ಸ್ಟ್ ವೀಕ್
40 next week. Yes.
ಥ್ಯಾಂಕ್ ಯು. ಮಾರ್ಚ್ 2nd ಹೇಳಿದ್ದಾರೆ ಸರ್. ಮಾರ್ಚ್ 2nd.
ಸರ್ವಿಸ್
ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದಾರೆ.
ಸರ್ ಸರ್ವಿಸ್ ಮುಗ್ದೋಯ್ತು.
ಸರಿ, ಮಧ್ಯಾಹ್ನ ಬಂದ್ಮೇಲೆ
ಕೆಲಸ ಆಯ್ತು.
ಆಗಿದೆ. 10ನೇ ತಾರೀಕು ಬರುತ್ತೆ. ಮಿಸ್ ಆಗಿದೆ, ನಮ್ಮಲ್ಲಿ ಮಿಸ್ ಆಗಿದೆ. ನೋಡ್ದೆ, ನೋಡಕ್ ಹೇಳಿದ್ರು, ನೋಡಿದೀನಿ, ಸಾಹೇಬ್ರ ಗಮನಕ್ಕೆ ತಂದಿದ್ದೀನಿ. 10ನೇ ತಾರೀಕು ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ 10ನೇ ತಾರೀಕು ಇಲ್ಲ, ಬೇರೆ ಬೇರೆ ನಿಮ್ದು ಅದಾದ್ಮೇಲೆ
ಅದರಲ್ಲೇ ನಂಗೆ ಪೇಜ್ ಪ್ರಕಾರ ಅದನ್ನ ನೋಡೋದು.
ಪಾಸ್ವರ್ಡ್
Before the stage is crossed, they can prescribe.
ಪಾಸ್ವರ್ಡ್ ಇದಾದ್ಮೇಲೆ ತಗೊಳ್ತಾರೆ. 30 ಯಾರು 30 ಇನ್ನೊಂದ್ಸಲ ಕೇಳ್ಬೇಕು. ಮಾರ್ಚ್ 2 ಹೇಳಿದ್ರು, ಇನ್ನೊಂದ್ಸಲ ಕೇಳಿ. ಸರಿ ಆಯ್ತು, ಬರ್ಲಿ ಸಾಹೇಬ್ರು ಬರ್ಲಿ ಸರ್. ಆಯ್ತು ಸರ್, ಸಾಹೇಬ್ರು ಬರ್ಲಿ. ಈಗ ನನ್ ಕಳ್ಸೇ ಇಲ್ವಲ್ಲ, ಅದನ್ನ ಇಲ್ಲೇ ಇಟ್ಕೊಂಡು
38 ಇದೆಯಾ ಸರ್?
ಬರ್ಲಿ, ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್.
ಇದು
ಯಾವ್ದು ತೆಗಿಬಿಡಮ್ಮ, ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ.
ಕಂಟಿನ್ಯೂನಾ 26 ಕಂಟಿನ್ಯೂನಾ?
ಬೇರೆ ಇದೆ, ಬೇರೆ ಆದ್ಮೇಲೆ ಅಲ್ಲೇ ಮಾಡ್ಕೊಂಡೆ
ನಂಗೆ ಪೇಜ್ ಪ್ರಕಾರ ಮಾರ್ಕ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ.
ಅದೇ ಅದೇ ಮಾಡ್ತೀರಾ? ಅದೇ ಹೇಳೋದು, ಮಾಡೋದಾದ್ರೆ ಮಾಡ್ಸಿ, ಇಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ ಪೋಸ್ಟ್.
Must be all over the place.
ಸ್ವಲ್ಪ ಫೋನ್ ಚಾರ್ಜಿಂಗ್ ಹಾಕ್ಬೋದಾ ಸರ್? ಫೋನ್ ಚಾರ್ಜಿಂಗ್ ಹಾಕ್ಬೋದಾ? ಚಾರ್ಜಿಂಗ್ ಹಾಕ್ಬೋದಾ ಫೋನ್?
ಕಾಸ್ಟ್ ಡೇಟ್ ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗುತ್ತೆ. Annexure
Yes, sir.
ಸರ್ 26 ಇವತ್ತು ತಗೊಳ್ಳಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ 26 ತಗೊಳ್ಳಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಸಾಹೇಬು ಅದು ನಾನು ಮಾಡಿಸ್ಕೊಂಡು ಹೋಗಿದ್ದೆ
ಮಾರ್ಚ್ 2 ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಒಂದು ಚೇಂಜ್ ಮಾಡಿ 50 ಇಲ್ಲ ಇಲ್ಲ ಸರ್, ಅದೇ ಇನ್ನು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Complied.
ಪಿನ್ ಹಾಕಿದ್ದೀರಾ ಮೇಡಮ್? ಪಿನ್ ಹಾಕ್ತೀರಾ? ಸ್ಟಾಪ್ಲರ್ ಅದೆಲ್ಲ ಆಗಲ್ಲ, ತೆಗೀರಿ. ಗಿರೀಶ್, ಚಿಕ್ಕದು ಸ್ಟಾಪ್ಲರ್ ಇರ್ತಾರೆ ಎಲ್ಲಪ್ಪ. ತಗಿಲಿಲ್ವಾ ಅದು?
ಆಯ್ತು, ರಿಟೈರ್ಡ್ ಆದ್ರೆ ಏನಾಗುತ್ತೆ? ರಿಟೈರ್ಡ್ ಆದ್ರೆ ಏನಾಗುತ್ತೆ? ಅಲ್ಲ ಆಯ್ತು, ರಿಟೈರ್ಡ್ ಆದ್ಮೇಲೆ ತೀರ್ಮಾನ ಆದ್ರೂ ನಿಮ್ ಪರವಾಗಾದ್ರೆ ಹಣಕಾಸು ಬರುತ್ತಲ್ಲ. ಹಾ ಈಗ ಆಯ್ತು, ನೋಡೋಣ ಅವತ್ತು ನೋಡೋಣ ಮಾರ್ಚ್ ಅಲ್ಲಿ. 23rd February 23rd. Yes.
For pronouncement of order, serial number 82, Somashekar for petitioner, Sushal Tiwari N.
The writ petition is devoid of merit, accordingly it is dismissed.
Grateful.
Continue.
Serial number 27, Prithvish MK for petitioner, connected matter, SV Prakash, Ajay JN.
Yes. Yes.
I'll continue from where I left off, only the judgment.
I think your matter may not reach. Yes. Any other date? Are there any dates you want?
No, any date.
Next week.
19th, other than 19th and 20th of this month. Any date, my lord.
24th.
Great.
24th.
My lords, I appear for the impleting application in that case. May I seek for a
Yes.
shorter date, my lords. We have filed vacating stay also, my lords.
Yes, 24th we will see, because another 2-3 matters spotted is there. By the time I will complete. Yes.
Interim order make.
Order granted earlier is extended till next week. Hmm. 78. ಯಾರು ನಿಮ್ ಲಾಯರ್? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ಗ? ಯಾರು ಲಾಯರ್ ಅದು?
Dada Kalanda. 78. 78, sir.
78. 18th. Yes. Yes, Mr.
The list of citations, my lord, they have given the proposition.
Yes.
The first proposition is that statutory rules would take precedence when there is variance with the advertisement.
Yes.
That's for twofold, my lords. First is, my lords, that minimum marks has to be prescribed. Second, relaxation.
Yes.
Third, the method in which selection has to take place.
Yes.
Lords, can I just show the facts in each case, because I don't want it to be distinguished on facts by any. Lords, the first judgment is Malik Mazhar Sultan, my lords.
Yes.
The fact, my lords, relevant fact is at internal page 6, para
Yes.
18 onwards, my lords. My lords, para 21 is the, yes, my lords.
Yes.
Right, in this case also at internal para 6 at page 4,
Yes.
the recruitment notification was issued. Candidates had participated, para 6. Para 9, my lords, the age is varied, my lords. Relaxation of age is varied. Therefore, my lords, some of them were ousted.
Yes.
Therefore, writ petition came up. Para 21 at page 6, my lords.
Yes.
The present controversy has arisen as the advertisement issued by the Public Service Commission stated that the candidates who were within the age on 1/7/2001 and 1/7/2 shall be treated within age for examination. Undoubtedly, the excluded candidates were eligible as per the advertisement, but the recruitment to the service can only be made in accordance with the rules, and the error, if any, in the advertisement cannot override the rules and create a right in favor of a candidate if otherwise not eligible according to the rules.
Yes.
The relaxation of age can be granted only if permissible under the rules and not on the basis of the advertisement.
Yes.
Let's kindly mark this, minutes. I'm saying this because if the rules say minimum marks has to be set,
Yes.
that relaxation can't be given by way of notification or otherwise. If the interpretation of the rules by PSC when it issued advertisement were erroneous, no right can accrue on the basis thereof. Therefore, the answer to the question would turn upon the interpretation of the rules. Therefore, my lords, my first submission is if the minimum marks are not set and they say we will not fix it, that would be counter to the rules, my lords. My lords, the second judgment, my lords, is at page 11. Para 2 are the facts. Internal page 11, para 2, my lords.
Yes.
My lords, the facts are noted to show, my lords, that recruitment notification was issued. The appellant therein participated.
Yes.
After the interview, my lords, he was ousted, my lords.
Yes.
Now, at internal page 15, para 14.
Yes.
14 and 15, the variance in the advertisement and the recruitment rules is noted, my lords. 14, 15. But for our purpose, page 19, para 27. I'm not saying recruitment should go. All that I'm saying is it has to be brought in conformity to the recruitment rules. That's all that I'm saying. Para 27. Any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. Thus, looking to the qualification prescribed in the statutory rules, the appellant fulfills the qualification and after being selected for the post, denying appointment to him is illegal and arbitrary. It is well settled that when there is variance in the advertisement and in the statutory rules, it is the statutory rules which take precedence. That is all that I'm saying.
No, even assuming that if it is accepted, can it be cured?
Malad, all that I'm saying is, Malad, we challenged this process before examination was conducted. They will today have to prescribe the minimum marks. This is the qualifying marks, this is the relaxation and redo the exam. That is all that is left, Malad.
No, even after the examination.
Yes, Malad.
Now that valuation has to be done.
Yes, Malad. Now, Malad, it may not be permissible. They can't fix the minimum marks after the exam is conducted.
Yes.
Malad, we challenged it before the exam. Interim orders were resisted, Malad, saying that we will proceed. In fact, memo is filed that we will take these many dates to for valuation. It is
then everything is again fresh only.
Malad, the only stage that has passed is examination is conducted. Yes. Now the clock will have to be put back only to that extent.
The problem is conducting exam in itself.
Yes,
large number of candidates are there.
Malad, in fact, can I before then I'll short circuit the end. Malad, it can be given a closure, Malads, provided Malads KPCL would find a way to accommodate candidates, Malads, who were selected, who are today not selected. Malads, the problem is this, Malads. These petitioners, Malads, in the earlier round of litigation were respondents, rather impleading, who were not allowed to implead themselves. These people were selected. As on 28 December, before this exam, they were all selected candidates.
Yes.
Now, my lords, after 28 December, we are ousted from the selection process.
Why?
Because of the new exam and the results. Now, my lord,
now that new exams you have not participated.
We have participated, my lords. Before participating, the first petition was challenged. Subsequently, all of this has come. Now, my lords, after 28 December, we are ousted. Before 28, we were there. Now, my lords, those who are impleading, of course, my lords, they were our clients earlier. They were in the division. They said selection is bad. Now, my lords, they are contesting saying selection is correct. So ultimately, my lords, it's a question of what happened when. If a way can be found, my lords, where all of us can be accommodated, it will be given a closure.
Yes.
How, my lords, next judgment, page 21, my lords, is the Tej Prakash. Para 52, internal page 53. Para 52, page 53.
Yes.
This is what I wanted to point out. Thus, in our view, the appointing authority, recruiting authority, in the absence of rules to the contrary, can devise a procedure for selection of candidates suitable to the post, and while doing so, it may also set mark for different stages, benchmarks for different stages of the recruitment, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extant rules or advertisement inviting applications empower competent authority to set different benchmarks at different stages of the recruitment, then such benchmarks may be set at any time before the stage is reached so that neither the candidate nor evaluator examiner is taken by surprise. So before the exam, if it is not stipulated in the recruitment rules, minimum marks can be stipulated before the exam. Now, my lords, the challenge is because before the exam they say we will not stipulate, my lords. My lords, the next judgment, my lords, is the most recent decision which your lordships would find at page 59. My lords, that is for the proposition, my lords, that executive memos cannot be relied upon, my lords. Their contention is we have given a go by to the statutory rules because by virtue of the executive instructions, it was given as a one-time measure.
Yes.
Page 69, para 39 at the very bottom. Page 69.
Yes.
We also note the argument regarding the General Administration Department's 2018 memo and 2021 memo. While these resolutions reflect a policy to grant weightage, they were executive instructions. The recruitment in question was governed by the statutory 2019 rules, which did not incorporate these resolutions at the time of the 2019 advertisement. The state cannot rely on executive instructions to override statutory rules that were enforced during the initiation of the recruitment process, especially to the detriment of the candidates who had no choice, so on, so on. So, therefore, my lords, my submission is these.
Yes.
The recruitment rules, my lords, cannot be given a go by. They have statute. My lords, in the reply statement, my lords, the respondents take one contention, my lords. I'll just point out the paragraph, my lords, that the recruitment rules have no statutory force. They are just executive instructions. Your lordships got the reply statement, my lord.
Yes.
In the reply statement, my lord, I'm sorry. Page 19, my lords, para 31.
Yes.
It is submitted that Cadre and Recruitment Rules 1997 do not have statutory force as they are not framed under any provisions of the statute.
No, page
19, my lords,
para
31. Reply statement.
Yes.
It is submitted that the Karnataka Power Corporation Limited Services Cadre Recruitment, Probation, Promotion and Seniority Rules does not have statutory force as they are not framed under any provision of the statute.
How that rule has been framed?
They say it is by way of board has adopted a resolution and therefore these are the rules. I have no difficulty, but without recruitment statutory rules, a public corporation cannot make employment to a public post in the absence of rules.
Where is that rule? Give that.
Annexure T. In fact, this contention is rejected by the court on the earlier occasion.
Considered.
I'll just point out. The judgment of
Kalburgi. See that rule first.
Yes, annexure T.
Rule is framed without law.
Yes. Then it has to be completely ignored.
Yes. Where is that?
Annexure T. Page number 161, 162 it starts.
Recruitment, appointment.
Full recruitment rules. These are the only things that were
conditions requested to appointment.
This was given under RTI. Therefore, this is all, my lords, that we have.
Yes.
Page 161 under RTI.
No problem.
Yes, this how this rule has been framed.
My lord, not under any specific statute or anything. My lord, this is only for internal purpose. We have framed these rules.
No, you see that power is available for you.
My lord, insofar as this concerned, my lord, there's a direct judgment on this part saying that it is only an internal thing. It is binding on us, my lord. Now, what the crux of the matter is, my lord, this is a third round of litigation, Let him complete, my lord. Just one sentence, my lord.
No, all his argument is on the basis of this rule.
Correct, my lord.
If you say that this is not the rule,
No, this
it has
is
no
the-
statutory force, then his arguments are gone. Why do you want?
Therefore, that I'll produce that to your lordship.
Yes.
Yes. But their argument is, my lords, it has no statutory force at all. Therefore, it's not binding on anybody, my lords. But then the entire recruitment has to go.
Now, where is that this issue has been decided?
Yes, my lord. My lords, the other judgment which I gave, my lords, just Geeta Chavan, Justice Magdum's order of Kalburgi.
Yes.
My lords, I'll just take your lordships to the specific paragraphs, my lords.
Yes.
Internal page 19, para 24, my lords. In respect of the very recruitment, my lords.
Para 14.
Internal page 19, para 24, my lords.
Yes.
On the other hand, learned counsel appearing for respondent number 1 to 3 has justified the respondent's action in prescribing 150 marks as maximum marks for Kannada language test despite the provisions of the Karnataka Power Corporation so and so. The learned counsel contends that the C&R rules of KPCL, while governing the service conditions and recruitment processes of KPCL employees, do not have the force of statutory law. Rather, they are of a contractual nature, essentially forming an agreement between KPCL and its employees. As such, learned counsel argues C&R must be understood as a set of internal guidelines designed to govern employment relations, and their interpretation should not be subject to the same rigidity as statutory provisions. Learned counsel emphasizes 4.2 of the C&R rules. They again rely upon the C&R rules.
Yes.
Now, page 31. This is where the consideration starts. The court, para 40, rule 4.5 of the C&R rules of KPCL is extracted as under Kannada language examination.
Yes.
I read this out to your lordship.
Yes.
Now, my lords, after assessing all the arguments at internal page 44, para 57,
Para 44.
page 44, para 57.
Yes.
The recruitment authority is obligated to set minimum qualifying marks in advance, providing clear and transparent criteria for all. The fixing of 150 marks as the maximum score, which is contrary to the regulations under, they quote KPTCL instead of KPCL, has further complicated the selection process. They rely upon the KPCL recruitment rules to say fixing of 150 marks is contrary to the C&R rules, which prescribe 100 marks.
No,
Now,
that,
my lords, 47, my lords.
no, what they are saying that this is only a, contract and it can be changed at any time. Therefore, now what they are changing, it is not contrary to that because it has no statutory force. That is what their arguments. I think so.
My lord,
Para 25, my lord, that is what your lordship's page 20, para 25 is exactly what was argued.
Yes.
Page 20, para 25, my lord. Page 20, 20, my lord.
Yes.
Yes.
Para 25, yes.
25, specifically, the learned counsel emphasized that root 4.5 of the C&R rules, which may traditionally set out certain criteria for recruitment, should not be viewed as a provision that limits or rigidly governs the discretion of KPCL. Instead, it is argued by KPCL has the authority to modify or adopt its own internal recruitment process, as long as such modification serves the larger goal of administrative efficiency. The council contains the decision to prescribe 150 marks as the maximum for Kannada language test falls well within the discretion of KPCL, and such change was permitted within the broader powers granted. This is what your lordships were pleased to just observe. Man.
That is exactly what at page 44, para 57. This was the contention that statute, it has no statutory force, it cannot be relied upon.
No, they are not saying that. They are saying that.
Yes,
they are making some regulations or rules.
Yes,
they are adapting.
Yes.
See, if there is a regulation and rules, they can change any time.
Yes.
If it has a statutory force, that cannot be contrary to this.
Yes.
They are saying that It may be called as in a rule.
Yes, my
But it has not in a rule has any statutory force.
Yes, my lord.
It
Then
is as like now they have issued one more circular.
Yes.
Like that, this is also one of the circular, that's what.
Yes.
Is it be permissible under that?
My lord,
I don't
at
know.
any
You have to
time,
be
yes, my lord. I'll point to that. Page 44, para 57, my lords. Quote fourth sentence, my lord.
Yes.
The fixing of 150 marks as maximum score, which is contrary to the regulations under the so and so, has further complicated the selection process.
Yes.
That is the finding, my lords. Their submission is it can be changed. Court says no. This is the criteria in the Rusienda rules. What you have done is contrary to that, which complicates the matter.
No, is it
Yes.
not permissible for them to change that rule?
It is, my lords. Absolutely. They have changed it as a one-time measure by way of an executive instruction. Now, my lords, that over. 2014, it was over. Then what prevails is only these executive instructions. I'm assuming it is correct. Even assuming these are only executive instructions, even then, the benchmark to set the minimum qualifying marks and to do a certain thing a certain way remains. That's page 47, clause D, my lords.
Just page 44,
Yes.
what, just to, so that
Yes,
we are on the
yes,
same
yes.
page. Page 44, para 57, my lords.
Yes.
Ultimately, the court has not gone, just I read this one para.
The court has not decided that aspect.
That aspect, and what it says, it is unreasonable, 5 lines from top, it is unreasonable to expect aspiring candidate to speculate about the minimum qualifying marks based solely on the maximum score of 150. If the respondent had properly notified the minimum qualifying marks in the recruitment notification, it is only natural the candidate would have been tailored the preparation accordingly, aiming to secure the prescribed 50. Furthermore, it is crucial to recognize the question of technical one and passing Kannada language exam should not override the technical qualification required to the pass. The primary focus should be on technical competence of the candidate and imposition of arbitrary language proficiency requirement without prior notice to undermine the fairness of the process. Ultimately, my lords, here, my lords, there are to say there are around 600 posts, my lords, or now 429. Now around 19,000 approximately, 9,000 or not. Every time an examination is being held, my lord, they're saying that ultimately what we have once we have cancelled because of malpractice. Second, court has set aside on 2 counts. One is Kannada and one is with regard to negative marking. While passing that order, court says go by your own notification of 2017. We have followed 2017 notification. Now, when we follow 2017 notification, there is C&R is not applicable.
No,
If it,
2017 notification, have you not prescribed passing marks for
no, my
technical?
No, my
Already.
lord. No. Therefore, my lords, if we had followed.
No, then why that 2017 recruitment has been passed by that High Court?
Well, on 2 counts, my lord. One was independent with this judgment saying that minimum marks for Kannada, my lord. That is one. Second thing, my lord, negative marking was not informed to them. Only on the same point, my prior knowledge is not there. They were not put on notice on both Kannada and the earlier notice.
There is no answer for this fixing a passing marks. There was no discussion on that. There was no earlier order.
And one, therefore, my lord, all I would say, my lord, just so that we can go.
No,
It's a constructive risk judicator. You can, having followed strictly as per this judgment, we are not only bound by the earlier division bench judgment, which upheld by Supreme Court. Now you cannot take an argument which was not argued, saying that follow C&R rules, not your 2017 notification, because this notification was there when that was argued earlier also.
That contention you have raised and it is not.
No, therefore, as my learned friend fairly considered, once he's appeared for those people who are on this side, now he's appearing people who are on.
It's not that. No.
He's an advocate.
No, I'm not saying, no, my point now, I'm not on that point. Point is, out of 9,000 people for 600 posts, somebody will be aggrieved because they're not gotten. Ultimately, the idea is not to get the best candidate as long as procedure followed is not arbitrary. They are put in prior notice of the nature of examination.
That what you are saying that earlier same notification was there, it is considered by the division bench. There is no finding regarding that condition is wrong or.
Please, my lord.
But how will you operate for SC/ST that?
Insofar as SC/ST, it's a very novel argument. SC/ST minimum prescribed is, then you have to give 5 marks. We have got 2 separate lists, my lord, for SC/ST separate list and general merit. So what the position is if you're putting minimum, when only 3.3, when Viva is to be held. There's no question of Viva. 3.3 speaks specifically about when Viva condition up.
For making that SC/ST separate list.
Separate list itself, my lords.
That might
So
not
on the
be
basis of merit, number of seats, vacancies, a separate list, or whatever is there, it will be filled up. They are not agreed in that sense, my lords.
On the merit there.
Yes, absolutely, my lords.
That
So
might not be
therefore,
permissible.
to saying that because we are not prescribed minimum, giving additional marks, nobody has failed, because, or nobody will not be getting.
Oh, if they are clubbing together, then relaxation will.
Absolutely, my lord. About on to your lordship.
It can't be, my lords, kept separate. The most meritorious candidates of a scheduled caste, my lords, by virtue of all the judgments, will sit as a general merit candidate. He can't be segregated and kept only in a scheduled caste category, my lord.
That is for filling up.
Yes, that is
But
how it
therefore,
is.
not for.
Do no.
My lord, yes.
See, they will give any marks.
Yes, my lord.
See, scheduled caste candidate who has secured in the top.
Yes, my
if he is secured more than that general category, he will be come to the general category.
But they are keeping it
Person
separate.
who is below in that, he will come to the top.
Yes, my lord.
That is what
But they are keeping it separate, even by their
No,
own admission.
No, ultimately,
yes,
whether it will affect to that larger effect, nothing will be. Their right has been protected. That's what the. Let us see that how they will answer.
Yes, my lord. Even otherwise.
Yes.
My lord, one is the earlier judgment, my lord, of Kalburgi, my lord, the direction at page 57, 51, my lord.
Yes.
Kindly have a look at clause 3, my lord. The respondents are directed.
Yes.
To reconduct the Kannada language test, ensuring compliance with rule 4.5 of C&R rules.
Yes.
By prescribing minimum 100% marks, 100 marks to the test. Now, my lords, admittedly, the court has said you follow 4.5 of C&R rules. Today, they can't say, my lords, it has no statutory force, I need not follow it. My lords, assuming that that argument is also correct. My lords, today, what is held against me is constructive res judicata. Same should apply to them because before the division bench, they did not say these have no statutory force. Retest is because of the division bench, my lords. Division bench gives a specific finding. In the absence of negative marking in the rules and in the notification, you can't have negative marking. There, they did not raise a contention that rules have no statutory force.
No, see, court said that you can't have any negative marking.
In the absence of the rules.
Now that has been removed now.
No, I'll point out the finding, my lords. Court specifically said, in the absence of negative marking in the rules, you could not have prescribed it. I'll point out that, my lords.
Yes, where is that?
My lords, yes. My lords, 3 points were raised for consideration. I'll just take your lordships to those. Para 1 not, I'm sorry, my lord, in that petition, in the writ petition that your lordship. That writ petition 2328.
Yes, 2328.
My lord, yes, my lord. 3 questions were framed, my lord, which your lordships would find at page 121. My lord, internal page number 31 of that judgment, my lord, which is at page number 127.
No, this is division.
Yes, my lord.
Yes.
Yes. The 2328, that would internal page 31 of the judgment, division. Can I read from the top?
Yes.
The contention advanced by respondent number 1 KPCL that the condition applies by implication is untenable for multiple reasons. Firstly, negative marking was imposed only through admission ticket and question booklet of the 2000. It is neither prescribed in the rules, regulations, nor in the recruitment notification. Moreover, the admission ticket and question booklet cease to have effect upon completion of that examination. Here, my lords, they never said that rules have no statutory force, I don't have to prescribe it. When the court gave a finding, when it was argued that the rules specifically, my lord, I'll place, in fact, my writ appeal is here. I have taken a specific contention that the rules do not prescribe negative marking. My lord, they did not say rules have no statutory force, I don't have to prescribe. If today what is held against me is constructive res judicata, that this was not argued earlier, then, my lord, their contention that this has no statutory force can't be looked into.
Yes.
My lord, in fact, the judgment of the Supreme Court also makes a reference to that.
Now, what is that final order of the court?
Final order of the court was, you did not prescribe it before the exam, you can't prescribe negative marking after the exam. Now, my lord,
So that means to say you can prescribe.
before the exam. That's all that I'm saying.
Court said, if that rules doesn't prescribe, now you can't do it.
Yeah, that is why they said, my lords, if the rules don't prescribe, then you can prescribe it in the advertisement notification. If you don't prescribe it before the stage is crossed, you can prescribe it. But after the stage is crossed, you can't prescribe it. Now, my lords, here in this case, the recruitment notification does not talk of minimum marks. The 3.3 talks of minimum marks.
Now you will come to that final directions order of the court.
Roman 4.
Yes, operative.
Yes.
Page 124.
Yes. 143.
Yes, ma'am.
Yes.
120. I'm so sorry. Yeah, 143.
Yes.
The order of the learned single judge in writ petition so and so are set aside. The notification bearing number so and so, the final score list dated so and so, and the provisional score list are quashed. Respondent number so and so are directed to conduct re-examination expeditiously within a reasonable time for all candidates appeared in the examination on so and so pursuant to the notification. Re-examination shall be conducted subject to the condition of negative marking, and such condition shall be expressly communicated. That is all. It was only on the question of negative marking, my lords. Court never said don't follow 3.3 or don't follow. My lord, if your lordships were to...
On 3/8/2017,
yes, my lord,
there was a condition that they have not prescribed that passing marks.
No, my lords. They never said they will not do it.
That has been upheld court only in respect of that negative marking. They said that you first intimate and do it.
Can I put it this way, my lords?
Yes.
2017 notification never spoke about minimum marks.
No, it is not there in that.
No, my lords. It did not say we will not prescribe at all.
Where is that 2017 notification?
My lords, annexure B, my lords. Page annexure B, page 50. Your lordships may see, my lords, page number 43, my lords.
Yes, we got it. Where is that?
My lords, clause 6 is the selection procedure.
Yes.
The recruitment notification is silent about minimum marks. There was no minimum marks that was prescribed. It can be prescribed before I write the exam. Now, when I am writing the exam this time.
No, that earlier, what was their understanding then in the selection? If there is not prescribed.
Yes, my lord. They can prescribe it before the exam in terms of the recruitment.
That's what
rules.
that.
Yes,
now, what you will do that in earlier notification for examination is concerned?
It was first time it was
Just
cancelled. They
clarify,
did
my
not.
lords. Minimum prescribing marks when read the 3.3, what my learned friend is not telling is only when there is mandatory viva. It is written examination and viva.
No.
That is why they say that you have to get minimum passing marks, then only you will be eligible for viva. While 2017 notification, when all of these students who wrote the exam, they never were agreed by this notification saying that minimum marks is not prescribed, it is contrary to CNR rules. They never argued that. They are happy with that. Now, having
Yes, I understood that what you want to say. Yes. Yes.
I'm sorry, my lords. Viva is never a criteria for selection, my lords. T1 page 170.
Selection will be made purely on the merit basis duly following reservation policy. Merit list will be prepared based upon the marks obtained in the written test.
Yes, my lords. Page 177, my lord. Your lordships may see. Only for written test.
Yes.
177 is the amended rules which were in force. It did not prescribe any viva voce. It only said qualifying exam, and that's page 177.
No, earlier also there is no passing marks for written test.
Yes, it can be prescribed before the exam. Notification need not prescribe it at all. That is where, my lord, I read Tej Prakash.
No, even examination is not conducted there. Before that,
my lord, it was conducted, cancelled. Second time conducted.
Is there prescribed before that
No,
examination?
my lord.
Then earlier also there is no.
Yes, my lord. Now kindly come to page 177, my lord.
Yes.
The amended rules.
Yes.
Yes. These are the amendment. For the written test to be conducted, MB will nominate the authority to conduct the written test. Specify the minimum pass marks for general category with relaxation.
Yes.
This clause, this portion of the clause is retained. What is amended here is instead of viva voce, there will be a qualifying exam and a written test. That is all that is amended.
Yes.
My lords, their contention is in the earlier time we did not prescribe, therefore we need not prescribe, my lords, may not hold water, because when the retest is being done, it has to be done in accordance with these rules. Now to say, my lords, these rules have no
But division bench said conduct in terms of that notification dated so and so.
No, my
That
lords,
has been affirmed
conduct pursuant to the notification.
Pursuant to that notification
Yes.
means same. Except changing in respect of that negative marking, all other things has been upheld till Supreme Court.
My lords, no, all other things were never an issue before the court. All other things were never an issue, because when the calculation of the marks itself was wrong.
But nobody is agreed for that passing marks.
My lords, we are aggrieved.
No, last
Because
occasion you have-
everybody is selected now, my lord, without any passing marks. Now, my lords, without a passing mark, everybody, my lord, what happens is, my lords,
Then they will take on merit.
my lords, it can't be done that way, because minimum marks will have to be prescribed. My lords,
No, that
Yes.
you have argued on that. Why that if it is clubbed together, if minimum marks is not fixed, then it will affect that reservation.
Yes, ma'am.
Now they are doing to separate this thing.
My lords, my respectful submission is, my lords, that is even the recruitment notification or the rules don't prescribe for separate one. My lords,
ಅವ್ರಿಗೇನು ರೂಲ್ಸ್ ಇಲ್ರಿ ಅವ್ರು ಹೇಳ್ತಿರೋ ಪ್ರಕಾರ they can do
my lords,
whatever.
then recruitment can't go on. Please have a look at this, my lords.
Yes, yes.
In the entire
What
case,
they are saying, notification itself is the rule for them.
my lord,
When there is no prescribed rules, what is the notification which is, this is the rule. If you are agreed, you can challenge that. That is what that.
my
now
lord,
that.
then
If there
the
is no
earlier
C&R,
direct,
yes.
my lord, then the earlier direction of the single judge
Yes.
to follow 4.5 of the C&R rules. My lords, they have not challenged this, where they said that you follow this.
Exactly. Division bench.
No, my lords, this was not carried to division bench.
Which one?
The Kalburgi bench.
No, that
judgment.
is there that.
There was a direction to follow C&R rules.
Yes. No, they said condition in that. See, if you use the word C&R, they immediately strike that it has a statutory force.
My lord, yeah.
They use that C&R, but it is their circular. You take it as in a circular.
My lord,
According to them,
yes.
unless they have to satisfy the court,
My
what
lord,
they are saying.
page 51 of the judgment, they say you follow this rule, C&R rule 4.1, you follow.
Yes.
My lords, they don't challenge that. Now they can't say I will follow 4.1 and forget the rest.
That is for them. See.
Yes,
their-
ma'am, I'm
their-
just answering their
their court said that this is the circular, you follow it. If they want, they can pass in another circular and make it amended, but they want to follow it. Therefore, they have not challenged that.
Yes, it's the same circular. 4.5 and 3.3 are different portions of the
No,
same circular.
See,
Yes, ma'am. And
yes, if it is in a statutory rules,
Yes,
C&R,
yes, ma'am.
they can amend any part of that C&R procedure has been prescribed.
Yes, ma'am.
Now they are saying that it is in a circular, it has no statutory force.
Yes, ma'am.
If any other notification is issued,
Yes.
it is superseding earlier. That's what their
Yes,
case
ma'am.
is. Because that has no statutory force. That is what that arguments of the.
Yes, ma'am. But there is no
Advocate
other
General will
notice.
see how they will.
There is no other executive order rescinding these amended rules, my lord.
No,
They are
that is
called
what
rules.
that-
I can.
yes,
Yes, my lord. My other argument of Hyderabad, Karnataka, my lords, 2 separate exams have to be held.
Yes, that's.
That is the second argument, my lord.
Yes.
Both the circulars,
Yes.
2016 and 2025, which they say they will follow, prescribe 2 different set of examinations.
Yes.
That
which is-
can't be.
Which is that.
My lord,
circular?
annexed Z and Z1, my lord.
Yes.
The very last notification,
Z1,
page
Z.
number 234. Can I draw your lordship's attention from 233 onwards?
Yes, yes,
I'll complete, my lord, in the next 5 minutes. My lord.
yes,
233 onwards.
yes.
My lord, 233.
Yes.
ಮಾನ್ಯ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ದಿನಾಂಕ 23/9/25 ಆದೇಶದಂತೆ ಎಇ ಜೆಇ ಕೆಮಿಸ್ಟ್ ಮತ್ತು ಕೆಮಿಕಲ್ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಾತಿ ಈ ಕೆಳಕಂಡ ಮಾಹಿತಿ ಆಗಿದೆ.
Yes.
No, my lord, they specifically 10/12/25, my lord.
Yes.
Clause 3. my lord.
Yes.
ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ 3625 ರಂತೆ ತಯಾರಿಸಲಾಗುವುದು.
Yes.
My lord, we objected to it. My lord, just take ಕ್ಲಾಸ್ 3 ಮಲರ್ಸ್ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ 3625 ರಂದು ತಯಾರಿಸಲಾಗುವುದು. Now if your lordships were to see
You read that whatever it has been happened for that.
yes my lord, for if it is already one exam is done, it's all right. You prepare it in that manner. Last portion munduvaredu henceforth you shall conduct 2 exams. Once they say my lords that they will follow this, they have to follow this.
Yes.
Right, and for this there can't be constructive res judicata because they say 3625 is the circular that we will follow.
Yes.
And that was published in 1012 my lord.
Yes.
1012 and 2412.
Yes.
At least to that extent my lord, I am entitled to success. That's my
Yes, Mr. You also let him finish, and what is that on Kannada I will also say. Yes. Which is your repetition, Mr.
No, 953 of 26, my lord. 953 of 26.
Yes.
In the morning, my lord, I have passed on the
Yes.
synopsis, my lord. With kind permission, my lord, I will argue on the basis of this synopsis, my lord, to cut short the. My first submission is, my lord, of twofold, my lord. The Kannada examination, which is conducted by the KEA in consultation with the KPCL, my lord,
Yes.
is wholly impermissible in view of the judgment rendered by the Geeta Chavan case, which has attained finality and the examination was held
Yes.
according to the Geeta Chavan case. And that was not ever, at any point of time, that examination was not an issue before this honorable court after Geeta Chavan case.
Yes.
Why? Because, my lord, your lordship kindly see the events, my lord, which led to filing of the Geeta Chavan case.
What is that? Where is that Geeta Chavan case?
Annexure, your lordship.
You have produced in this.
I have produced the Geeta Chavan judgment, my lord. Kalburgi judgment.
Kalburgi court justice.
119, my lord.
11?
119 in my writ petition, my lord. My writ petition,
No,
I have
that-
filed annexure D, my lord.
Copy he has given.
Yes.
Yes.
The issue was there, my lord, why they permitted to hold the Kannada examination, my lord. At page 51, my lord, your lordship will get point 3, my lord. Order, your lordship got it, my lord. Final order, my lord,
Yes.
of Geeta Chavan, my lord.
Yes. Conclusion.
Yes, my lord. The writ petition is allowed the impugned endorsements while annexure Q and Q1 issued by the respondent number 3 are hereby quashed.
What is that endorsement?
Shoot towards my lord. I'll produce that endorsement.
Q1, Q1, what
I
is
have
that?
appeared in that. Ajay
Yes.
and myself appeared.
Yes. The respondents are directed to reconduct the Kannada language test, ensuring compliance with Rule 4.5 of the C&R rules of KPCL by prescribing a maximum of 100 marks for the test.
Yes.
Now, according to the KPCL, my lord, they held the examination.
Yes.
After this order was made, in terms of, my lord, 4.5 of the C&R rules,
Yes.
on 4/2/2025, my lord. On 4/2/2025, in my synopsis page number 3, my lord.
4/2/25.
Yes, my lord. Conducted the said examination in the descriptive mode, my lord,
Yes.
and which is valid, and till today that examination was never challenged by any of the candidates, my lord. So my humble submission is, this examination results of this paper were never in question at any point of time. Therefore, whatever orders that are made by the division bench and also the Honorable Supreme Court are not applicable to the Kannada examination, is my first submission. Kindly see the orders of the division bench.
No, that what was the notification earlier in Kannada examination? Where is
Yes,
that in the notice?
they have same notification, Lord, which was subject matter of division bench.
No, that's what notification in respect of
These
Kannada
two,
exam.
12/6/2024 and 18/5/2024 are the score list notifications, my lord.
Now, how that examination has been conducted for Kannada? What are the conditions?
Conditions, I will tell. Notification is there, my lord. Annexure A, my lord. Your lordship may kindly see, my lord. Annexure A, my lord.
2017.
Yes, my lord. 3/8/2017, my lord. There, my lord. Your lordship will get at page 35, my lord. Page
Kannada
35.
language
Written test, my lord. Kannada language test. Those who have not studied Kannada as one of the subjects in SLC or equivalent examination are required to pass a Kannada language test. Candidates who pass the Kannada language test are only eligible to be considered for selection process. Date and venue of Kannada language test will be published separately in KPCL website. Now, sum and substance of this is, my lord, that in terms of the recruitment notification, the C&R rules, they have to hold the Kannada examination test in terms of the SLC standard, my lord. That means descriptive in nature along with objective in nature, my lord. 3 times, my lord, earlier to this examination, 3 times they held it in a descriptive mode along with objective mode, my lord. 80 descriptive, 20 objective, like that, my lord. Therefore, suddenly, as on today, my lord, when they have OMR, suddenly they have turned it into OMR. Out of 100, they are entirely 100 marks they are prescribing as objective test. That is also bad. This is second ground of my attack, my lord, on the Kannada exam. Kindly see the division bench order now, my lord. Whether the division bench has at any point of time in its entire order, my lord, has made any observations regarding the examination that is held on 4/2/2025. That is the examination regarding Kannada examination after the Geeta Chavan case.
Now that we will come to that order portion.
Yes, ma'am. The writ appeals are allowed, 115.
Exam shall be conducted subject to that condition of negative marking.
This will hold, my lord. Your lordship, I will just clarify the facts and the dates so that my argument that the division bench has not at all prescribed any examination in Kannada, how it is emerging from the dates, that is very much visible.
We will see what is the direction.
Yes, my lord. The direction is the third point, my lord. Third point, your lordship may kindly see, my lord. The notification bearing number so and so, final score list dated 12/6/2024 and the provisional score list dated 8/5/24 are hereby quashed. They have not quashed, my lord, the Kannada examination held on 4/2/2025 because it was
This provisional selection list is prepared on the basis of that.
not on the basis of previous examination, my lord. The examination which was held prior to, my lord, 4/2/2024, there was one more Kannada examination that was quashed. So that after quashing that, my lord, these notifications have been issued. Now the third is very important, my lord. Third direction. What they are saying is, my lord, respondent number 1 to 3 are hereby directed to conduct a re-examination expeditiously and within reasonable time for all candidates. This all candidates they are interpreting as if all the candidates who are in the selection list. I have no grievance about it, my lord. All the candidates who are in the selection list has to write which paper is the question, my lord. The which that re-examination expeditiously and within reasonable time for all candidates appeared in the examination on 18/2/24 pursuant to the notification dated 3/8/2017. Now there is one more.
Candidates appeared in the examination on
18/2/2024. On 18/2/2024, your lordship will get who are the candidates appeared for which exams in my rejoinder, my lord, at annexure H, my lord, page 17. I have filed, my lord.
Kannada examination has been conducted separately.
Separately. It was there.
On 4/2/25 it has been conducted.
Yes. This was never an issue before the division bench, never an issue before the Supreme Court. Holding examination regarding Kannada examination, that too in a objective mode itself is a null and void, is my humble submission, because that was not an order passed by the division bench. Why? Because
What is the directions of the
18/2/24, your lordship kindly excuse me, lord. What are the papers that all the candidates?
What is that Gulbarga bench direction?
The Gulbarga, my lord, Geeta Chavan case, my lord. Annexure.
51 Roman 3.
Page 169, my lord. The direction is, my lord, I will just read the third direction which I have already read, my lord.
Yes.
Fourth direction, my lord.
No, the respondents are directed to
Reconduct the Kannada language test, ensuring compliance with rule 4.5 the C and rules of KPCL by prescribing a maximum of 100 marks for the test.
Then Kannada examination also they are directed to.
That is already over, my lord. This division bench order was complied by the KPCL separately on 4/2/2025.
No, this on 12th December 2024.
This division bench order was not challenged before the Supreme Court, my lord.
Division bench. This is single.
It is single judge. I'm sorry. This is single judge judgment.
No, after this Kannada examination has been held.
Yes, it is over, my lord. It is over. 4/2/2025.
No, they have held in terms of that rule 4.5.
Yes, my lord. We have no grievance, my lord. As far as that result is concerned, I have produced that result also.
No, by taking advantages of division bench, again they are going
Again, they have held the Kannada examination, which is wholly impermissible because nowhere, none of the candidates, my lord, who are party to the examination that is written on 4/2/25, they are not before the division bench, nor there is a direction to hold the examination regarding the Kannada language. That too, where there is no specific order to hold it in a objective manner. There are two aspects of my argument, my lord. If your lordship, first is that
cannot be a
there cannot be any Kannada examination at all. There cannot be.
My lord, the same petitioner has filed a writ appeal against the judgment also.
No, we are.
Which is pending. You should tell that.
No,
yes.
There was no stay, my lord. I cannot say that because of that, my lord, I am precluded from arguing the validity of the judgment. No, I will inform. Sorry, man. Senior.
Go and withdraw now.
I will withdraw, my lord. I will withdraw. Much water has been flown. Now that I will withdraw it, my lord. I will withdraw.
What is that second?
Now, kindly see, my lord, this annexure E, my lord, after what happened, Geeta Chavan, my lord, Geeta Chavan, the second limb of argument to hold, my lord, that it cannot be in a objective type. Annexure E, my lord, your lords will get it, my lord, at page 170, my lord.
Yes.
Here, my lord, the first Suchane nodadre, ಕನ್ನಡ ಭಾಷಾ ಪರೀಕ್ಷೆಯು SSLC ಹಂತದ ಪರೀಕ್ಷೆಯಾಗಿರುತ್ತದೆ ಹಾಗೂ ವಿವರಣಾತ್ಮಕ ಪರೀಕ್ಷೆಯಾಗಿರುತ್ತದೆ.
ವಿವರಣಾತ್ಮಕ ಅಂದ್ರೆ
Descriptive. Long answers. Now kindly see the present. And next annexure E1, annexure
only objective type.
Yeah, now objective type. At that time, when the Geeta Chavan case was rendered, this is the mode of examination, and based on that, my lord, Kannada examination conducted, and the results are at annexure E1, my lord. What 171?
Yes.
My humble submission and my argument is that whatever may be the examination regarding technical papers, they have to redo the technical paper examination and add these marks, my lord, these 171 page annexure E1 Kannada results to that and announce the selection list, because it changes the whole game altogether in two aspects, my lord. One is they themselves have conducted all the Kannada examination throughout whatever notifications they have made from the beginning till now in a descriptive mode.
Yes.
Having understood the examination as per the C&R rules as a descriptive mode.
Method they are adopting.
That is also very OMR sheet, my lord. Your lordship will get it. I have produced that notification also at page 102, my lord. The notification is there. Annexure F, my lord.
Yes.
And at page 203, clause 4, my lord. Clause 4, my lord. Page 203, my lord. Clause 4, my lord. Lordship got it, my lord.
Yes.
ಮೇಲ್ಕಂಡ ಮರುಪರೀಕ್ಷೆಗಳನ್ನು OMR ಮಾದರಿಯಲ್ಲಿ ಆಪ್ಟಿಕಲ್ ಮಾರ್ಕ್ಸ್ ರಿಕಗ್ನಿಷನ್ ಬೇಸ್ಡ್ ನಡೆಸಲಾಗುವುದು. ಅಂಡ್ ಇದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನವಿದ್ದು ಪ್ರತಿ ತಪ್ಪು ಉತ್ತರಕ್ಕೆ 1/3 ಅಂಕಗಳನ್ನು ಕಡಿತಗೊಳಿಸಲಾಗುವುದು ಅಂತ ಹೇಳ್ತಾರೆ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಕನ್ನಡ. One more mistake what they have done is annexure F1, my lord. After stating this, now they are telling that ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನ ಇರುವುದಿಲ್ಲ. At the top, my lord, your lordship will get ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ annexure 203, my lord, page F1, ಫಸ್ಟ್ ಒನ್ ಭಾನುವಾರ 28/12/2025 ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆ ಆದ್ಮೇಲೆ ಲಾಸ್ಟ್ ಕೆಳಗಡೆ, my lord, OMR ಉತ್ತರ ಪತ್ರಿಕೆ ಮಾದರಿ ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನ ಇರುವುದಿಲ್ಲ. That means no negative marking. On the one hand, they say, my lord, that it will be objective,
Where you are pointing out that?
that 203 is the ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನ ಇರುವುದಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ 203 ಅಲ್ಲಿ ಕ್ಲಾಸ್ 6 ಮಲೋಟ್ ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನವಿದ್ದು ಅಂದ್ರೆ ನೆಗೆಟಿವ್ ಮಾರ್ಕಿಂಗ್ ಇದೆ ಅಂತ ಒಂದ್ ಕಡೆ ಹೇಳ್ತಾರೆ, ಇನ್ನೊಂದ್ ಕಡೆ ಎಕ್ಸಾಮಿನೇಷನ್ 2 ದಿನ ಇದೆ ಅಂದ್ರೆ ಋಣಾತ್ಮಕ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲಿ ವೇರ್ ಇಸ್ ದಟ್ ಇಲ್ಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಇಲ್ಲಿ ಮೇಲೆ F1 ಅಲ್ಲಿ ಮಲೋಟ್ F1 203 ಬಾಕ್ಸ್ ಅಲ್ಲಿ 204 ಐ ಆಮ್ ಸಾರಿ 204 ಮಲೋಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ OMR ಉತ್ತರ ಪತ್ರಿಕೆ ಮಾದರಿ ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನ ಇರುವುದಿಲ್ಲ. ಯು ಲಾಟ್ಸ್ ಗಾಟ್ ಇಟ್ ಮಲೋಟ್.
ಇದು ನಿಮಗೆ ಎಕ್ಸಾಮ್ ಇದು ಲೇಟೆಸ್ಟ್.
ಇದು ಲೇಟೆಸ್ಟ್. ಬಟ್
ಅವರು ಏನು ಅಂತ ಅಂದ್ರೆ ಎಕ್ಸಾಮ್ ಹೋಗಕ್ಕಿಂತ ಮುಂಚೆವರೆಗೂ ಅವ್ರು ಏನ್ ಬೇಕಾದ್ರೆ ಚೇಂಜ್ ಮಾಡಬಹುದು.
ಅದು ಮಾಡ್ಲಿ, ಅದು ಮಾಡ್ಲಿ. ಐ ಆಮ್ ನಾಟ್ ಆನ್ ದಟ್ ಗ್ರೀವೆನ್ಸ್.
The petitioner doesn't have to write Kannada exam. He is
No,
agreed
no.
for somebody else.
No, I am.
He need not write Kannada exam in this.
No,
He has not.
He has not
No,
written.
what I am trying to say is, my lord, from the beginning, my submission is that I have already passed SLC examination. I need not write the SLC, the Kannada examination. But the very selection process takes away my right for selection because of wrong process. I am agreed by that.
No, see, you are the candidate who has taken a Kannada examination.
I am not. I am not the candidate.
How person who are happy?
No, my
taking
lord.
an examination. Why do you worry?
Why I am worrying is, my lord, my worry is this to this extent. No. The reason is this, my lord. Kindly, my lord.
No, they want this type of examination. They are happy. Person outsider, why do you want to question?
No.
them?
What I'm trying to question is, mal, because of this process, my ranking, which was at serial number 9, I have now taken out of the list because at that time, those who wanted to get eligibility by writing Kannada examination were very few candidates. Now, because of this objective type examination, lot of other side, outside state candidates have entered into, and they have pushed me down the list. I am not able to be selected because of this examination, Kannada examination.
For you merit, they have conducted an examination. You score it, go top. Don't take that others who will be scored top and he will come to effective.
No, the very wrong process which is adopted by the
Person who has affected has to be challenged
the
for the wrong
KPCL method is taking away my right, my rights to be selected is my humble submission. My lord. Secondly, my lord, will lords may kindly see, my lord, the
Yes.
the notification which the division bench has quashed, my lord, dated 12/6/2024 and 8/5/2024.
Yes.
Already, adರಲ್ಲಿ there is no question of holding any Kannada examination, my lord, because they cannot make use of that for the purpose of holding Kannada exam. The first they have to satisfy this honorable court whether holding of Kannada examination is permissible. If it is permissible, then only whether it is objective or descriptive will arise. My submission is because the direction was only with regard to negative marking on the technical subjects. At no point of time, this examination result, which was announced on 4/2/2025, was not even a subject matter before the division bench, before the Supreme Court. For the purpose of, my lord, just conducting the examination, it cannot be held, is my humble submission.
Yes.
Then, my lord, lordship may kindly see the Hyderabad Karnataka reservation issue. Now
You are also challenging that.
I am also challenging it because the non-Hyderabad Karnataka candidates are now fitted into non-Hyderabad Karnataka candidates category also. Because of that, my lord, I am outstayed by Hyderabad candidates who are present, my lord, in the
No,
recruitment.
your ground is also that they cannot be one examination. It should
That
be
is one. Second ground is earlier, my lord, for Hyderabad Karnataka candidates, they are permitted to apply under only that category.
Yes.
And they are not supposed to get selection under non-Hyderabad category. Now that option was there. Even if they apply by using the option regarding Hyderabad Karnataka, first they will be selected under the non-Hyderabad Karnataka merit list. If they are not available there, then they will be selected under the Hyderabad Karnataka list. That means what, my lord? That means a candidate who is not willing to come under the non-Hyderabad Karnataka category, they are forcing him to come and take away an eligible candidate who has got a selection criteria under the non.
There is no force him to come. If you don't want to come to that residual category, he can go back.
No, there is no such, they have taken out that option, my lord.
Municipal has been considered in that reservation matter.
Ah.
They can be first given option to that general merit. If they want to, still wants to there in that Hyderabad, Karnataka region, they can opt it and go there.
Now that, my lord, they will be selected under the non-Hyderabad Karnataka category.
Yes.
Earlier, they were not willing to come here because they were restricting their right to be selected only under the Hyderabad category.
Yes.
Now that by that process, my lord, a candidate who is selected under the non-Hyderabad category will be ousted.
Yes.
Because they are coming in, and I will be ousted, and some other candidates will be selected under the non-Hyderabad category, my lord.
Yes, that is what that reservation.
Yes, my humble submission is, previously this was not the situation which the KPCL has done it, my lord. They have given clear option for the candidates. Only who has applied under the Hyderabad Karnataka was allowed to go there, and he was never fitted into the north.
That was there. Then I think they have given a representation and all government has considered. Unless you say that that is wrong or illegal, then you can't. There may be earlier that was the procedure adopted. Maybe some other cases we have seen that. Therefore, after that they have given a representation and all government has reconsidered to give this method. Unless that method you show that it is illegal, I think there is no bar for them.
No, because it was never an issue. It was never notified in the notification, my lord, recruitment notification, that we are going to change the criteria regarding how to be the non-Hyderabad Karnataka candidates and the Hyderabad Karnataka candidates will be included in the same list simultaneously without there being any option anta ellu helilla in the notification. They have changed the rules of the game.
Get that they are doing.
Suddenly, after all the Supreme Court judgment, my lord, they are now saying after the selection process is.
No, even then, that there is two different examination has to be conducted. That he has pointed out that because whatever that recruitment notification process is completed, government said you go ahead with that. Subsequently, you have to do it separate.
Yes, what they are trying to say is
they will answer.
No, they are not saying, my lord, that they will do it separate. What they are saying is ಉಳಿದವರನ್ನ ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ಹಾಕ್ತಿವಿ.
No, that is maybe general circular is their government.
That is what. Yes. These are the. Earlier also 3 times they have done the same thing, my lord. Whatever earlier that Hyderabad Karnataka and non-Hyderabad Karnataka candidate should be selected separately anta enittu. Same thing they have conducted. Now suddenly what was the need for them to do it? Because I was ousted from the list, my lord.
Some cases it was been argued.
Yes.
I think in Gulbarga itself.
Please.
Saying that I think government circular or something has been issued after thinking that they are been denied.
Yes.
In referring to that some Supreme Court judgment, I think they have made it. Let us see how that AG will answer because he knows.
And the judgment which my learned friend has relied upon, my lord, the same judgment I am also relying upon to the extent, my lord, that the rules of the game has been changed. Even though there was no direction by the Supreme Court to hold the Kannada examination, they have conducted it, and there it was descriptive paper.
Preliminary objection is that who are you?
Because my rights are affected, my lord. Because of that, I was selected rank number 9. Because of that method of recruitment, that method of examination, number of candidates who were supposed to pass the Kannada examination, they did not pass it, my lord. And I was put into the top ranking list. I was selected there, my lord. Now, because so many non-Kannadigas have written the examination in objective manner, those who have scored even 9, 5, 10 marks, now they have scored 80, 70 marks, my lord. That itself has changed the entire matrix of the game.
Your merit will be assessed in the written test. They are only passing to come inside that
Yes.
they know the Kannada. You have to be compete with them that written test which you want to delete them before.
Why I am saying this was, my lord, this is very important, in my humble view.
Very important for your
For me, for me, for one reason, my lord, if the harder the eligibility, greater is the burden on the candidate to get the eligibility and then compete with the other candidates. Now that they have made the eligibility very smooth, the persons who are not eligible have become the eligible barely because they wanted to do it, even though there is no direction by the High Court or the Supreme Court, and they've changed the rules of the game by changing the descriptive into objective. That even that also they are not answering, my lord, because it is not the subject matter which allows them to change the descriptive into objective type, because the C&R rules which they are relying upon itself points out to SLC pattern, my lord, the Kannada examination regarding SLC pattern. SLC pattern, they have followed all these earlier 3 examinations. Now suddenly they have given a go by to that, and they are saying, my lord, that we have to write it in objective manner and you are eligible. By that method, my lord, I was at the top list, and number of people who were not eligible have become suddenly eligible, and they have thrown me out of the list is my humble submission. That therefore I have right, my right subsists till the entire selection process is completed. I have a locus standi to challenge this is my humble submission. Grateful, my lord.
Yes, Mr. You are there, Mr. A small submission, Lord. I am before your lordship on 2 grounds.
Now, which is your petition?
It will be 573 of 2026. 27.1. But I will not, my lord, trouble your lordship, my lord, repeating facts which my learned friends have already, my lord, brought to your lordship notice. My lord, you are the engineering graduates, my lord, who are eligible for being appointed, my lord, as engineers as called for by, my lord, the corporation.
Yes.
They applied for, my lord, the post, respective posts,
Yes.
my lord, to their qualification.
Yes.
And, my lord, they my lord, attended, appeared for the test, my lord, which was conducted in the year 2018.
Yes.
That is pursuant to the 17 notification. My lord, your lordship is aware that that examination was, my lord, cancelled by the
Yes.
corporation for the reasons, my lord, stated therein.
Yes.
And, my lord, thereafter, my lord, the modified notification was issued, and, my lord, in the 2018, my lord, examination was conducted in 6 centers, my lord, to cater the needs of the candidates who, my lord, spread over the entire state, to accommodate them to, my lord, appear to nearest to their place, my lord. 6 centers examinations conducted. My lord, the second examination, that is, my lord, in 24, my lord, was conducted only in Bangalore.
Yes.
Only in Bangalore. We could not appear, my lord, for 2024 examination.
Yes.
We are not challenged, my lord, earlier the notification or other examination, etc. My lord, your lordship is aware that, my lord, the examination conducted on 1824 was challenged before learned single judge, which was dismissed, and ultimately, my lord, writ appeal was allowed, my lord, on the ground of negative marking.
Yes.
My lord, your lordship is aware of that. My lord, in my writ petition docket, my lord, I invite my lordship to page 103, page 103, that where your lordship would get the operative portion of, my lord, the order of the division bench. My lord, the first one, my lord, writ appeals are allowed. Single judge order so and so is set aside. Next notification, the modified notification, score list, etc. hereby quashed. 1 to 3 are hereby directed to conduct re-examination. This is important, my lord. I want to put emphasis on this. Re-examination expeditiously and within reasonable time for all candidates. My lord, this is important. Appeared in the examination on 18/2/2024, pursuant to the notification dated 3/8/2017. Lord, it is the direction is very clear that it is, my lord, the re-examination is, my lord, confined to those candidates who appeared for the examination conducted on 18/2/2024. This is the specific order passed by the division bench. This order of the division bench was challenged by way of a special petition before the Honorable Supreme Court, page 105. So one Manjunath and others.
Yes.
But of course, my lord, this special petition was dismissed. But certain observations are made. Page 106. Page 106. Para 1, page
Yes.
106.
Hmm.
We are not inclined to interfere with the impugned judgment and order of the High Court, hence specially petition dismissed. Next, my lord. However, we direct that in the retest that has to be conducted as directed by the High Court, my lord, this is important. All the candidates who have taken the earlier test since quashed shall also be entitled to take the retest.
Hmm.
If any candidate due to passage of time has become age barred, the same shall not operate as a bar for consideration of the candidature for appointment.
Hmm.
Lord, the para 2, my lord, this is important. According to me, the Supreme Court wanted to, my lord, see that all the candidates who appeared for the test, the first test, my lord, which was cancelled, shall be given an opportunity to, my lord, write the retest that would be conducted by the corporation or CET. My lord, your lordship, I invite your lordship attention to Annexure B, my lord. Annexure D, page 41. In the first test, my lord,
Hmm.
my lord, the second, this is 8/6/20,
Page,
18
page.
to 2024, the
Page.
examination conducted.
Page.
41, my lord, page 41. This is a table showing.
Yes.
Annexure D, page 41. My lord, kindly note your lordship. Kindly.
Annexure C.
D, my lord.
Page 41 is C.
Next page, my lord.
Annexure D.
Yes.
Hmm.
Note your lordship. Kindly.
Hmm.
About 56,000 candidates were eligible to appear for the return state. Out of 56,000, only 18,732 candidates have been appeared for the return state held on 18/2/2024. The reason being, my lord, in most of the cases that the center is only in Bangalore center. Earlier, my lord, they conducted in 6 centers. So therefore, some candidates, they could not, my lord, know about this and appear, my lord, by traveling to Bangalore. Therefore, my lord, and out of them, the rest of it is may not be necessary. Now, what I submit to my lord is, my lord, pursuant to this, my lord, we have uploaded our credential to their, my lord, official website that they accepted. But only, my lord, 2 days prior to the 25th, when we wanted, my lord, to get our admission ticket, my lord, that website was closed to us. From the, my lord, the direction of the Honorable Apex Court, my lord, it is clear because, my lord, if they wanted to allow only candidates who appeared the, my lord, 18/2/2024, there was no need for the Honorable Supreme Court to make this observation because I have read it, the direction issued by the division bench. Division bench categorically in a, my lord, language, my lord, said that only those who have written, my lord, appeared for 18/2 are, my lord, entitled. If that is so, there was no need for Honorable Supreme Court to make this
Reiterate
observation.
ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. They have reiterated.
Yes,
That
no,
will
not reiterated. Next sentence, but if any candidate due to passage of time has become age barred, that is because, but 18 is, my lord, the
That is
test.
there. That they have not
18,
denied.
18. Otherwise, my lord, from 25 to 20, there is no question of
Yes.
using this, my lord,
Oh,
passage
age.
of time. Passage of time means it is little longer, not 4 or 5 years.
No, now on the basis of the age, anybody is denied.
No, not that, my lord. We were not allowed to, my lord, get the admission ticket because they have confined this retest as directed by the division bench to those who appeared in the examination held on 18/2. We were not given opportunity at all.
You have appeared in 18/2.
No, no, we have not.
Then how can you?
We have not, my lord. That's why, my lord.
No, what is that Supreme Court said?
Supreme Court, that's why, my lord, para 2, page 106. Para 2, your lordship can see.
Yes.
However, we direct, my lord, after declining to, my lord, interfere in the order of the division bench,
Has to be
the
conducted
Supreme Court
as
makes
directed by the
observation
High
as per
Court.
para. However, we direct
Earlier
that in the retest that has to be conducted as directed by the High Court, all the candidates who had taken the earlier step since quashed shall also be entitled to take the retest.
The candidates who have taken that earlier test.
No, if earlier test means there is clear direction by the division bench, there is no question of Supreme Court saying anything. My lord, I have read it. The respondent
See,
1 to 3.
you forget about that. Now it's Supreme Court order is that ultimate. what Supreme Court said, all the candidates who have taken that earlier test,
No, no, earlier test means, your lordship kindly see.
Yes.
Earlier test
who
means.
was not eligible earlier, again, they cannot be given
No,
permission.
my lord, if
Yes.
there was no occasion for, my respectful submission is, there was no occasion for Supreme Court to make this observation. If they want, if the, because they have confirmed the order of the High Court saying that we decline to interfere in the order of the High Court. Still, my lord, they wanted to make certain observation, my lord, that is to say that all candidates, because your lordship kindly see, 18 examination was attended.
ಆಯ್ತು, ಅದ್ರನ್ನೇ ಏನ್ ಅರ್ಥ ಹೇಳಿ, who had taken the earlier test.
Earlier test, my lord, that may be correct, earlier test, in squash, shall also be entitled. My lord, shall also be means, along with the candidates who appeared for 18 to 2024.
Don't interpreting that judgment.
No, my lord.
Yes,
My lord,
yes.
otherwise, your lordship kindly see, otherwise, there was no occasion for the Supreme Court to make. They should have left it that, saying that we decline to interfere in the order of the High Court. That is sufficient because the direction issued by the division, kindly, my lord, under 103, my lord, kindly see that the direction is very clear. There is no ambiguity. There is no need for Honorable Supreme Court to make the observation because the, in the order portion, my lord, point number 3, my lord, it is respondent 1 to 3 are hereby directed to conduct re-examination expeditiously within reasonable time for all candidates appeared in the examination on 18 to 2024 pursuant to the notification dated 3/8. If this is the, my lord, order, and when Supreme Court said we don't want to interfere in the order,
Yes.
why, my lord, this observation? This observation is only to see that, my lord, all the candidates who appear for the test conducted in the year 18.
Yes.
Otherwise, my lord, you lordship see the, ultimately we have to interpret the based on, my lord, the language couched in the order.
Yes,
Kindly
yes.
see, my lord. Also be, shall also be means along with those who appear.
Also, who has
Also
applied,
be.
who has applied. You are all applied for that.
Yes, we have applied and appeared for, my lord, 18 examination conducted in the year 1918. 18 we appeared. That was cancelled. 24 we could not. Now the Supreme Court says, my lord, who had taken the earlier test since court shall also be means, shall also be means with the candidates who appeared
Yes.
for, my lord, the examination which was quashed.
Yes. Now you are going back to that one exam early,
My lord, you
which has
last-
been cancelled by that
Cancelled
board,
is by the corporation itself
corporation.
on
Yes.
the ground of some malpractice, something like that.
You
Anyway,
want to
that
say-
was confirmed, that order is confirmed. I don't want to say anything on that.
Yes.
But, my lord, because of this para 2 and 3
Yes,
in the
yes,
order
yes.
of the Supreme Court, my lord, the intention of the Supreme Court is to allow all the candidates who appear for the test which was cancelled to write the, my lord, the retest that would be conducted
Yes.
as directed by the division bench.
Yes,
My
let
lord,
us see how
that
they
is,
will
my lord, my
answer. Yes.
My lord, another one, my lord, we have
Which
stated
date-
so many
no,
repetition.
Which date you have taken examination?
My lord, on first, my lord, which was cancelled. My lord, that is 21/1/2018.
Yes. Yes, that's all.
My lord, we have taken a ground, my lord, in the writ petition itself. There is no counter, my lord, denying this. My lord, we were allowed to upload our credentials by the corporation in their website. But admission tickets were denied.
Yes.
They have closed the website to us.
Yes.
That's why we could not appear for
Yes.
examination which was conducted as directed by the division bench.
Yes.
But only 2 days prior to, my lord, examination, they blocked, they closed the website.
Yes.
That's why we could not. Otherwise, we have uploaded all our credentials.
Yes. That's all. Yes.
Just answering my learned friend Prakash, my lord, the objections are ready. We'll file it by tomorrow, my lord. In the second round of litigation, that's the second examination, my lord.
Yes.
The learned friend's clients were not parties to the proceedings because they're not written the exam.
Yes.
So there are two things. First was withdrawn, my lord, as a lordship. Only thing which was quashed is the second exam. The
Yes.
Supreme Court clearly says people whose examinations were quashed or written, they are eligible. It doesn't take back to the first examination which was cancelled.
Yes.
So therefore, my lords, it doesn't revive an existing right which has already given a closure pursuant to the first examination, my lords. This is again just a game of chance, my lords, where they're trying to say that by virtue of the Supreme Court order to which they're not neither before single judge, division bench or Supreme Court, they're a party, neither taken the examination, they have a vested, they have a right accrued.
Yes.
And one more thing, the age relaxation is only given, all those things have been given only for those of those who have taken the second examination. I'll just read this. We direct that the retest has to be conducted as directed by the court, High Court. All the candidates who have taken the earlier test since quashed. What is important is only regarding the quash shall also be entitled so and so. If the candidate due to passage of time has become age barred, the same shall not operate as bar for consideration of the candidature for appointment. That's very clear, man. So therefore, it doesn't say that people, the examination which has been cancelled,
yes,
they are entitled to, malos. Insofar as, malos, the petition with regard to Hyderabad, Karnataka, malos, that is what is the
no, that you give that reply to that Santosh Nagarale case.
Please, Malad.
Because these are all only 2-3 grounds. Then we will go to that
please, Malad.
Final reply to that Prithvi's case.
In that 2 grounds, Malad, in this matter, that is first. There are 2 issues in that Santosh Nagarale's matter, Malad. One is regarding Kannada, Malad.
Yes.
If your lordship may kindly see that petition annexure B, clause 8, Malad. What is required to be done in that as per clause 8 is he needs to pass the Kannada examination, Manoj.
Page.
The page is yeah, page 8. Annexure, which petition? Yes, WP number 953, Malot.
Yes, yes.
That is page 40, Malot, clause 8.
Yes.
What was read out to your lordships, Malot? Kannada language test. What is important in this? No, this is. So, okay, this is that's why. Your lordship may kindly see this, Malot. Those who have not studied Kannada,
yes,
as one of the subjects in the SSLC or equivalent examination are required to pass Kannada language test.
Yes.
Then candidates who pass the Kannada language test are only eligible for consideration for the selection test.
Yes.
So therefore, my lords, my first preliminary submission to this is, my lords, writ petition is not maintainable at all, my lords.
Yes.
For the simple reason, my lords, he need not take the examination because he has studied Kannada examination.
He is not an aggrieved person of that class.
Under this.
Yes.
And his grievance is like a thing, my lords. If they become eligible, it is not eligible, then they'll become more meritorious. So I don't want other people to be eligible. And
yes.
So therefore, my lords, any person who can be aggrieved by the test conducted or any error is a person who has taken the test under clause 8.
Yes.
Either saying that the earlier test you should have taken my earlier test marks.
Yes.
Pursuant to the High Court order, or you could not have conducted a retest,
yes,
or on the ground that it is multiple choice and descriptive answers. So therefore, my lords, the
yes,
candidates who have taken the test under clause 8 are not before the court. When they have no grievance, my lord, at the instance of the petitioner, this petition is not
yes,
maintainable, my lord.
Yes.
Insofar as Hyderabad, Karnataka, my lord, I'll just point out that while replying to that, the various judgments which this court has dealt with, my lord, where recruitment, my lord. The notification of 2025 is a clarification of the 2016 notification, my lord. It only says that, my lord, like scheduled caste and scheduled tribe, my lord, saying that if Hyderabad, Karnataka students are available, my lord, they go on the merit list for non-HK region, then leftover will go get filled up in HK. So therefore, my lords, to say that then there are conflict, I'll produce those judgments which this court has dealt with similar issue, my lord.
No, he is saying that they have to conduct two different
No,
examinations.
no, examination is the same. What he is trying to say, subject to correction, when you fill up an application for HKE region, you cannot take selection in the non-HKE.
First he is saying that examination has to be conducted separately.
No, expedition, I don't think that's a contention, my lord.
Yes.
But
That
there's
is-
one single examination.
No, that your circular, government circular says it should be separate. That is what he has read out. You come to that annexure Z1.
We'll clarify that, my lords, with regard to this 16th circular has been subsequently that has been modified with 3625, right?
Yes.
Clarified, my lords.
Yes.
Page 235
WP.
WP 2328.
In fact, my lord, I'll come back to that and clarify that with regard to the June 2025 clarifying 2016.
Yes.
Which is raised in my learned friends, Nagaraj, Santosh Nagaraj.
No, that
Lakshmi's case. When you got it only yesterday, my lord, we'll just.
No. In 2328 of 2020-26, annexure Z1, where your director has issued saying that we further clarified that notification dated 3/6/2025. Accordingly, both notifications are applicable to that examination scheduled to be held on 27/12/2025 and 28/12/2025.
Net 233 previous page.
Yes.
I'll get back to that, my lord. To be honest, my lord, they're
Yes.
not, I have to get proper, correct
Yes.
information, but so far as saying that mode of selection, not the test, my lord, this court has already dealt with it, my lord. Then coming back to other contentions, my lords.
Yes.
Can I give a note which has been prepared, my lords? Which is-
No, that Lakshmi Narayan and Murthy, you can take some other date instead of waiting.
May I request that we have it on Friday?
Friday, bada. Friday,
Kindly
Friday.
have it on 11th, my lord, Wednesday.
11th. Yes, 11th.
12th one.
12th. Yes, 12th. Yes. Which date you want? ಸೋಮವಾರ ಮಂಗಳವಾರ ಅವರು ಇರ್ತಾರೆ. 11th or 12th? 12th, yes.
12. Serial number 28.
No, I think your matter will be reached before 12 because it is the first in that B group. Today, otherwise it would have been reached as 12:30 itself.
But the effect of your lordship's order is going to be one of its kind in entire territory of people.
Yes.
Though the engineering medical college unaided.
Yes.
Whether class for employees are paid by the pay scales of state government are not easily possible.
I thought on that day 4 o'clock. Yes.
Last week and ಏನಾಗಿದೆ Supreme Court ನಲ್ಲಿ, whether you are earning profit, whether you are earning loss, you should pay the state pay scales. All state governments have been asked to file an affidavit. So whereas Karnataka, they didn't file it. They took time.
I will see. I don't know. I've forgotten what is the case and all. On 4th, on that day, we'll yes recollect. 13 ಅಲ್ಲ 12. No, you do one thing on 12th at 2:30. 2:30. 12th 2:30. 2:30 it's huh? Yes. 12:30. then you will know that 18th.
ಇಲ್ಲ ಬೇಡ, what I am appealing to my learned friend, 4 o'clock 12th I start, let him not come here, but let him be there in office, next day ಬರ್ಲಿ.
He is also seeing that.
Concern for me, I am very happy about it.
No, he is concerned about you, but he is not concerned about the court. See, if I am in that, yes. See, like this matter, I am in that middle of that in the 4 o'clock. Either I can't call your matter or I will not complete that. That is what that Narsimurthy is telling. 2:30 we can give a break. 2:30.
4 o'clock.
Yes, let us hear that. 4 o'clock. Yes. Yes.
ನೀವು ಆಫೀಸಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ ಪರವಾಗಿಲ್ಲ.
Yes. 4 o'clock. Yes, on that day, if he's, you can give some other day for you if he's concluded. Yes. 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 Mm.
February 2014, 13th February 2014 and 20th April 2014. One of the totally what is important is also to take page number 7 for a moment. Page number 7. The total sanction strength, my lord, is 1742.
Where you have mentioned?
That is page 7, end of page 7, my lord.
Yes, 1742. Yes.
Number of posts filled up by the law recruitment in 2014, that is first stage. Your lordship, one of the argument was argued 2 stages it should be.
Yes.
So first stage was, my lord, 615.
Yes.
Second stage, which is the subject matter now before your lordship, is the second stage, my lord.
Yes.
Number of posts for recruitment was conducted for 622.
Yes.
In that, my lord, the total number of candidates who wrote is 6482, my lord.
Yes.
9482.
Yes.
9482, I'm sorry.
Yes.
So therefore, my lord, insofar as what has been quashed by this court is insofar as 9482 is concerned.
Yes.
Of second stage, my lord.
Yes.
So therefore, my lord, in spite of having filled, if we fill 622 also, my lord,
Yes.
there'll be a further vacancy of 470. The
Yes.
point I'm trying to make is, my lord, and this has been going on from 2014 to 2026, past 12 years. This is the third round of litigation and third examination.
Yes.
So therefore, your lordship, this is the basic facts, my lord. Then your lordship will get page 1 and page 2 is the first examination which was held on serial number 4, my lord, on 21st January 2018, my lord. Then, my lord, we withdrew the examination due to certain malpractices. Writ petition was filed to direct to continue with the examination. Then this court dismissed the writ petition and writ appeal, and the matter went up to Supreme Court. Our cancellation was upheld, my lord.
Yes.
Then the second round of litigation at serial number 6, second examination is at serial number 16, my lord, page number 4. Page number 4.
Yes.
I've just put the heading as second examination, my lord.
Yes.
Multiple challenges, my lord. Re-examination was considered. Final score was published, serial number 17,
Yes.
on 18/5/2024. Public provisional list was thing, my lord. The most important, my lord, in this, 1/3 negative marking was given. What is important is, my lord, the original notification 2017
Yes.
did not speak about negative marking. It came only in the hall ticket.
Yes.
So out of 9,000 and odd, my lord, around 25 people went to the court
Yes.
saying that we did not know about this negative marking out of all the numbers, my lord.
Yes.
Court said, was it part of the, not the C&R rule does not speak about it. Your notification does not speak about it. At the last moment, people might not have read your hall ticket.
Yes.
So you're not informed much earlier
Yes.
to these people.
First exam, second exam, hall ticket.
I'm sorry, I stand corrected. because we are in the first exam, we had mentioned in the hall ticket. Second examination, we are not, this examination, we are also not mentioned in the hall ticket. We presume that they had knowledge. Court said that neither in your 2007 notification or in your hall ticket.
Yes.
So therefore, on that ground, my lords, it was quashed. I'll point out to the division bench judgment, my lords, to show that the examination was set aside by the single judge, confirmed by the division bench and the Supreme Court.
Yes.
And the review petition also came to be dismissed, my lord. Now, in the side in Dharwad High Court, my lord, what your lordships were read, my lord, Justice, Honorable Justice Sachis Mugdum judgment with regard to Karnataka examination. There also, my lord, the short point in what Rule 8 and Clause 4 point says that, my lord, he has to pass the examination. To pass an examination, there should be a minimum criteria, unlike for others. So if you're saying conducting a march for 150, or you should tell it talks about 100, then you should say what is the minimum mark so that he knows while going what should he score.
Yes.
So therefore, again the point number 3 in that judgment was put them in notice. You find out what it is. You do it after telling them. Yes. The whole point in both the cases with regard to negative marking or Kannada, prior notice, no information was given to them. I'll just point out by reading the those two judgments. Ultimately, my lords, what is the direction issued to us? Is implement the 2017 notification. Supreme Court says do it within 4 months.
Yes.
We have strictly complied with the 2017 notification, my lords, and we have held the examination within 14 months. So the only, now coming to answering the grievance in the written submission, which I'll just answer the written submissions with written note given by my learned friend, my lord, one by one, so that it, Prithvish has given, so that it's not, where is it? Okay, I've got it here. I've got it here. I've got it here. I've got it here. I've got it. Your lordship may kindly see dispensing with minimum qualifying marks is illegal, my lords. If your lordship sees first point, my lords, A in this summary of contention, my lords, my learned friend summary of contention, my lords. Page 1, my lords. First page summary of contention. Yes. Not mine, my lords. My learned friends.
Yes.
So I'll just reply to my learned friends.
Yes.
Summary of contention. Yes. Contentions, my lords. Is seeking to challenge the 2025 publication for holding the examination. He doesn't challenge the 2017 notification, and he cannot challenge also because
it's concluded by Supreme Court.
And there's a positive mandamus to do it as per that. Now the question is, he's not able to point out that we have violated the 2017 notification.
Yes.
So therefore, he has said not challenge because we are bound to imply. He has not challenged that, and all these people, and these people are the same people who have taken the person to the 2017 notification.
Yes.
Because it is quashed. So therefore, my lords, neither when the test which was conducted, the previous examination and this examination, there's absolutely no change except for the point, my lords, in so far as negative marking is continued because we have put them on notice as per the division bench judgment. What we introduced is, my lords, sometimes what happens while 4 choices were given, they used to say because of negative marking, my lords, the person does not know the question. Sometimes because OMR sheet, my lords, it's not very clear as to whether they have marked or not marked.
Yeah.
So what we gave a 5th column. I don't know this answer. So that no negative mark is in the interest of the candidate, saying that you put this, make a 5th choice so that you do not get
that confusion will not arise.
That confusion. So therefore, my lords, whatever we did, the question is no prejudice is caused to the candidate. It is in the interest of the candidate. It's not, question is you can find fault. The question is what prejudice and this is caused. So therefore, my lords, and going by again the second 3.33, my lord, this says where written examination, can I permit you to read 3.3.3, my lord?
Yes.
I'll just read it. Your lordship need not go through it, my lord. The only point here is that is at page 144. Yes. Lordship may kindly note the page number. For the written test to be conducted, the MD will nominate the authority to conduct the test, written test, specify the minimum marks for general category with the relaxation of 5% for SC/ST candidate.
Yes.
That is one aspect of it. Second is such of the candidate who pass the written test will only be appeared for Viva OC subject to rule 3.34. So therefore, my lords, however, a written test is conducted in relation to the post of specified so the visa OC will be limited to the ratio of 1:5.
Yes.
So therefore, admittedly, my lords, nobody is agreed.
Yes.
Here saying that, my lords, earlier also there was first, second test, there was no Viva OC.
Yes.
Nobody's case was you have violated 3.3 and conducting the test. So minimum marks will arise or this condition will arise only when you are saying that
Yes.
these candidates are allowed to be taking for, unless you get a minimum marks of this, you are allowed. Here, it is strictly on the basis of inter se merit,
Yes.
either for scheduled caste, scheduled tribe, or for the general category.
Yes.
For example, Malos, if assuming in the worst scenario, there are 100 candidates,
Yes.
100 seats for general category. If I put a minimum mark of 60, if only 40 come, then we are failing somebody.
Yes.
Here, what we are saying that we are going to make number of candidates seniority
No, that intention is that all post has to be filled.
filled up, and we have got another 470 to be filled up in future. And past 2014 to 2026, no vacancies has been filled up nearly for 12 years. So therefore, my lords, again going back to the point,
Yes.
how is the petitioner prejudiced or affected by not prescribing the minimum marks? And second point is 3.3 applies only when Viva OC is to be conducted. And all these candidates had knowledge, my lords,
Yes.
that there was no minimum marks
Yes.
either for, therefore, my lords, misplaced sympathy, saying that in the name of scheduled caste and scheduled tribe, you are not, as if we have not given them the benefit because they'll get affected. So it's such a, well, we got a separate list for them. On those people, number of candidates, my lords, we'll fill them up. If they're merit, my lords, if they come in general merit category, we will fill them up in the general merit category.
Yes.
So therefore, to say that we have not fixed a minimum, then giving them, it's like saying, put a number, delete minus so much, then give plus marks. Need not be done.
Yes.
My lord, that is point number A and B, my lords. HK, my lords, I'll just come back to that, my lords.
Yes.
Page 2, serial number 3, my lords. C, my lords.
Yes.
Merit list based on written examination in ultra virus, which also, so therefore, my lords, A, B, and D are the same points, my lords, which I just made. My lords.
Yes.
Then I need not answer. So therefore, my lords, I'll have to get back to your lordships only on point number C, my lords.
Now that you have to answer, what is that C&R?
My
How
lords,
it has been framed? What is that effect?
your
Where
lordship
is
may
your
kindly
power
see
to
one.
frame that C&R?
My lords, so therefore, both the judgments, my lords, which division.
Not answered there.
They have not answered. They have also said not, even though they have not said whether it is binding or not, they have answered in saying that you put them on notice and you can go ahead in spite of it not coming in C&R rules.
No. See, your is the board.
Correct, my lord.
It is board is created under which statutes?
That is under the Karnataka. Board is created under the Karnataka KPTCL Act.
No, how that board has been created under which statutes?
There is no statute. It is not created as, it was a department of the PWD. It's got bifurcated and created as a company under the Companies Act. It is not a statutory corporation.
It's a company.
It's a company.
Then now
100%.
what is that service conditions and all of the employees of your company?
Board fixes. Under the articles of association of the company, board has the.
We have that articles of association.
Not placed, not on the record. No.
Also, that is the point where you will get this power for framing. You may
Passing
call
the
it
board
is rule.
resolution or to do the C&R rules where it is.
It is like any other company.
No.
It is like any
No.
other company.
No,
You
if
have
it
to
is
place
a
it before
company, you have that articles of this thing. Under that, you have any power, what you can be.
So the board has the power to do everything.
No, we'll place it, we'll go through it and place it
Just
before.
go through and place it that.
I have
Otherwise,
not
by
examined that, my lords. I'll look
yes,
into that and.
by reading that, it shows that C&R, you are using that same word C&R. What that normally using in that service
Correct,
matter.
service.
It's under either Article 309 or under civil service.
No, we'll just,
cases.
honestly, we'll study that aspect and the Hyderabad, Karnataka thing.
Two is the
things.
major issues, yes, that has to be answered. Yes.
Can I
Tomorrow.
request, my lords, my learned friends are not there tomorrow, day after tomorrow, my lords.
Day after tomorrow, Thursday. Friday, no. Friday
Monday, can I
only for
request?
Monday. Yes, Monday at 2:30. You have no, there is no any.
Now they have become 3 tests they have already conducted for us. They are fully prepared.
No, you are keeping busy.
Fully occupied.
Yes, let us see that. Yes. Yes.
I just got a copy of the full rules, of course, not the schedule of it. Can I
Yes.
just pass on that?
Very good.
The only thing is that I just wanted to show to your lordship. Of course, this has, it looks like it has all the trappings of a C&R rules.
Yes, yes.
Let's from the first chapter, my lords. Last.
These are all the employees who are working in that KPTL. They have been, they might have been advised to make this type of rules.
Yes, 1.3.1, they say 3.1, my lords.
Yes.
These rules shall apply to all persons appointed and to be so appointed. So even for recruitment, my lords, this follows. And last one, my lords, repeal and savings. They repeal rules of 1992. 20.1 KPCL cadre recruitment probation rules 1992 are hereby repealed.
Yes.
So probably, my lord, we'll have to look at the 92 rules to see the source.
Yes.
I'm just.
Yes, that we'll see. And yes. Impleading applications, you can argue.
Let's barred by res judicata because earlier round impleading was not allowed. No, my lord, it can't be. No successful, no select list only.
No,
Yes, they can file appeal, my lord. I have no difficulty.
If I hear and the application is allowed, challenging that and all, instead of that, this is the, what are the questions you can also argue. Even if that order is goes against you, you can file an appeal. There is no bar. Why you want to be impleaded? You want to be impleaded to argue the case. I will permit you. Or if you go against that, you can easily file an appeal. Instead of that also, you can file an appeal. Let us. Yes.
Yeah. That's right.
Let us see that. Yes. Pastor.
Pastor matter. Serial number 5, A. Nagarajappa, connected matter.
It's an order of suspension.
Yes.
We have complied the orders, your lordship.
Yes.
Impugned order, your lordship will find at page 31.
Yes.
Annexure F. At the operative portion of the order.
Yes.
Lordship at page 33. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಕಾರಣಗಳ ಮೇರೆಗೆ.
Page.
Page 33. Internal page 3 of the annexure F.
Which case?
My lord, 3089.
3089. Page 33.
Please.
Yes.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಕಾರಣಗಳ ಮೇರೆಗೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರಿ ಸೇವೆ ವರ್ಗೀಕರಣ ನಿಯಂತ್ರಣ ಸೋನ್ಸ್ 10 ನಿಯಮ 2ರ ಉಪನಿಯಮ ಮೇರೆಗೆ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಹಾಗೂ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ UDD 104 2014 9/1/2000 ರಲ್ಲಿ ಪ್ರಚೋದಿಸಲ್ಪಟ್ಟ ಅಧಿಕಾರಗಳಂತೆ ಶಂಕರ್ CS ದ್ವಿತೀಯ ಸಹಾಯಕ ಇವರನ್ನು ತಕ್ಷಣ ಜಾರಿಗೆ ಬರುವಂತೆ ಇಲಾಖಾ ವಿಚಾರಣೆ ಬಾಕಿ ಇಟ್ಟು ಸೇವೆಯಿಂದ ಅಮಾನತುಗೊಳಿಸಲಾಗಿದೆ. ಸದರಿ ನೌಕರರಿಗೆ ಕೊಡಲು ಪುರಸಭೆಯಿಂದ ಪಟ್ಟಣ ಪಂಚಾಯತಿಗೆ ವರ್ಗಾಯಿಸಿದೆ. ನಿಲಂಬನಾವಧಿಯಲ್ಲಿ ಸಕ್ಷಮ ಸೋನ್ಸು ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಕೆಲಸ್ಥಾನ ಬಿಡ್ತಕ್ಕದ್ದಲ್ಲ, ಅಮಾನತಲ್ಲಿ ಕಾಲಾವಕಾಶವನ್ನು ನಿಯಮ 98 ಜೀವನಾಶಾರ ಭತ್ಯೆಯನ್ನು ಸ್ವೀಕರಿಸುತ್ತಾರೆ. Lord, the allegation as such, my lord, is not, Lord, ಕೈಬರ ಅರ್ಜಿಗಳನ್ನು ಭೌತಿಕವಾಗಿ, my lord, your lordship will find at page 32, internal page 2, top, my lord, the para 2 is the allegation.
Yes.
ನಿರ್ದೇಶಕ ಪ್ರೌಢಾಡಳಿತ ನಿರ್ದೇಶಕರ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 23ರಲ್ಲಿ ಈ ಆಸ್ತಿ ತಂತ್ರಾಂಶವನ್ನು ಪರಿಣಾಮಕಾರಿಯಾಗಿ ಅನುಷ್ಠಾನಗೊಳಿಸುವ ವಿಚಾರದಲ್ಲಿ ವಿವರವಾದ ಸುತ್ತೋಲೆಯನ್ನು ಹೊರಡಿಸಿದ್ದು, ಸದರಿ ಸುತ್ತೋಲೆ ಕೈಬರ ಅರ್ಜಿಗಳನ್ನು ಭೌತಿಕವಾಗಿ ನಗರ ಸಂಸ್ಥೆಗಳು ಸ್ವೀಕರಿಸುವುದನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ನಿಷೇಧಿಸಲಾಗಿದೆ ಅಂತ. This is the, my lord, allegation.
No, who are you?
My lord, I am working as, my lord, second division assistant. Shankar CS. The primarily, your lordship, my lord.
No, who is the person who is receiving that application?
The person who is receiving, madam, para Manjanath ivaru ಚೆಕ್ಕುಬಂದಿಯಲ್ಲಿ, my lord, page 31 of annexure F, ದೂರಿನ ಕುರಿತು ಪರಿಶೀಲಿಸಾಗಿ ಮಂಜುನಾಥ್ ಇವರು ಚೆಕ್ಕುಬಂದಿಯಲ್ಲಿ ಏನು ತಪ್ಪಾಗಿದೆ ಎಂಬುದನ್ನಾಗಲಿ ಸರಿಪಡಿಸಿ ದಾಖಲೆ ಮಾಡಬೇಕಾದ ಚೆಕ್ಕುಬಂದಿಯ ಕುರಿತು ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ತಿಳಿಸಿರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರ ಅರ್ಜಿಯೊಂದಿಗೆ ತಾವು ಖರೀದಿಸಿದ ಸೊತ್ತಿನ ಕ್ರಯಪತ್ರ ನಕಲು ಹಾಗೂ ಅರ್ಜಿದಾರರಿಗೆ ಮಾರಾಟ ಮಾಡಿದವರು ಖರೀದಿ ಮಾಡಿದ ಸೊತ್ತಿನ ಕ್ರಯದ ಪತ್ರ ನಕಲನ್ನು ಒದಗಿಸಿದ್ದಾರೆ. ಎರಡು ಕ್ರಯಪತ್ರದಲ್ಲಿನ ಚೆಕ್ಕುಬಂದಿ ಪರಸ್ಪರ ತಾಳೆ ಇದ್ದು ದಿನಾಂಕ 23/9 ನೀಡಿದ ಈ ಖಾತಾದಲ್ಲಿ ನಮೂದಿಸಲಾಗಿದ್ದ ಚೆಕ್ಕುಬಂದಿಯು ಸಹ ಈ ಕ್ರಯಪತ್ರದಲ್ಲಿ ನಮೂದಾಗಿರುವ ಚೆಕ್ಕುಬಂದಿಯೊಂದಿಗೆ ಪರಸ್ಪರ ತಾಳೆ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಕಡತದಲ್ಲಿರುವ ಕ್ರಯಪತ್ರದಲ್ಲಿ ನಮೂದಿಸಲಾಗಿರುವ ಚೆಕ್ಕುಬಂದಿ ವಿವರವನ್ನು ವಿಷಯ ನಿರ್ವಾಹಕರಾಗಿ ಮೊದಲಿಗೆ ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತವಾದ ಟಿಪ್ಪಣಿಯನ್ನು ಮಂಡಿಸಬೇಕಾದ್ದು ವಿಷಯ ನಿರ್ವಾಹಕರ ಜವಾಬ್ದಾರಿ ಆಗಿರುತ್ತದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಹಾಗೆ ಪರಿಶೀಲನೆ ಮಾಡಿ ಕಡತದಲ್ಲಿ ಟಿಪ್ಪಣಿ ನಮೂದು ಮಾಡಿರುವುದು ಕಂಡು ಬರುತ್ತಿಲ್ಲ. Then, my lord, just have read your lordship. ನಿರ್ದೇಶಕರು ಪೌರಾಡಳಿತ ಇವರ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 1/8/23ರಲ್ಲಿ ಈ ಆಸ್ತಿ ತಂತ್ರಾಂಶವನ್ನು ಪರಿಣಾಮಕಾರಿಯಾಗಿ ಅನುಷ್ಠಾನಗೊಳಿಸುವ ವಿಚಾರದಲ್ಲಿ ವಿವರವಾದ ಸುತ್ತೋಲೆಯನ್ನು ಹೊರಡಿಸಿದ್ದು, ಸದರಿ
ಆಯ್ತು. By taking that application, what is that cost to that department? ಏನಾಗಿದೆ? Are the parties, anything is happened to them?
Nothing has happened.
What is that? ಅದರ ಕಂದಾಯ ನಿರೀಕ್ಷಕರ ವಿಷಯ ನಿರ್ವಾಹಕ ಅವರು ಅದೇ ಕಡತದಲ್ಲಿ ಪರಿಷ್ಕರಿಸಬೇಕಾದ ಟಿಪ್ಪಣಿಯನ್ನು ಉಲ್ಲೇಖಿಸಿ ಕಡತವನ್ನು ವಿಶೇಷ ನಿರ್ವಾಹಕ ಹಿಂದಿರುಗಿಸುತ್ತಾರೆ. ಆದರೆ ಕಡೂರು ಪುರಸಭೆಯಲ್ಲಿ ಕಂದಾಯಾಧಿಕಾರಿ ಹುದ್ದೆಯೂ ಇದ್ದು ನಿಯಮದಂತೆ ಕಂದಾಯ ಶಾಖಾ ಸಂಬಂಧಿಸಿದ ಕಡತಗಳನ್ನು ಕಂದಾಯ ನಿರ್ದೇಶಕರು ಕಂದಾಯಾಧಿಕಾರಿಗೆ ಮಂಡಿಸಬೇಕಾಗುತ್ತದೆ. ಇದನ್ನು ವಿಷಯ ನಿರ್ಣಾಯಕ ಗಮನಿಸದೆ ಕಡತವಾಗಿ ಮುಟ್ಟಿಸಿ ಶಿಷ್ಟಾಚಾರವನ್ನು ಪಾಲಿಸಿರುವುದಲ್ಲದೆ ಮುಖ್ಯ ಅಧಿಕಾರಿಗಳು ತಿದ್ದುಪಡಿಗೆ ಸಮ್ಮತಿ ನೀಡಿದ ನಂತರ ಕಡತವನ್ನು ಮುಂದುವರಿಸಲಾಗುವುದು. ತಿದ್ದುಪಡಿಗೆ ಯುಕ್ತ ಆದೇಶವನ್ನು ಮಾಡಿ ಆದೇಶವನ್ನು ಈ ತಂತ್ರದಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡಿ. ಯು ಆರ್ ನಾಟ್ ಫಾಲೋಡ್ ದಟ್ ಪ್ರೊಸೀಜರ್. ಇದರಿಂದ ಏನ್ ಲೋಪ ಆಗಿದೆ ನಿಮಗೆ? ಚೆಕ್ಕುಬಂದಿ ತಿದ್ದುಪಡಿ ಮಾಡಿದ ಕರ್ತವ್ಯ ಹೀಗೆ ಪ್ರಕರಣದಲ್ಲಿ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲನೆ ಮಾಡದೆ ವಿಷಯ ನಿರ್ವಾಹಕರ ಹುದ್ದೆಯ ಕರ್ತವ್ಯವನ್ನು ಜವಾಬ್ದಾರಿಯುತವಾಗಿ ನಿರ್ವಹಿಸಿ ನಿಯಮ ಬಾಹಿರವಾಗಿ ಚೆಕ್ಕುಬಂದಿಯನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಕರ್ತವ್ಯ ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುತ್ತೆ. Now, who has alter that ಚೆಕ್ಕುಬಂದಿ?
That is, my lord, the highest officer in the municipality, the chief.
No, you see that last line there, it's in a cuts of the matter.
Chief officer, hige last line, your lordship.
ಹೀಗೆ ಪ್ರಕರಣಗಳ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲನೆ ಮಾಡದೆ ವಿಷಯ ನಿರ್ವಾಹಕ ಹುದ್ದೆಯ ಕರ್ತವ್ಯವನ್ನು ಜವಾಬ್ದಾರಿಯುತವಾಗಿ ನಿರ್ವಹಿಸದೆ ನಿಯಮ ಬಾಹಿರವಾಗಿ ಚೆಕ್ಕುಬಂದಿಯನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಕರ್ತವ್ಯ. Who has done this?
My lord, these are the highest officer in the municipality is the chief officer, my lord. He is the one.
No, what is your duty?
The application which is received by him will be forwarded to the, my lord.
No, application is received by him, or he is saying that it is not received by him?
And in the usual course, my lord, as usual, it is received by in the Tapal branch and it will be, my lord.
No, that's what, two things. If you are not received, then this circular will not applicable to you. This changes is made by you or the higher authority is the question. If it is by you, then you have negligent in discharging your duty.
But page 23 is, my lord.
What is your duty?
That is an application. I have not received, my lord. This is referred to the, my lord, Purasabhe Mukhyadhikari, page 23,
Page 20?
annexure B,
20?
23.
Yes.
Chief officer ಗೆ ಇದು ಮಾಡಿದ್ದಾರೆ. Refer to chief officer.
Where is that?
23 my lord.
Read, what is that? ಮೇಲ್ಕಂಡ
ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಡತ ಪುರಸಭೆಯ ವ್ಯಾಪ್ತಿಯ ವಾರ್ಡ್ ನಂಬರ್ ಸೋನ್ಸೋ ನಂಬರ್ ಸೋನ್ಸೋರ ಸ್ವತ್ತನ್ನು ಚೆಕ್ ಬಂದಿ ತಿದ್ದುಪಡಿ ಕೊಡಬೇಕೆಂದು ಈ ಮೂಲಕ ವಿನಂತಿಸುತ್ತೇನೆ. ರೆಫರ್ ಟು my lord ಮುಖ್ಯಾಧಿಕಾರಿ.
ಮಾಡದ್ ಯಾರು? whose power that modification?
He is the chief officer.
No, see, modification, see, person who has received that application by hand is somebody, it is not by him. It is passed to that petitioner, he is just forwarded. There also he has to verify. He has forwarded, that is that only a mistake. Or he has altered that checkubandi, then it is a serious offense. No, but that's what I want to know, that whose duty that is. Is it, mister? Then, but see, you are only a forwarding, it is different. If you have done it, then you have. Yes.
Then, no, my page 26 alle.
Yes.
Page 26, my lord, is the chief officer.
Yes.
Madam, at page 26, my lord.
Yes.
ಮುಖ್ಯಾಧಿಕಾರಿ ಡಿಜಿಟಲ್ ಸಹಿ ಪುರಸಭೆ ಕಡೂರು 26.
No, he is the final authority to sign. Is it your duty to, if you are saying that you are only forwarding, you are not changing, altering, then it is not your
Forward,
responsibility.
my lord, the application.
Where have you stated in that petition? That is done by that higher authority, I have just forwarded. Where is your pleading?
Receiving this.
Yes, have you pleaded? Otherwise, to make this thing, you have received that with an intention to see that, to help that person.
Page 12, my lord, page 12.
Yes.
In page, my lord, in page 12.
Chamber.
Ground, my lord, ground number 15. My lord, in the starting, the complaint, second sentence, the complaint has
page
given
number?
Complaint to the deputy commissioner who is not an affected party. As such, either his kata is not disturbed nor the kata of the Manjanath, son of Kandoji Rao is changed. What was recommended the petitioner was to rectify the schedule in the E-Swattu. After submitting a report, the same was forwarded.
Which paragraph you are reading?
Chief officer. Page.
Ground 15.
Ground 15.
Ground 15.
Liability be caused on the ground that there is no question of change of kata in the case on hand. It is only that rectification of the schedule E-Swattu.
E-Swattu. The
complaint has been given
a
complaint to the deputy commissioner who is not an affected party. Either the kata is not disturbed nor kata of Manjunath changed. What was recommended by the petitioner was to rectify that scheduled E-Swattu. You have recommended to rectify E-Swattu. How can you recommend? Who is
After submitting a report, the same was forwarded to the chief officer.
ನೀವು recommend ಮಾಡಿ, this can be rectified ಅಂತ ಹೇಳ್ಬಿಟ್ಟು you have sent it. What you have rectified is correct. Paragraph number? Yes.
Already in the request made by the said Manjunath was to rectify the schedule in E-Kata as such there is a difference in the physical when compared to the E-Swattu. After receiving the said representation, the petitioner instructed the spot and verify the schedule in respect of the said Manjunath enter the schedule as per the physical verification. It is clear that there is no change of Kata standing in the name. Kata is not the only the boundaries of the schedule is changed by the
No, case worker after receiving that representation, K. Manjunath, where he was request for made to rectify the schedule in the e-Khata. After the verification of the records, it is found that said K. Manjunath Rao has purchased the site in that question through the register sale deed, and the Khata was already in his name. The request made to said K. Manjunath was to rectify the schedule in that e-Swattu. As such, there is a difference in the physical position of that site. No, see what he is saying that Manjunath has purchased the schedule. There is a difference in the physical position of the site. Then you can change that if it is a difference in that physical position. It has to be changed by filing an appeal or something. Now what he has did, Manjunath has purchased that property. Purchase ಮಾಡ್ಬಿಟ್ಟು on purchase ಮಾಡಿರೋದು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇದೆ, ಅಲ್ಲಿ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಬೇರೆ ತರ ಇದೆ. He has changed in consonance with that position. That he can't do it. He has to change before the surveyor. ಅವನು ಯಾವ್ದೋ ಇಲ್ಲಿ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ABCD ಇರೋದ್ ಬಿಟ್ಟ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಪರ್ಚೇಸ್ ಮಾಡ್ದ. ಇವನು ಹೋದ ಅವ್ನ್ ಸೇಲ್ ಡೀಡ್ ಕರೆಕ್ಟ್ ಆಗಿ ಸ್ಕೆಚ್ ಹಾಕೊಟ್ಟ ಅಂದ್ರೆ ಅವ್ನ್ ಪ್ರಾಪರ್ಟಿನ ಫಿಕ್ಸ್ ಮಾಡಿದ ಇವ್ರು. Then it is let us see.
The primary question is, my lord, the deputy commissioner has no authority, my lord, that I have examined. But he is a group C officer, my lord, that he has referred, my lord, in the order itself. Your lordship, I kindly go to, my lord, the operative portion of the order. He has got a power, my lord, on page 33 annexure F, my lord, internal page 3. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ operative portion. Page 33, my lord, page 33, internal page 3.
Yes.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಕಾರಣ ಮೇರೆಗೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರಿ ಸೇವಾ ವರ್ಗೀಕರಣ ಸೋನ್ಸೋ ಉಪನಿಯಮ ಮೇರೆಗೆ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸ ಹಾಗೂ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ನಂಬರ್ ಸೋನ್ಸೋ ದಿನಾಂಕ 9/1/2015 ಪ್ರತ್ಯೋಜಿಸಲ್ಪಟ್ಟ. But this provision of delegation of power under the Municipalities Act to the, my lord, the deputy commissioner. My lord, this is under suspension. It's altogether different. My lord, for the appointing authority, my lord, under the rules. Your lordship, my lord,
ಶ್ರೀ ಶಂಕರ್ PS ದ್ವಿತೀಯ
Annexure C.
ದರ್ಜೆ. No, that by government order, suspension order has been given that power to that.
No, my lord, that's under the municipality. The powers have been delegated. I will also, my lord, pass on. He has no authority, my lord. That is the. And the, my lord, the notification is also printed. Your lordship, I kindly see, but that is the rules governed for the municipal employees of the municipality. These are the rules, my lord. The appointing authority and discipline authority for a group C employees is, my lord, the deputy commissioner, my lord, the DMA. Your lordship will find, my lord, in that page,
various category of the post.
Item number B, my lord. Director for municipal administration or an officer employed by the government in the case of a group B and C post. My lord, C, my lord, the petitioner is, my lord, a group C employee.
Director of the municipal administration.
This is Baradela, sir.
Are an officer
Deputy
employed
commissioner
by the
can
government.
exercise powers only in respect of group D employee.
No, are that officer employed by the government?
Please, they are not empowered. Empowered, my lord, is under municipality. The provisions of the Municipalities Act was delegated to the deputy commissioner. Not, there is no suspension, my lord, may I pass on this also.
What is that?
The notification. Notification, your lordships may kindly, my lord. Notification was referred on 9/1/2015. Your lordship may kindly say, my lord, all the provisions of the Municipalities Act was delegated to the deputy commissioner.
Read.
Please, my lord. In supervision of all the orders, notification issued by government of Karnataka, earlier from time to time in this regard, the government of Karnataka can exercise the power conferred under section 1 and section 2 of the section 321 of subsection 2 and 3 of the section 388 of Karnataka Municipalities Act 1964, hereby delegated the powers of the government with immediate effect to regional commissioner, director of municipal administration, deputy commissioner, assistant commissioner, Tahsildar of the revenue district as specified below. But all the provisions of the Municipalities Act.
This is the power which has to be exercised by the government has been delegated.
Delegated in so far as
The
Municipalities
government
Act.
secretary is busy. Therefore, he said These are all the powers will be delegated to that. So many other authorities, deputy commissioner, commissioner ಗೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
Municipalities Act ಕೆಳಗಡೆ ಮಾತ್ರ service regulation is different. What I have produced your lordship.
Here you have not done. Where is this?
Without authority of law, my lord.
It is a director of municipal administration has a power to suspend, not the DC, not the DC. Yes. Tomorrow, yes. ಕಾಪಿಲ್ ಏನಿಲ್ಲ ನೀವು ಇದು ರೂಲ್ಸ್ ಇಸ್ ದೇರ್.
ರೂಲ್ಸ್
ಇದ್ರಲ್ಲಿ ಏನು ಅಂತ ಅಂದ್ರೆ ದಿಸ್ ಈಸ್ ಓನ್ಲಿ ಎ ಪವರ್
ಅಂಡರ್ ದಿ ಮುನ್ಸಿಪಾಲಿಟೀಸ್ ಆಕ್ಟ್.
ಗವರ್ಮೆಂಟ್ ಪವರ್ ಮುನ್ಸಿಪಾಲಿಟಿಲಿ 322 ಅವೆಲ್ಲ ಇದಾವಲ್ಲ,
306 ಅವೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
306 ಅಲ್ಲ, ಅದನ್ನ ಡೆಲಿಗೇಟ್ ಮಾಡಿದ್ದಾರೆ. ಬೇಕಾದ್ರೆ ಕೊಡಿ ಅವರಿಗೆ. ಲೆಟ್ ಇಟ್ ಸಿ ಆಲ್ಸೋ.
ಮಂಡೇ ಅಲ್ಲ, ಸಸ್ಪೆನ್ಷನ್ ಆಗಿದೆ.
ಸಸ್ಪೆನ್ಷನ್ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. Otherwise we'll stay that order.
Please, my lordship, till that
day after tomorrow. Yes. To give one more opportunity, that's all. Connector matter same. Yes, day after tomorrow.
Office objection complete.
Yes, office objection is complete. Yes.
Serial number 15, J. Srikantegowda for petitioner. 15, J. Srikantegowda, office objection complete.
Office objection is complete. Leave this matter Monday.
Serial number 16, SB Mukkanappa for petitioner, government advocate.
16.
16, amendment carried out, sir.
Yes. Learned counsel for the petitioner submits that amendment is carried out. Office to verify and proceed further.
Continuation of list. B group matter, serial number 28 adjourn. Serial number 29, Manjunath R for petitioner. Connected matter, Rajesh Shettigar, Subramanya R.
Yes, Mr.
For petitioner in this case, my lord. Let's kindly a date can be fixed in next week.
Old matters at the request of
Senior
petitioner.
counsel is.
Leave this matter after 3 weeks. Yes.
Serial number
Kindly a
30
date can
adjourn,
be fixed, my lords.
On 5th March.
Much over.
Srikantegowda, the office objection is complied. On 10th. ನೀವು ಇರ್ಲಿಲ್ಲ, we have urgent it. 10th. Friday ಬೇಡ, Monday 9th. Yes.
Serial number 30 adjourn. Serial number 31, B. Shivaji for petitioner, T. Mohandas Shetty. Serial number 31.
31.
Yes.
Girish.
My lord, petitioner ಪಂಚಾಯತಿಯಲ್ಲಿ ಗುಮಾಸ್ತಿಯಾಗಿ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ ಸರ್. ಅದು ಪೇಜ್ ನಂಬರ್ 18 ನಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಗ್ರಾಮ ಪಂಚಾಯತಿಯವರು ನಡವಳಿ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ, ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿ ಅವ್ರದ್ದು ಅಪ್ರೂವಲ್ ಮಾಡಿದ್ದಾರೆ.
Gram Panchayat Mangalore Taluk DK is directed to be appear for PDO. Who is that?
PDO ಬಂದಿದೆ ಸರ್.
You are filing in a power. Yes. Yes, what is your case, Mr.
ಸ್ವಾಮಿ, ಗ್ರಾಮ ಪಂಚಾಯತಿಯವರು ಸಭೆ ನಡವಳಿ ಪಾಸ್ ಮಾಡಿ ಅವರಿಗೆ ಅಪ್ರೂವಲ್ ಮಾಡಿದ್ದಾರೆ. 21/1/13 ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಯವರು ಅನುಮೋದನೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅನೆಕ್ಷರ್ ಡಿ, ಪೇಜ್ ನಂಬರ್ 22ರಲ್ಲಿ.
ಪೇಜ್ ನಂಬರ್
22 ಸ್ವಾಮಿ. 22, 23 ಅಟೆಂಡೆನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ ಅವ್ರದ್ದು. ಆಮೇಲೆ 1/10/7/17 ಅವರಿಗೆ ಇನ್ನೊಂದ್ಸಾರಿ ಏನೋ ಅನುಮೋದನೆ ಮಾಡುವಾಗ ಬೈ ಮಿಸ್ಟೇಕ್ ಅವರು ಪಂಪ್ ಆಪರೇಟರ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವರಿಗೆ ಡೆಸಿಗ್ನೇಷನ್
ಎಲ್ಲಿದೆ ತೋರ್ಸಿ.
ಅದು ಅದೇ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ನಿಮ್ ಫಸ್ಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 18 ಸ್ವಾಮಿ.
ಓದಿ. ಗ್ರಾಮ ಪಂಚಾಯತಿ ಖಂಡಿತ ಹಾಗೂ ಕಾಲಕಾಲಕ್ಕೆ ನಿರ್ವಹಣೆ ಕರ್ತವ್ಯ ತಕ್ಕಂತೆ ದಿನಾಂಕ 1/25 ಕಚೇರಿ ಕೆಲಸಕ್ಕೆ ಹಾಜರಾಗತಕ್ಕದ್ದು. ಏನಂತ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ?
ಇವರಿಗೆ ಗುಮಾಸ್ತಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಗ್ರಾಮ ಪಂಚಾಯತ್ ಕಚೇರಿ ನಿರ್ವಹಣೆ ಮಾಡಲು ಆಯ್ಕೆ ಮಾಡಿದ್ದು.
ಎಲ್ಲಿದೆ ಗುಮಾಸ್ತಿ ಅಂತ? ಓದಿ ಅದನ್ನ.
ಅವರು ರೆಸಲ್ಯೂಷನ್ ಇದೆ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 20ರಲ್ಲಿ.
ನಿಮ್ಮನ್ನು ಇದೇನಿದು ನೀರು ಮಾರ್ಗನ ಎಂತದದು?
ನೀರು ಮಾರ್ಗ
ಅಂದ್ರೆ ಏನು?
ನೀರು ಮಾರ್ಗ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಊರ ಹೆಸರು ಸ್ವಾಮಿ.
ಊರ ಹೆಸರ? ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಚೇರಿ ಕೆಲಸ ನಿರ್ಮೂಲನೆ ಮಾಡಲು ಆಯ್ಕೆ ಮಾಡಲಾಗಿದೆ. ಏನ್ ಪೋಸ್ಟ್ ಅಂತ ಹೇಳಿಲ್ಲ.
ಏನ್ ಪೋಸ್ಟ್ ಅಂತ ಹೇಳಿಲ್ಲ.
ಆಮೇಲೆ ಏನಾಯ್ತು?
ಆಮೇಲೆ ರೆಸೊಲ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇವರು.
ಎಲ್ಲಿದೆ?
20 ಪೇಜ್ ನಂಬರ್ 20 ಸ್ವಾಮಿ. 20ರಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 4ರಲ್ಲಿ ನಿರ್ಣಯ ನಂಬರ್ 22 ನೀರು ಮಾರ್ಗ
ಏನಿದೆ ಗೊತ್ತಾ ಕೇಸ್ ನಿಮಗೆ?
ಹ್ಞೂ ಸ್ವಾಮಿ.
ಎಸ್
ಇವರು ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಯವರು ಇದು ಸರಿ, ಇದು ನೇಮಕಾತಿ ನಾವು ಅನುಮೋದನೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಗುಮಾಸ್ತೆ ಅಂತ ಹೇಳಿ, ಅದು ತಪ್ಪಾಗಿದೆ ಸರಿಪಡಿಸಿ ಅಂತ ಪಂಚಾಯತಿಯವರು ರೆಸೊಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿ ಕಳಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಜಿಲ್ಲಾ
ಫಸ್ಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇರೋ ರೆಸೊಲ್ಯೂಷನ್ ಎಲ್ಲಿದೆ ರೀ?
ಅವ್ರು ಅಪ್ರೂವಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಅಪ್ರೂವಲ್? ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ? ಕೇಸಿಗೆ?
ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್
ಮತ್ತೆ ಅವರು ಕೇಳಿ ನೋಟಿಸ್ ಸರ್ವ್ ಆದ್ಮೇಲೆ ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತ ಕೋರ್ಟ್ ಇಂದ ವಾರೆಂಟ್ ಕಳಿಸ್ಬೇಕಾ ಬರೋದಕ್ಕೆ? ವೈ ಹ್ಯಾಸ್ ನಾಟ್ ಅಪಿಯರ್ಡ್ ವೆನ್ ನೋಟಿಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸರ್ವ್ಡ್ ಮಿಸ್ಟರ್?
ಸ್ವಾಮಿ ಅವರು ಪಂಚಾಯತಿಯವರೇನೆ ಇದು ಸರಿಪಡಿಸಿ ಅಂತ ಹೇಳಿ ಒಂದು ರೆಸೊಲ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅವರು. ನೋಡಿ ಇಲ್ಲಿದೆ.
ಆಮೇಲೆ ಏನಾಯ್ತು ಈಗ? ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದೀರಾ ನೀವು?
ಈಗ ನಾವು
ಏನ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
10/7/77ರಲ್ಲಿ 10/7/17ರಲ್ಲಿ ಪಂಪ್ ಆಪರೇಟರ್ ಅಂತ ಮಾಡಿದ್ದ ಆದೇಶವನ್ನು ನಾವು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಎಲ್ಲಿದೆ? ಯಾವ್ದು ಅನೆಕ್ಷರ್ ಹೇಳ್ರಪ್ಪ?
ಅನೆಕ್ಷರ್ ಇ
ಜೆ ಅಂತ ಹಾಕಿದೀರಾ, ಇ ಅಂತೀರಾ? ಆಯ್ತು, ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ. ಇದಕ್ಕೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಾ? ಹಾಕಿ. ಎಸ್,
ಅವರೇ ರೆಸೊಲ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಹಿಂದೆ ರೆಸೊಲ್ಯೂಷನ್ ಮಾಡಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಕಳಿಸಿದ್ದಾರೆ.
ಆಯ್ತಪ್ಪ, ಈಗ ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದೀರಾ ನೀವು?
ಈಗ ಇದೆ ಸ್ವಾಮಿ, ನಾವು ಹೇಳಿದ್ನಲ್ಲ ಈಗ ಅನೆಕ್ಷರ್ ಇ ಪೇಜ್ ನಂಬರ್ 20.
ಏನಿದೆ ಅನೆಕ್ಷರ್ ಇ?
ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸಿಬ್ಬಂದಿಗಳ ನೇಮಕ ಅನುಮೋದನೆ ನೀಡುವ ಕುರಿತು ಅಂತ ಹೇಳಿ ಇವರು ಒಂದು ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಯವರು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದನ್ನ ಇವರು ರೆಸೊಲ್ಯೂಷನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಗ್ರಾಮ ಪಂಚಾಯತಿ 32ನೇ ಪೇಜ್ ಅಲ್ಲಿ.
ನಿಮ್ ಪ್ರಯರ್ ಏನ್ರಿ?
32ನೇ ಪುಟದಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಯವರು.
ಎನಿ ಅದರ್ ಆರ್ಡರ್ ಡೈರೆಕ್ಟ್ ದ ಕೇಸ್ ಮೇ ಬಿ ಕಮಿಷನ್ ಬೇರಿಂಗ್ annexure J so far is led designation of the officer of the pump operator and direct the respondent to show the name of the petitioner as a clerk. ಎಲ್ಲಿ ಪಂಪ್ ಆಪರೇಟರ್ ಅಂತ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ? ಯಾರು ಕೊಟ್ಟಿರೋದು?
ಪೇಜ್ ನಂಬರ್ 26ರಲ್ಲಿ ಅವರು ಒಂದು ಅನುಮೋದನೆ
ಪಂಪ್ ಆಪರೇಟರ್ ಅಂತ ಕೊಟ್ಟಿರೋದು ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ರೀ?
ಪಂಪ್ ಆಪರೇಟರ್ ಅಂತ ಕೊಟ್ಟಿದ್ದು 20ನೇ ಪೇಜ್ ಸ್ವಾಮಿ. 29-30ರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
ಏನಿದೆ 29-30?
31ರಲ್ಲಿ ಒಂದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಇದೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ನೀರು ಮಾರ್ಗ 31ನೇ ಪೇಜ್ ಅಲ್ಲಿ.
ಯಾರು ಆರ್ಡರ್ ಮಾಡಿರೋದ್ರಿ ಪಂಪ್ ಆಪರೇಟರ್ ಅಂತ?
ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಅವರು.
ನಾವು ಹೂ ಇಸ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್? ವೇರ್ ಇಸ್ ಮೋಹನ್ ದಾಸ್ ಶೆಟ್ಟಿ? He is not coming. He has to answer that. Last occasion also nobody is appeared. We'll ask that. Yes, you communicate that government advocate, chief officer.
ಅವರು ಇದುವರೆಗೂ ಗುಮಾಸ್ತೆಯಾಗಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
Panchayat Development Officer directed to name the Armugan Learned Council for respondent 3 from the past list. Panchayat Development Officer directed to appear. See our which is that Jilla Panchayat, Mr. Yes, none appear for.
ಸರ್ ಇದೊಂದು ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇದೆ.
ಆಯ್ತು, ಅವ್ರು ಬರ್ಲಿ, ಅವ್ರು ಹೇಳ್ತಾರೆ. ನೀವೇನ್ ಹೇಳೋದು ನಮಗೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ ಬಿಡಿ. ಎಸ್, ಚೀಫ್ ಆಫೀಸರ್ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಮ್ಯಾಂಗ್ಳೂರ್. ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ is directed to intimate the same to the chief officer, chief executive officer Dakshin Kannada Jilla Panchayat. You intimate him, Mr. Nobody is coming. He has to answer that. And objection ಹಾಕಿದಾರ ಅವರು?
ಅವರೇ ಸ್ವತಃ ಇದು ರೆಸೊಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿ ಸರಿಪಡಿಸಿ ಅಂತ ಕೇಳಿದಾರೆ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ ಅವರು ಹಾಕಿಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್.
Directed to communicate. None appear for respondent number 3 Jilla Panchayat. Respondent number 3 Jilla Panchayat alri kodri ಅಲ್ಲಿ. CO DK executive officer Dakshina Panchayat, nobody is represented ಅಲ್ಲ. ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀವಿ? PDO ನಾ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಗೆ ಇವರು ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇವತ್ತು NOC ಕೊಟ್ಟರು.
ಅವರು ಮೋಹನ್ದಾಸ್ ಶೆಟ್ಟಿ ಅವ್ರು ಇಲ್ವಾ? ವೇರ್ ಇಸ್ ದಟ್ ಟಿ ಮೋಹನ್ದಾಸ್ ಶೆಟ್ಟಿ? ಅವ್ರು ಯಾರಿಗೋ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ರಿ, ಅವ್ರೆಲ್ಲಿ? ಕೇಳ್ರಿ ಅವ್ರನ್ನ. ಮೋಹನ್ದಾಸ್ ಶೆಟ್ಟಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ಲ, ಅವ್ರು ಇದಾರ ಇಲ್ಲ ಅಂತ.
ಇವ್ರು
ಯಾರು ನಿಮ್ ಲಾಯರು? ಅವ್ರು ಮೋಹನ್ದಾಸ್ ಶೆಟ್ಟಿ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ವಕಾಲತ್. ಮತ್ತೆ ಅವ್ರಿಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಇಲ್ವಾ ಅವ್ರ ಹತ್ರ? ಏನ್ ಮಾಡಿದ್ರ ಕೇಸ್ ಅಂತ? ಅವ್ರು ಯಾರು ಬರ್ತಾ ಇಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ ನಿಮ್ಮನ್ ಬರಕ್ ಹೇಳಿರೋದು. ಈಗ ಇವ್ರಿಗೆ ಕೊಡ್ತೀರಾ, ಅವ್ರಿಗೆ ಕೊಡ್ತೀರಾ? ಯಾರಿಗೆ? ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲಲ್ಲ. I will ask that chief executive officer Jilla Panchayat to be present before this court. He is not present. Yes.
ಸ್ವಾಮಿ R3ಗೆ ಆರ್ಮುಗಮ್ ಅಂತ ಇದ್ರು ಸ್ವಾಮಿ, ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಇವ್ರು ಯಾರು ಟಿ ಮೋಹನ್ದಾಸ್ ಶೆಟ್ಟಿ ಅವ್ರು ಯಾರಿಗೆ ವಕಾಲತ್ ಹಾಕಿದಾರೆ?
R3ಗೆ ಸರ್.
R3ಗ
ಇವ್ರು R3ಗೆ ಸರ್.
Yes. ನೀವು ವಕಾಲತ್ ಕೊಡೋದರ ಕೊಡಿ ಅಲ್ಲಿ, ಆಯ್ತು. As per the directions of this court, the PDO of Gram Panchayat is present. Hence his presence is noted. And the respondent number 3, respondent number 1, Chief Executive Officer, Dakshina Kannada Jilla Panchayat has been served unrepresented. Government advocate is directed to communicate this order. Either he has to engage the council by next date of hearing. If it is not engaged, he has to be present before this court on 19th. Yes. Chief Executive Officer, let him come, Mr. Jilla Panchayat. You communicate him, Mr. Either let him engage or otherwise you will present, Mr. Yes.
Serial number 30.
Serial number 16, my lord.
Huh?
Serial number 16, my lord. Adna, date may be.
16 ಏನಾಗಿದೆ?
Need put stated of it done after. Amendment.
It is done.
Date may be fixed.
ಈ ಬಿ ಗ್ರೂಪ್ ಗೆ ಬರ್ಬೇಕಾದ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಹೌದು ಸರ್.
Leave this matter in B group 23rd. Yes.
Serial number 32, Shrikant MP for petitioner.
Matter.
Yes, madam. What do you want?
Kindly have it on next week, my lord.
Yes. Request of petitioner.
Date may be fixed.
Next week. Yes.
Serial number 33, MP Shrikant.
Yes, 2 weeks.
Registry. Serial number 34, Shrikant MP.
Same 2 weeks.
Date may be fixed, my lord.
All are second and third. Yes.
Serial number 36, Shrikant MP, connected matter.
Same. 36.
Number 37.
Yes. Four. Yes.
Nayak VS for petitioner.
None appear for the petitioner. Leave this matter of 2 weeks.
Serial number 38, Binu M for petitioner.
My lord, a date may be fixed, my lord.
Yes, at the request of petitioner. Leave this
I am
matter.
ready to hear, my lord, if there is sufficient time.
Fourth.
A shorter date, my lord, because I have moved the matter because of urgency, 2020 matter, my lord.
Yes, 23rd.
On the previous occasion, there was a direction given for the respondents to see whether the posts are vacant yet, my lord. Final notification has not been issued. They told they'll verify and let us know, my lord. Let the court know when there is vacancy of the post.
Yes, 23rd. Well, a date could
Please. Sir. Serial number 39, Shrikant MP.
5th.
Serial number 40,
Date may be fixed.
5th. Yes.
41, B Shivaji.
Yes. Yes, Mr. 40. Yes, where is that your opponent? Oh, he has taken time next week. Date ಕೊಟ್ಟಿದ್ದೀವಾ?
ಇಲ್ಲ next week.
Which date you want? Next week ಆಗಲ್ಲ. 24th. Yes, 24th. Yes.
41, B Shivaji.
ಸ್ವಾಮಿ, ಇದು ಸೇಮ್ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಗುಮಾಸ್ತೆ ಆಗಿ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದಾರೆ.
ಇದರಲ್ಲಿ ಇದಾರಲ್ಲ. Where is that AK Vasant? Yes, none appear for the respondent. Leave this matter next week. None appear for respondent number 2 and 3.
Serial number 42, Ashwini Rajagopal.
Yes, none appear. Leave this matter up to 2 weeks.
43 adjourned. Serial number 44, L Srinivasa Babu. 44 Srinivasa Babu.
Yes. Learned Council for respondent number 2 and 11 submits that in view of subsequent event. Yes, submitted that in view of disposal of the writ petition so and so. No, they said they wants to, but they are not coming. Yes. Please, none appear for the petitioner. Release this matter on 5th March. Yes.
45 Vaishali Hegde.
I pay for the petitioner, my lords. My lords, this is a matter where I'm seeking the payment of pensionary benefits under the Payment of Gratuity Act, my lords.
All will give in a date.
Please, my lords.
Because I have some.
Any short date, my lords, because he's
Which date you want?
has some financial distress, that is why. Any date next week, my lords.
18th.
Please, my lords.
46 Shilpa Gogi.
Yes, madam. Which?
My lords, I have filed an IA, my lords, seeking for extension of direction that was given on 1.
No, we'll hear that matter one for all. Ready?
Lord,
Yes, leave this matter on 4th. Yes.
Lord, short.
Cell number 47 NBN Swami.
Appearing for petition. Please time next week.
Yes, leave this matter.
Next week. And 74.
5th. Yes.
74 also is there.
74. Yes.
Next week.
Same.
Cell number 48 Kevin Narasimhan.
48 FA for the petitioner. But this is a compassionate appointment matter, my lord, which my application, my lord, is pending from 2016.
Why it is not considered?
Rejected once, my lord. Then I approached the writ petition court. That rejection order came to be set aside. They have rejected again, my lord. On the ground that, my lord, I am not the son of one Annama under whom I am claiming the compassionate appointment. It's a very short matter, my lord.
No, then where is that Satyanarayana? They are disputed that document.
Please, my lord. They have disputed and filed a statement of objections, my lord. In the 3 instances, my lord, 3 different contentions were taken.
Yes, any date? Any date you want?
My lord, any date in the next week, my lord, any date may be given. 2:30, my lord.
Not 2:30, mister. So many matters I have heard. I have to be finish it up. No, yes, I remember that. Therefore, I said that he said compassionate appointment I can dispose of. Then I see that you have heard and disputing that. Then the matter requires hearing. Yes, 23rd.
Yes.
49 Arjun 50 Raghupati MJ. Connected matter Subramanya Bhatt.
Yes, leave this matter after 2 weeks.
Appear for applicant, interim order may be extended, my lord.
Interim order granted earlier is extended till next date.
51 Arjun 50
Date may be given, my lord.
Yes, 5th.
Not serial number 61.
51 ಬೆಳಿಗ್ಗೆ 2 weeks ಆಗಿದೆ ಸರ್.
51 is no 51 you are not there.
I'm sorry, I heard
Yes.
this. 61.
Appearing for the petitioner in this case, my lord.
Who is your opponent?
ಗೌತಮ್ ದೇಸಿ ಉಳ್ಳಾಳ್.
None appear for the respondent. Leave this matter after 2 weeks.
53 Uday Kumar.
Date may be fixed, my lord.
Yes.
Already considered. Considering the representation, that is the lordship and listed on Monday. There is nothing in it.
Why short that you have taken time today?
There is nothing in it.
What is this matter, Mr.?
Considering the representation, similarly placed, she was a petitioner was appointed as a daily, this one on compassionate ground in the 2006, my lord. At that time, she was appointed as a D group. She was a BCom graduate as per the annexure B, my lord. Similarly placed employee was also a graduate, approached the KAT and got an order to appoint in a group C. He was considered as per the KAT order, annexure B.
When you are appointed?
She was appointed in 2006.
2006. You are not
Even-
challenging that appointment
Order already issued. They are not affected. Annexure H may be seen, my lord. The order are already issued, but that was not affected because there was no meeting was held. It was pending like that only for 2 years, my lord. That is all, my lord. There is nothing in it. There is nothing in it.
Who is your senior?
Last occasion itself.
No, madam, 2 days back it has come. Today I said that to this thing.
Annexure H, my lord. May I read the last para, my lord. Last para of the annexure H, my lord. 58.
Yes, at the request of council for. At the request of council for the respondent, as a last chance, please this matter on 9th, Monday. If otherwise we will dispose of.
Cell number
That
54.
serial number.
Srinivas.
Sorry, my lord, serial number 52 date, madam.
Appear for the
52, you have given a date, Mr.
53.
53, yes.
54 Srinivas.
I appear for the petition.
Which date you want, Mr.?
Any date, my lord, in the last week or any.
2nd March.
Because it's a retired employee. Only recovery, my lord, covered by the
26th, huh? Your time aitala 5 o'clock. That's why. Yes. 26th, please.
Cell number 55 Srinivasake.
Same 55 adhe alva.
26th, my lord. They're all temporary employees.
56 Mukkanappa SB.
I am appear for the petitioner, my lord. Last occasion, my lord, heard the matter because so far as my lord, the respondent, my lord, directed. Last occasion also, my lord, he took time, my lord,
No,
because
you are appearing for whom?
In the first matter, my lord, I am petitioner.
second matter, I am appear for the
Otherly,
petitioner,
you
my lord.
respond number,
My lord, they have challenged the, my lord, appointment, my lord, issued by the first respondent. The petitioner is appointed on compensatory ground, my lord. He is no way concerned, my lord. Even he has no locus to challenge that order, my lord. Last occasion also it took time. Today again, my lord,
matter is compassion appointment. Lord, if you want particular post, my lord.
that is
And
not,
bill
they have
collector
not
ಬೇಕು
challenged,
ಅಂತ
they have not challenged that order,
ಬಿಲ್
my lord.
ಕಲೆಕ್ಟರ್ ಬೇಕು ಜೊತೆಗೆ ಅದೇ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಬೇಕು ಅಂತ
ಅಲ್ಲ, ಆ ತರ ಇಲ್ವೇ ಇಲ್ಲ ಸ್ವಾಮಿ ಅದು.
ಅದೇ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಬೇಕು
Kindly see, my lord.
ಕಲೆಕ್ಟರ್ ಬೇಕು ಅಂತ ಹೇಳಿ ಕಂಪ್ಲೇಂಟ್ ಟೈಮ್ ಮಾಡ್ತಾರೆ.
My lord,
what
approved
is
by,
that
my lord,
qualification?
my lord, the diploma, my lord. See, even the petitioner.
If they are qualified to that post, you have to be given. That is
Already
what-
given, my lord, the appointment is also approved by the chief executive officer.
then-
Now, my lord, he has appointed on temporary basis. Now he has challenged my appointment order. How he has locus?
Now, is there any stay?
Yes, stay them, stay them.
You
ನನಗೆ
are working.
working, my lord.
Then no problem. ಯಾರ್ದು outside ಇದರ ಕೆಲಸದಲ್ಲಿ ಇಲ್ಲರ ನೋಡೋಣ first.
ಅಲ್ಲ, ಒಂದು short date, my lord, last occasion also, my lord.
Yes.
ಇದೇ month ಅಲ್ಲಿ ಒಂದು 20th.
25th.
Much.
No, if this matter which is consider for that urgent and heavy matters, it will take time. Therefore, I can't reach that.
Please, my lord, 25th.
Half day I have taken that matter. Yes.
Please, 25th.
Yes.
57 Sadhana S Desai. Serial number 57.
None appears. Leave this matter after 3 weeks.
58 urgent. Serial number 59 Ramakrishna N.
Seeking writ of mandamus, my lord, only seeking directions to the respondent to consider the representation. Husband of the petitioner died his service during his service, my lord. Thereafter, the petitioner approached the respondent for the job and the settlement of death benefit, my lord. Thereafter, they have issued one endorsement by saying that you have to approach by proper channel. Again, she has made a representation, my lord, which is annexure.
Who has to consider?
My lord, state has to be considered. Initially, she has made, this is aided college, my lord.
Your aided college management has to recommend.
Yes, my lord. Management is respondent number 5th, my lord.
Who is appearing for 5th respondent?
ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೆ. Respondent already served, my lord.
No, have they forwarded?
But
No, you are appearing for whom, mister? Serial number history?
59, my lord, 59.
No, he is seeking for only mandamus. You consider that and reject it. Instead of filing an objection here, you give that endorsement. Grant a financial benefit to the petitioner and her deceased who has employee of the education. See, retirement benefit to ಮತ್ತೆ ಇದನ್ನ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಬರುತ್ತೆ. ಗ್ರಾಂಟಿನೈಡ್ ಇಲ್ವಾ ಇದಕ್ಕೆ? ಹಾ. It is not.
Let them to file that withdrawal order matter, because as per my knowledge, my lord, and instructions by my client and college, my lord, respond number 5.
ಸತ್ತೋದ್ಮೇಲೆ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಮತ್ತೆ? No, you consider and this
Page number 20.
Petitioner sought following relief. The case of the petitioner that his husband, late Nagaraju P, was appointed as
teacher, my lord.
Appointed as a teacher in 5th respondent school, which was admitted to Grantinide. When he has died?
My lord, he died on 17/9/2024.
Again, when he was in duty.
Yes, my lord.
He died on 17/9/2024 while he was in service. Petitioner application hakidara?
Yes, my lord. Yes, my lord.
Filed an application for.
My lord, annexure J and K, my lord.
For appointment of compassionate ground and also
J and K
of retirement benefit.
Yes, my lord.
Filed annexure
J and K, my lord.
J and K.
L is endorsement issued by the state, my lord, by saying that you have to approach through college, my lord, which is annexure 25. I'm sorry, annexure M. I have approached subsequent by way of subsequent representation, my lord, which is page number.
College has to forward then.
College through kalisi anta. No, my lord. Also, I have made to the state, my lord.
When he was dead. Grantinide college withdraw, what about that? You have to be shifted to them. You consider and yes, Learned Council, government advocate submits that the Grantinide sanction to that school itself has been withdrawn on 12/1/2022. Be that as it may, since that representation has been submitted by the petitioner, has not been considered. Be that as it may, submitted that so and so. Since the representation submitted by the petitioner is not considered by that respondent, it is suffice for this court to direct the respondent to consider the same in accordance with law. In view of the above, without expressing any opinion on the merit of the case, JK ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
JK to the respondent number 2 and 3. Thereafter, I have made representation which is annexure M, my lord.
Yes, respondent number 2 and 3 is directed to consider that representation submitted by the petitioner. Wide annexure J and
M, my lord. Annexure M, my lord.
M ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಗೆ
ಇಲ್ಲ,
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಮೂರು ಜನಕ್ಕೂ.
ಇನ್ಸ್ಟಿಟ್ಯೂಷನರ್ ಇಲ್ಲ ರೀ, ಅವ್ರಿಗೆ ಏನು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡಕ್ ಬರ್ತದೆ?
ಅಲ್ಲ, ಈಗ ನಮಗೆ ಇದರಲ್ಲಿ ಇವ್ರಿಗೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ, 2 and 3 ಮಾತ್ರ. ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 and 3 ಗೆನೇ ಇದೆ ಇದರಲ್ಲಿ. ಕೈಂಡ್ಲಿ ಸಿ, ಮೈ ಲಾರ್ಡ್, annexure M, my lord. BEO and deputy director, my lord. Annexure M, page number 25, my
Yes,
lord.
annexure M.
Yes, my lord.
Respondent number 3.
Yes, my lord.
Yes, 1, 2, 1, 3 and 4 is directed to consider that representation of the petitioner with annexure KLM in accordance with law, as expeditiously as possible, not later than 3 months from date of receipt of copy.
Serial number 60, Ashok R. Kalyan Shetty for petitioner, connected matter.
I appear in the connected matter, my lords. I have moved the matter.
I beg to appeal for the petitioners, my lords. This is my lord with regard to that pension matter. UGC pension.
UGC pension is coming at 5 o'clock, 5:15, Mr. When do you want, Mr. Ashok? There is no time because I have
same point ಇದನ್ನ ಸಾಹೇಬ್ರೆ ತಮ್ಮ ಗಮನಕ್ಕೆ ಒಂದು ತಗೊಂಡ್ಬರ್ತೀನಿ. ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕು ಅಂತ ನಾಗಪುರ ಸಾಹೇಬ್ರ ಮುಂದೆನೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಸೇಮ್ ಯಾಕಂದ್ರೆ ಅವ್ರ ಆರ್ಡರ್ ಇರೋದ್ರಿಂದ ಅವ್ರ ಮುಂದೆನೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಧಾರವಾಡ ಬೆಂಚು. ತಾವ್ ಯಾವಾಗ ಅಂತೀರ ಅವಾಗ ಹಾಕ್ಬಹುದು.
ಅಲ್ಲ, ಅವ್ರದ್ದು ಆಮೇಲೆ ಅವ್ರು ಏನ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಡ್ತಾರೆ ಆಮೇಲೆ ವಿಲ್ ಹಿಯರ್ ದಿಸ್.
ಬೇಡ ತಮ್ಮ ಮುಂದೆ ಬರ್ಲಿ, ಯಾಕಂದ್ರೆ ಅವರೆಲ್ಲ 88, 89.
Yes, post this matter on 25th. Yes.
ತಾವು ಯಾವಾಗ ಒಂದ್ ಶಾರ್ಟ್ ಡೇಟ್ ಅಷ್ಟೇ.
Yes, 25th. ಆಯ್ತು, 25th, yes. I am
Serial number
not-
61, Puttegoda
ಆಯ್ತು,
K for
ಆಯ್ತು.
petitioner.
Well, as I appeal for the petition,
61.
your lordship had
Yes,
heard
madam.
this matter, my lords, on the last date, that it is directly covered by the Honorable Apex Court's judgment, my lords. Criminal
that?
Lord, I am appealing for the
proceedings
respondent in this case.
acquit agidre, departmental inquiry needs to be exonerated on the same set of facts evidence.
Yes, Mr. Who is appearing for?
My lord, on this aspect, my lord, the judgment what relying upon by the petitioner that may not be helpful for the petitioner, my lord, my humble submission. In that matter, there was a lapse in the department
No.
inquiry itself. Based on that, the
No,
acquittal has
no,
been placed.
you can distinguish that if you are ready.
Please, my lord, we have also produced judgments, my lord, where we are relying upon a date may be fixed, my lord, or tomorrow it will be taken up, my lord. We are ready for arguments.
Not tomorrow. You will have it on 19th.
Please.
Obliged, my lord.
Yes, 19th.
62, Vandana PL.
Yes, leave this matter. Is it, Mr.?
My lords, I have no instructions on that. If a short date could be given, we'll. My lords, I have no instructions on that.
What is that you are
From my
making submission, Mr.? Consider the representation of petitioner taken action against that fifth respondent in view of that unauthorized absence from the duty. Who is the petitioner? General prosecution. He has directed to take against that fifth respondent. Now you have taken the action. You are appearing for whom? Enquiry has been initiated. Who has initiated that enquiry? Yes, Mr. Government Advocate. No, see, their case is that taken action against the fifth respondent. Now that they are saying that you have already initiated that action, is it true? No, ಅವರೇ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಪಾರ್ಟಿನೇ, ಅದಕ್ಕೋಸ್ಕರ ನಿಮಗೆ ಹೇಳಿದ್ದು. ಅಲ್ರಿ ನೀವು ಮಾಡರ್ ನೀವ್ ಹೇಳ್ರಿ, ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲನ್ರಿ ಅವ್ರು ಮಾಡಿದಾರ ಇಲ್ಲ ಅಂತ. Learned Council appearing for the fifth respondent has submitted that. The state has already initiated the departmental inquiry, Nandre? Departmental inquiry against the fifth respondent. In view of the above, the prior sought by the petitioner will not survive for consideration.
My lords, it may be submitted on affidavit or so, because
I will take it on record, Mr. Submission of the counsel for respondent number 5 is taken on record. Since the petitioner has sought for following prior, now the state has already initiated the departmental inquiry. The prior sought in this petition will not survive for consideration. Accordingly, the writ petition is disposed of. Yes.
Grateful. Serial number 63, Manjunath N for petitioner, Government Advocate.
My lord. Already 2 weeks time was given, my lord. Right, still, I am ready with the.
But they have not filed an objection.
Probably short date, my lord. It's a grave injustice of fundamental rights, my lord. That's the reason.
The last chance. Use this matter on 24th.
24.
Yes.
Okay, my lord, and another submission, my lord. The name of the advocate needs a little change. It's not Manjunath, it's Sandeep Kumar. I'm also on the wakalat. The previous advocate has left the firm and not responding. Submission.
Now, what is your name?
Sandeep Kumar, Advocate Sandeep Kumar.
Directed to delete the name of Manjunath N, show the name of so and so. Yes.
Much obliged.
64, Syed Akbar Pasha.
Yes.
Lord, I appeal for respondents, my lord. My lord, matter pertains to selection that took place in the year 2020. My lord, the challenge is made in the year 2025. 2020 selection. Selection agi or kelsa madi, now that person is also no more who was selected. She passed away recently in the year 2025.
Then where is that council? Yes, none appear for the petitioner. There is a last chance. Leave this matter on 12th. 12th, Mr. Yes.
Serial number 65.
Yes, Mr. Vijay Kumar.
Vijay Kumar, connected matter, S. Rajshekar.
Hearing, Lord, can be taken up on any day next week, my Lord.
Yes, 24th.
Please, my Lord.
Yes,
Grateful.
66 Chetan B.
Yes.
For the
Connected
respondent,
matter.
university, my lords.
No, that matter.
Wait for the
Yes.
petitioners.
Any date?
My lords, last time what was asked was some of the connected matters.
That's here clarified.
Please, my lords, if the memo could be taken, my lords.
Which are that matter? Is there common? What
They've
he has-
given a memo, my lords.
No, that, is there any dispute regarding that, any of that?
I think first matter, it's disposed already, my lords.
ಕೊಡಿ ಅವ್ರದ್ದು memo ಕೊಡಿ. ನೀವೇ ಕೊಡಿ ಅವ್ರದ್ದು memo ಕೊಟ್ರೆ ಅಲ್ಲಿ ಇಸ್ಕೊಡ್ರಿ.
Connected and it's anyway disposed of, my lords. I
one.
think the other 7 matters are similar, my lords.
We'll ask them to transfer to that High Court principal bench. These are all from Gulbarga.
Kalburgi bench, my lord.
This will be transferred, madam.
I think if
No,
it could
because
be, my
earlier
lords.
there is a direction, therefore I am asking.
Please,
that.
my lords.
ಅದ್ ಕೊಡಿ ಅವ್ರದ್ದು ಸುನಿಲ್ ಅವ್ರದ್ದು ಆರ್ಡರ್ ಇದೆ ಕೊಡ್ರಿ ಅದರಲ್ಲೇ ಇದೆ. When that order has been passed, Mr.
My lords, that order was passed on the 12th December, my lords.
24, I
ಯಾವ
think.
matter ಅಲ್ಲಿ sir?
14
Really, sir.
2327 of 2022.
December.
My lords may refer to 17/2/2025's order, my lord.
Interim order granted. This is
Order dated 12/12/2024 in WP number ಅಂತ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ. 12/12/2024.
12/12/24 ಕೊಡ್ರಿ ಅಂದ್ರೆ 17 ಕೊಡ್ರಿ.
Please, my lords.
In which case, Mr.
14330 of 2022.
ಕೊಡ್ರಿ ಇದು ಯಾವ್ದು ಬೇರೆ ಕೊಟ್ಟಿದ್ದೀರಿ. Four 45 in the 5:30 to just urgent the matter.
My lords.
From 4:45 I stop hearing for urging the matter. See how 45 minutes has taken.
12/12/2024.
Giving a date.
Please, my lords.
It made clear that apart from this matter in the undertaking state has been given before the apex court visits the right of the employee who claim request unless there is a consolidated all pending matters and also details furnishing of those similar place before this court who has not approached the court is looking in university appropriately. Such directions if passed order and shall be equal treatment on all. There is a consolidating of all pending matters and also detail furnished. Yes, this court by order dated 12/12/2024 has passed following order. The learned counsel for the parties has placed the so and so furnished that so and so writ petitions which are pending before Kalburgi bench idralli ide 227. The registry is directed to obtain necessary order from the Chief Justice and connect all this matter placed before appropriate bench.
Please, ma'am.
Yes.
My lord, they have a submission, serial number 66.7, for the petitioner have carried out the amendment.
Wait, I will come back. 66?
0.7, my lord.
66.7 now.
This, my lord.
66.7, you are not there. That is, you are appearing for whom, madam?
Petitioner.
Petitioner, that you are not the petitioner. 66.7. Which is your matter, madam?
14,330.
14/3/30 66.3.
66.3, yes.
Please.
Amendment not carried out.
Have carried out, my lord.
66.3 learned counsel for the petitioner submitted that amendment has been carried out. Office to verify and proceed.
My lord, one more submission, 66.5 and 66.6, I won't be extended, Your Honor.
Interim order granted earlier is extended till next date of hearing.
66.3 also.
All matters, yes.
Please, Your Honor.
Please, my lord.
A day may be fixed. A day may be fixed.
Date.
Now that registry has to decide after
Please, my
taking
lords.
that permission, yes.
Serial number 67, Kashinath JD.
Prepare for
67.
respondent, my lord.
Yes.
Lord, any date, my lord, after 23rd, a date may kindly be fixed, my lord.
Leave this matter on 2nd March.
Much
Yes.
Serial number 68, Suvarna Lakshmi.
Number
Milords,
4,
I
my
appear
lord.
for the petitioner.
My lord,
Milords.
petitioner
Milords,
challenged the order of transfer
Hmm.
on the ground that my lord premature.
Hmm.
Now, my lord, he has completed his term, my lord, in the said place.
Hmm.
Therefore, my lord, writ petition has
Is it,
become-
madam, you have completed the term?
Milords, there are various other grounds. I am due to retire in the next 1 year. The transfer
Yes.
guidelines still bars
That is
Milords
the only-
transfer.
Then
When I'm due to
she
retire in 2
cannot-
years.
he cannot
Has to
transfer
provide
when
for that.
she was in the verge of the
My lord, in the
retirement.
writ petition, that is the only ground, my lord, he has urged. As on the date of filing petition, my lord, he has left with another 6 months. He has completed 1 year, 6 months in the said post, my lord. He has deployed within the city headquarter itself, from one building to another building within the same compound, my lord.
When you are going to retire, madam?
Milords, I'm going to retire in the next year, Milords. 1 more year I have.
No,
I have
just give the
specifically
date.
pleaded, Milords, that I am 58 years old and I'm due to retire in the next 2 years, which was last year. I have 1 more year
No,
to go.
which is that transfer order, annexure?
Annexure F, my lord.
Annexure F.
36/20/25.
When you are going to retire, madam?
Milords, the exact date I'm not aware, Milords.
Where
But
is your
as
ground?
per the cost title, 58 years is what
No such
I
ground
stated.
urged.
The ground, Milords, is at para 6.
My lord, this is not transfer order, it is a deployment order, my lord, within the city
Milords,
headquarter.
deployment and transfer are the
also
same
transfer.
has been held by the division bench of this
my
I
lord,
think the bench is also transfer ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದಾರಲ್ಲ, constitutional bench. Yes. Now that, have you taken that ground, madam? Where is that?
no, my lord.
Please, Milords, paragraph 6, page number 10.
Paragraph 6, page number
10.
10. 10 is
Please,
that
madam.
ground.
Please, Milords. I've
There
stated in the
paragraph
facts as well as the grounds. If I may just read from the top, Milords, 4th line, 5th line. Since the petitioner has been working as AEE at the said place and has completed 1 year, 6 months against 2 years, the petitioner is 58 years old and is due to retire in the next 2 years. I specifically pleaded that. And of course, for the transfer to be effected at that particular point of time.
Now, what
the
is your
procedure also.
exact date of
Please.
retirement, madam?
Milords, date I'm not aware. If I can get back to my lords on that,
You
Milords.
get that,
Please.
yes.
Exact date
That
I'll
is-
provide.
Yes. Short date, leave this matter on 18th. Yes.
Please. Interim order may kindly be extended.
Interim order granted earlier is extended till next date of hearing.
Great.
69 disposed of, 70, 71 urgent, 72 Maitreyi Krishnan.
The petitioners, well, this is the matter, 68 petitioners who are working as jamadars, peons, etc. in the residences of the judges, my lord, in Dharwad and Kalburgi. Arrears aurge has not been given for January 2012 to December 2019.
Yes,
Annexure D, my lord.
Now,
This honorable court, my lord, has forwarded a proposal to the state government.
Yes,
ಈ ತರ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು ಅಂತ.
Yes, yes, what is your instruction? No, I will ask her to present before the court.
My lord, arrears, my lord, it is ಕೊಡ್ಬೇಕಾಗಿರೋದು. I don't need to come to this honorable court for this.
Yes, yes.
My lord, may please see Annexure D, page 53. Page 53, my lord.
Yes. Page
53, my lord.
Now, where is that recommendation of High Court?
Other, page 53, my lord. Annexure D. My lord, may please come straight to page 4, page 56, which is about areas.
I have seen that, yes.
My lord, may please see, I was being paid 3,500, my lord, from January 2012 to January 2016. I was supposed to be paid 7,730.
In spite of granting sufficient opportunity, neither comply this order or they have not filed any statement of objection. today, again, they sought for time. If that respondent number 1 is not filed objection, ಎಷ್ಟು 4 days ಕೇಳಿದ್ದೀರಾ? On or before 10th. First respondent is directed to be present before this court on 11th. Yes.
My lord, on 11th, if it can be taken at the
Please, this
top, my
matter on
lord.
11th.
Please, my lord.
Yes,
If it
let
can
him
be
come,
heard.
if it is come in the morning, let him wait till 5 o'clock. Yes.
Grateful, my lord.
Serial number 73, Srinivasake.
Yes.
The respondent. Any date may kindly be given, my lord, in the last week, because the matter, division bench, my lord, is hearing the matter on 12th.
12th.
11th. Similar matter is before the division.
Yes, 17th.
Please.
Yes.
Okay.
74, Swami NBN.
Yes, 2 weeks. Post this matter in first week of March.
ಇದಕ್ಕೆ ಯಾವ್ದು ಕೇಳೋದು? ಸರಿ, ಇನ್ನೊಂದು ಯಾವ್ದು ಕೇಳೋದು? 75, HV Praveen Gowda.
We have an interim prayer, Your Lordship.
Interim prayer is granted.
No, Your Lordship. Kindly list the matter within this week, Your Lordship.
Yes, leave this matter on 23rd. Yes. Yes, madam.
Still number 52, just we are besides outside.
50?
Just 52, my lord. We are appearing for Gautam Dev Silwan, sir. Maybe our presence may be shown, my lord. Maybe we'll seek adjournment, my lord.
Yes, 52 at the request of the parties, leave this matter. Yes.
Much obliged, my lord. Much obliged.
ಯಾವ್ದೋ ಒಂದು ಇನ್ನೊಂದಕ್ಕೆ ಯಾವ್ದೋ ಮಾಡಿ 47 ಅಲ್ಲಿ ಇದೆ 53.
Court officer, serial number 79.
ಮಾರ್ಚ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ತಗೊಳ್ಳಿ. 76 ಇಂದ ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀನಿ. ಮಾರ್ಚ್ ಫಸ್ಟ್ ವೀಕ್ 76 ಯಾರಾದ್ರೂ ಇದ್ದೀರಾ? 76 ಅರ್ಜನ್. 77
ಇದೀವಿ ಸರ್. 77
ಮಾರ್ಚ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ ತಗೊಳ್ಳಿ.
4 or 5 ಎನಿಥಿಂಗ್ ಇಸ್ ಫೈನ್. 5 ತಗೊಳ್ತೀನಿ.
4
ಓಕೆ.
78 ಅರ್ಜನ್. 79
ಸರ್ ಮಾರ್ಚ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್.
ಒಂದ್ ನಿಮಿಷ ಇರಿ ಸರ್. 78 18 ಬೆಳಗ್ಗೆನೆ ತಗೊಂಡಿದ್ದಾರೆ. 79
ಸರ್ 4th or 5th ಸರ್.
ಆಯ್ತು 4th. 1 ನಿಮಿಷ ಇರಪ್ಪ. 80 ಇಲ್ಲ ಅರ್ಜನ್. 81 ಅರ್ಜನ್. ಹೇಳಿ. 40